Here's the important motion today, and that is the decision that I'm going to indicate for the record, Jensen 1 and Jensen 2. State versus Jensen, 299, Wisconsin 2nd, 267. And State versus Jensen, 331, Wisconsin 2nd, 440. They're both identical as to the letter. And they ruled that the letter was testimonial. And they both ruled that the statements made by Julie to Kosman, who was a police officer for Pleasant Prairie, including the letter addressed to the police, are testimonial. So that letter, those statements, it's not coming in at all. I'm not the Supreme Court. I'm not the Court of Appeals. This is the law of the land. It's not coming in. But all the other non-testimonial statements, and the testimony, it was in the first trial. It says here, the statements Julie made to her neighbor, it talks about Wojt, W-O-J-T, her son's teacher, DeFazio, all those non-testimonial statements that are in Jensen 2, which is 331 Wisconsin 2nd, 440. They're coming in. That's a distinction. And that's the law, and that's what's going to be going to happen at the trial. And if anybody does anything different, they'll pay the consequences. And
now I want to ask you about one more conversation. So you had told us in detail about the conversation you had with Julie Jensen on November 25th of 1998. During that conversation, obviously you heard some disturbing things. Did you ask Ms. Jensen whether she had told anybody else her concerns?
Yes, I asked her if she told anyone else, and she said she had told a police officer at Pleasant Prairie, a friend that she knew.
Just is unresponsive and hearsay.
overruled, go ahead.
And from the motion and limine, Judge.
Overruled, go ahead. Right now?
I would like to, Judge, but before we do that, can I just put an objection on the record?
Sure.
Okay, so when Ms. DeFazio was testifying, I objected and said it was based upon the motion and limine because she had testified that Julie told her that she had told police officers about being in danger or about telling police officers about thinking Mark was going to kill her. And I believe that is outside of, I think that's inconsistent with the ruling this court made that no statements to law enforcement and the letter were not coming in. So that's why I made that objection.
In my opinion, I, of course, find it strange that these two highly qualified forensic pathologists reviewed the same material and neither one of them thought about asphyxiation as a possibility given the scientific evidence until it was asked of them to retroactively
show
if it was consistent.
You're familiar with the phases of ethylene glycol poisoning?
No, I'm not.
Not at all?
Not at all.
Were you at one time?
No, I'm not. I wasn't at one time. I
Wouldn't be able to testify at all about,
No, I would not.
okay, so
Not about ethylene glycol. I'm not an expert or even very comfortable going through the different pharmacokinetics of ethylene glycol.
So if you testified in 2008 about the phases of ethylene glycol, do you wish you hadn't?
I wish I had.
Oh, I told you guys he was key during the 2008 trial. This is big. This is major, guys.
This case that I just cited talked about the penis issue pretty extensively. And I'm shocked how many times they mentioned the word penis. And what did this case say? Now, this is guidance for me, and I like it.
Of the ability to have this witness testify about prior testimony or admit the prior testimony of this witness.
I denied it.
I know you did, and you
Bringing
denied
the
it.
jury back.
Judge, you denied it, but you didn't allow the state to make its argument. So,
Your counsel made her argument.
Your Honor, you denied it.
Your counsel made your argument. Bring the jury back.
Your Honor, it's prior testimony. It's not being offered to refresh a recollection. It's prior testimony. It's admissible under 908.045 of the Wisconsin statutes. This witness is unavailable on that particular issue. We deserve to be heard on this, Your Honor. It's a first-degree murder case. We should be following the rules of evidence. The rules of evidence indicate this testimony is admissible, and it's an important part of this case.
The jury probably could hear you yelling.
Well, Your Honor, please, the state is entitled to make an argument
your record.
on evidentiary issues.
Go ahead and make your record. Here's the important motion today, and that is the decision that I'm going to indicate for the record, Jensen 1 and Jensen 2. State versus Jensen, 299, Wisconsin 2nd, 267. And State versus Jensen, 331, Wisconsin 2nd, 440. They're both identical as to the letter. And they ruled that the letter was testimonial. And they both ruled that the statements made by Julie to Kosman, who was a police officer for Pleasant Prairie, including the letter addressed to the police, are testimonial. So that letter, those statements, it's not coming in at all. I'm not the Supreme Court. I'm not the Court of Appeals. This is the law of the land. It's not coming in. But all the other non-testimonial statements, the testimony, it was in the first trial. It says here, the statements Julie made to her neighbor, talks about Wojt, W-O-J-T, her son's teacher, DeFazio, all those non-testimonial statements that are in Jensen 2, which is 331 Wisconsin 2nd, 440. They're coming in. That's a distinction. And that's the law, and that's what's going to happen at the trial. And if anybody does anything different, they'll pay the consequences.
Now I want to ask you about one more conversation. So you had told us in detail about the conversation you had with Julie Jensen on November 25th of 1998. During that conversation, obviously you heard some disturbing things. Did you ask Ms. Jensen whether she had told anybody else her concerns?
Yes, I asked her if she told anyone else, and she said she had told a police officer at Pleasant Prairie, that a friend that she knew.
Just because unresponsive and hearsay,
Overruled, go ahead.
and from the motion and limine, Judge.
Overruled, go ahead. Right now?
I would like to, Judge, but before we do that, can I just put an objection on the record?
Sure.
Okay, so when Ms. DeFazio was testifying, I objected and said it was based upon the motion and limine because she had testified that Julie told her that she had told police officers about being in danger, or about telling police officers about thinking Mark was going to kill her. And I believe that is outside of, I think that's inconsistent with the ruling this court made that no statements to law enforcement and the letter were not coming in. So that's why I made that objection.
There we go. I wasn't a life science major, but one of my majors was economics. So we did all kinds of graphs as economists. So this is, in economic terms, this would be like a supply curve, because this would be a demand curve. As the price goes up, the demand goes down, right? And this would be like a supply curve. As the price goes up, the supply goes up. And this point right here is equilibrium. So from an economist perspective, supply curve, demand curve. And we're looking at EG, we're looking at kind of like a demand curve. So now if there's an extraneous shift in the availability of a particular item, the demand curve might shift upwards. So then we just have a different curve. We'd put it up here. It would look like this. So let's take this and say this is 50 milliliters initial ingestion, and this is 100 milliliters initial ingestion. All of the factors being equal, at this point in time, there'd be a less amount of ethylene glycol in the blood, and with a 50 milliliter ingestion, and with a 100 milliliter ingestion, there'd be this amount, right?
I don't mean any disrespect, but you have completely lost me.
Oh.
And how a supply and demand curve analogy applies in this situation really doesn't make any sense.
Okay, well, let's take.
All right, what is up? What is up, everybody? Good morning. Good morning. Welcome back to the Mark Jensen trial. We are on day 14, folks. This morning, we will hear jury instructions, followed by closing arguments, several breaks in between each set of those things. Make sure you guys like the stream. Hit that thumbs up on YouTube on your way in. Don't forget. Keep spamming the chat on Facebook. Push the stream out. Hit those likes and hearts on Facebook. Keep doing that throughout the stream. We do have a poll up on YouTube, so I'll ask the Facebook chat. So yesterday there was a major Wisconsin Supreme Court violation. I think that they will be filing a motion for mistrial today. I'm surprised they didn't ask for it yesterday. But Facebook chat,
This is,
put a 1.
Good morning, Your Honor.
If
State of
they will,
Wisconsin
put
appears
a
by Special
2
Prosecutor Robert
if you think
Jamboys,
they
Deputy
won't.
District Attorney Carly McNeil,
Here we
and
go,
Public
chat.
Service Special Prosecutor Beverly Jamboys.
Attorneys Bridget Krause, Jeremy Perry, and Mackenzie Renner appear on behalf of Mr. Mark Jensen, who appears in person. Good morning, Judge.
good morning. All right, the record should reflect the jury is not in a courtroom. We have some housekeeping matters to take care of. The first one, the clerk has provided the attorneys in the court with the exhibit list. Is there any objection to the list as it is prepared now from the state?
Not from the defense.
There's no objection from the state, Your Honor.
Is there any objection from the defense?
No.
All right, can I have the attorneys then sign the original? If one of the bailiffs could take the copy to each counsel? Switch it, I'm sorry. The clerk has the original. I forgot about that. She's the boss. Switch it. Ones that were not offered or not received.
Correct. Your Honor, the state would offer Exhibit 90 into evidence if it was. I thought it had been, but Exhibit 90 is the comparison contrast suicide homicide by Dr. Mainland.
All right, that'll be received.
I mean, Judge, I'd object to that. I mean, it's being offered. We're not in front of the jury.
Bailiff has to move so I can see the lawyers.
Sorry. I would object to that. It wasn't offered. The evidence is closed. We're not in front of a jury right now, all those reasons. But, I mean, it was described. It was certainly described by Dr. Mainland, but it was never offered.
Bailiff has to move so I can see the lawyers. Thank you.
Well, Your Honor, first of all, I thought it had been offered into evidence, and we can ask, and I see the court reporters nodding her head. So it was offered into evidence. It just isn't recorded here, but we did offer it into evidence. We did move it into evidence.
Let me look at my notes. I think Mr. Jambois is right because I marked down every exhibit that was offered and received. And I've got a notation that the study was offered, so it is going to be received. So that's the only addition, Jan, is 90. All right, so we got that taken care of. The next thing is the instructions that have been provided to the court. I'll ask who's going to talk for the defense as to the instructions?
I will, Judge.
All right, thank you. Have you had a chance to review the document that was prepared by the state?
Judge, I have, and outside of like just a misspelling, I have no issues with the instructions. The only thing I was wondering is if we wanted to do an instruction about the legal arguments outside the juror's presence, because we did have them leave a lot, and there is a simple instruction we could give if the court felt it was appropriate.
What's the state's position as to that?
I don't really think it's necessary. I think we kind of explained it to them as they were excused, so.
You mean when we would ask them to leave?
Right.
Yeah, I think we've explained it to them numerous times. I told them that obviously we had to do some legal issues, and I think they understand.
Other than that request, Judge, I'm fine with the instructions. On page 8 under video recordings, actually it's fine. Everything is right. I just reread it.
So there's no objection to me reading these instructions?
Correct. Not from the defense.
Okay.
All right.
So for the record, we reviewed the opening instructions and all the other instructions that are attached. I will indicate to the attorneys, I will read the instructions before their closing arguments, but I will stop on page 13. And then when the closing arguments are done by the lawyers, I will read page 14, 15, and 16. And then we will swear in the bailiffs after the verdict comes in and we are done with the case. I will read page 17. All right? Any objection to that from either side?
No, Your Honor.
Okay. Now, have the attorneys had a chance to, I should also ask the defense to two verdict forms. Any objection to the two verdict forms?
No.
All right. Have the attorneys had a chance to look at the issue of the alternate jurors? And I did read the case that Mr. Jamboyce talked about yesterday. It's kind of the defense has all the cards in this game. If they don't agree, we can't do it.
Well, Judge, I think we can hold the jurors as the court thought in a room. And then if it becomes an issue at that point, I think we would have to look at the three factors that are in the case law and then make the decision after consulting with our client.
I think it's like a 1982 case and there's nothing after that. Any thoughts from the state?
Well, I'm glad the court found the case that I'd referenced. I didn't bother to look at it, but I do recall that the defense has to agree to it. So it's really, the ball would be in their court at that point.
The judge was overturned in the case of 1982 because he replaced the juror.
Well, we don't want that to happen again.
I know, that's why I'm glad I read the case.
I will say this, Judge Schrader's rulings during the first case did not cause the case to be overturned. There was no error by Judge Schrader in that first trial that resulted in this case being overturned on appeal.
So what I'll do is we will take 4 jurors. We will put them in a separate room and they will have to stay there while the jury deliberates. And if we have an issue during deliberations, we will bring the attorneys back with the defendant and we will decide what to do.
Thank you, Your Honor.
Okay?
Judge, just for figuring out where we're going to be, does the court allow the jury to deliberate well into the night, or is there a specific time?
That's a great point to bring up. And I think we should, if we want them to deliberate after 5, we have to inform the security ahead of time that they are available. And another thing is, I think we should have the jury have some input as to that also, because they might have some personal responsibilities that they have to take care of, like children.
Correct.
So
That's why we're asking, Judge,
yeah.
because the court knows we're about an hour away, so we
Yeah.
just want to make sure that we're planning it appropriately.
what we'll do is we'll try to maybe start talking to the jury like maybe 4 o'clock or 4:15 and get their thoughts. And if they want to stay, I'm going to let them stay. And then we'll have to inform security. Okay, one more quick thing. Did we figure out how much time you're going to talk on the closing, Ms. McNeil?
So I think it's going to be between an hour and 15 minutes and an hour and a half.
Wonderful. Did Mr. Perry, did you figure out how much time you're going to talk?
I don't know how long this is going to take me to get through.
All right.
Probably at least that.
Okay, what I'm going to do then, so the lawyers are aware, so everybody feels comfortable, I'm going to do my reading and then we'll let the state do their closing and we'll take a break. So the jury gets a little break and then Mr. Perry, you can start after the break, okay?
Thank you.
And it sounds like we'll have to do the rebuttal right after lunch, unless we go a little quicker. Okay? Let's take 5 minutes and we'll bring the jury out, okay?
So
issue?
You're blocking our client from being able to see the jury.
Larry, ready to stand up?
That's where it was last time. Yeah, I'm pretty, oh, wasn't it? No, because I wouldn't have been able to see the jurors if it was there. They put it there and then we moved it back. It might have been right there, but I don't know. Jeremy thought it was there, but I would just have to see if he can see. Yeah, he is. He's not going to be sitting here. Was could he see everybody when it was forward? Could Mark see the jurors when the box was where it was for opening? Like, okay, we're good. Right there, I know you can probably see the jury, but if they move that box out and forward, are you going to be able to see the jury?
If they move it this way.
So that's good then, we're gonna do it there?
But then the issues for the court. Oh, no, the court reporter will see.
Court reporter is gonna see very clearly. She doesn't need to see that. She just needs to see the person.
Right. So does Bob. Okay, thank you.
I know. I don't rely upon. Go home and scrub that. Mackenzie's going to get you on. Yes, I'm bringing water.
All right, bring the jury out. We'll go on the record on Mark D. Jensen, 2002 CF 314. Let's have the appearances.
Good morning, Your Honor. The state of Wisconsin appears by Special Prosecutor Robert Jamboys, Deputy District Attorney Carly McNeil, and Public Service Special Prosecutor Beverly Jamboys.
Attorneys Bridget Krause, Jeremy Perry, and Mackenzie Renner appear on behalf of Mr. Mark Jensen, who appears in person. Good morning, Judge.
Good morning. The date is January 31st, 2023. The jury is back in the courtroom. Ladies and gentlemen of the jury, thank you for coming on time, having patience with us. We are going to do then closing arguments. Nobody has their pads and their pencils with them, right? So we're good on that. Just to give you a little heads up, all the instructions that I have to read to you in the two verdicts you're going to have, but I have to read the instructions to you. I will do that first. The state will do their closing first because they have the burden of proof, and then the defense will do their closing, and then the state has an opportunity to do a rebuttal. So, and we'll take a break in the middle of it so you won't have to sit here till 12 o'clock noon, okay? All right. With that, the court will now instruct you upon the principles of law which you are to follow in considering the evidence in reaching your verdict. It is your duty to follow all these instructions, regardless of any opinion you may have about the law is or ought it to be. You must base your verdict on the law I give you in these instructions. Apply the law to the facts in the case which has been properly proven by the evidence. Consider only the evidence received during the trial, and the law is given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. You are entirely free to disregard anything that counsel have said, or that I have said or may say about the facts. You are not in any way to defer to a judge merely because you think a judge has more experience and therefore might be wiser with the respect to the facts. If at any stage you have thought that I have expressed an opinion about the facts in this case or upon how you should decide the guilt or innocence of the defendant, I assure you that you have misunderstood my intention. Neither previously nor now nor hereafter do I intend in any way to indicate how you should view the testimony of any of the witnesses or how you should decide as to the guilt or innocence of the defendant. Information is not evidence, and information is nothing more than a written formal accusation against the defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. The accusation. The information in this case charges that on December 3rd, 1998, at the village of Pleasant Prairie, County Kenosha, state of Wisconsin, the defendant caused the death of Julie C. Jensen with intent to kill her. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. First-degree intentional homicide, the statutory definition of the crime. First-degree intentional homicide is defined in 940 sub 01 of the Criminal Code of Wisconsin is committed by one who causes the death of another human being with the intent to kill that person or another. The state's burden of proof. Before you may find a defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. The elements of the crime that the state must prove. Number one, the defendant caused the death of Julie Jensen. Cause means that the defendant's act was a substantial factor in producing the death. Number two, the defendant acted with the intent to kill Julie Jensen. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. When must intent exist? While the law requires that the defendant acted with intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. Deciding about intent. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent and motive. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. The jury's decision. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Julie Jensen with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. Burden of proof and presumption of innocence. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reasons, and prudence. Presumption of innocence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The state's burden of proof. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. Reasonable hypothesis. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. Meaning of reasonable doubt. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. Evidence. Evidence is, first, the sworn testimony of witnesses both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. Circumstantial evidence. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge or experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Improper questions. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore that suggestion and do not consider it as evidence. Objections of counsel, evidence received over objection. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You, the jurors, are the judges of the credibility of the witnesses and the weight of the evidence. Stricken testimony. During the trial, the court has ordered certain testimony to be stricken. Disregard all stricken testimony. Exhibits. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Remarks of counsel. Remarks of the attorneys are not evidence. If the remarks suggested certain facts not in evidence, disregard that suggestion. Video recordings. You have seen previously recorded testimony of witnesses who are no longer available to testify in person. You should ignore the logo which may appear on these videos because it has no relevance to this case. You are further instructed that this recorded testimony is evidence and should be evaluated the same way as the witnesses who testified in person. Statements attributed to the defendant. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine three things. Whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered as evidence. Whether the statement was actually restated here at trial. Whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all the other evidence, in determining how much weight, if any, the statement deserves. The weight of the evidence. The weight of the evidence does not depend on the number of witnesses on each side. You may find the testimony of one witness is entitled to greater weight than that of another witness, or even several other witnesses. Jurors' knowledge. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. In formulating your views of the facts, you are not to bring in to bear anything except the evidence you have heard in this courtroom. You are to ignore any immediate account or anything else you may have heard or seen about the case except what you learned in court. Expert opinion, testimony, general. Ordinarily, a witness may testify only about facts. However, a witness with expertise in a particular field may give an opinion in that field. You should consider the qualifications and the credibility of the expert, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any expert's opinion. In resolving conflicts in expert testimony, weigh the different experts' opinions against each other. Also consider the qualifications and the credibility of the experts and the facts supporting their opinions. Hypothetical questions. During the trial, witnesses were told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in a hypothetical question have not been proved, then the opinion based upon those facts should not be given any weight. The credibility of witnesses. It is the duty of the jury to scrutinize and weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based upon the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristics. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness had an interest or lack of interest in the result of this trial, the witness's conduct, appearance, or demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any, has been shown, possible motives for falsifying testimony, and all other facts and circumstances during a trial which tend either to support or discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There's no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. And in everyday life, you determine for yourself the reliability of things people say to you. You should do the same thing here. Defendant elects not to testify. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. Impeachment of witnesses, prior conviction, or juvenile adjudication. Evidence has been received that some of the witnesses in this trial have been convicted of crimes. This evidence was received solely because it bears upon the credibility of the witness. It must not be used for any other purpose. Impeachment of witness, character for truthfulness. Evidence has been received regarding a witness's character for truthfulness. You may consider this evidence in weighing the testimony and determining credibility. Closing arguments of counsel. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. I will stop now with my instructions. I will read a portion later. At this time, the attorneys will do their closing. And anytime you're ready, Ms. McNeil, you can do your closing argument.
Good morning, everyone. 2023, this year, is the 25th year stolen from Julie Jensen. Birthdays and Christmases and new school years and graduations, all taken from her. When a person dies, their family is devastated, their friends mourn them and remember them. And after all this time, Ruth Vorwald, the first witness, cried thinking of Julie and remembering her death. After all this time, we heard from Angela Martinelli, Kim Noble, Carrie Ashley, Eric and Laura Shore, Therese DeFazio, David and Sharon Naring. We saw the videos of Ted and Margaret Voigt, Marion Passetti. Many, many good and wonderful people have died tragic deaths, but not many people, after all this time, would have so many friends and neighbors coming forward to tell you about them, to tell you what a kind, loving, devoted person they were, as Julie Jensen was. And it matters in this case because, yes, it is possible that even a mother with young children might end her own life, but that is not the evidence in this case. The evidence we have is that Julie told Ted Voigt, Margaret Voigt, Therese DeFazio, and the defendant's own sister, Laura Koster, about her fears that the defendant would kill her. Julie took pictures of things that troubled her in the defendant's day planner and gave them to the police. So the evidence here is not evil murder or tragic suicide. It's murder or it's suicide plus something else. Somebody committed a ghastly crime here. Either Julie Jensen plotted for weeks and weeks since at least mid-October 1998 to kill herself with a substance undetectable at autopsy, to plant evidence with her friends and the police and even in the computer that her husband was responsible, or Mark Jensen, who had tormented and punished and never forgiven his wife for years, found her replacement and then killed her. What a convenient suicide this was for Mark Jensen. Kelly Labonte wasn't just an affair. She was Julie's replacement. That happened, and it happened almost immediately, even without regard for appearances. The defendant didn't have to worry about losing custody of his kids or child support or alimony. How convenient. As an added bonus, he stood to gain $100,000 in the life insurance money, even if Julie's death was ruled a suicide. Julie's death was so convenient for the defendant that he couldn't even resist high-fiving his father after he got his house back from the police. He couldn't wait to throw away Julie's possessions to make room for Kelly. What excellent timing Julie's suicide was for the defendant. The timing was so good that she died before the kids got home on December 3rd, so the defendant didn't have to worry anymore about David's pleas for his mother. Now, this is hard to fathom, and it can be hard to wrap your head around the idea that a respectable member of society, a person with a great job, a nice house, 2 kids, a dog, a pool, an idyllic life, would poison his wife with ethylene glycol and then smother her to death. That's why Julie's affair and the years of harassment that followed matter, because it shows how the defendant felt about his wife. He hated her. What the defendant did to kill his wife is almost past understanding, except he hated her. For nearly all people whose marriages are falling apart, the answer is divorce, not murder. But the defendant hated Julie, and we can prove it. There's the email to his girlfriend. See it on the screen there? You can see the text of the email. Hey, can't forget about you. Can't, don't want to. I miss you. Then you see the email you've seen repeatedly. This is the email to his wife with the pornographic images attached to it. That shows you what he felt about his wife and what he felt about his girlfriend. How he wanted his girlfriend, he had Julie's replacement. And for him, it didn't have to be a divorce because he hated his wife. And now I want to take a look at this harassment that we've shown you before. I just want to take a look at a few things. First of all, I want you to see the extent of it. There's just page after page after page in this exhibit that we showed you of the harassment. It just keeps going on and on and on of Julie tracking it. And remember, we showed you yesterday the page where she was told by the police, hey, you got to keep track of this. You got to help us. So if we take a look at this, we just see some examples of what's happening. This is the page we showed you where she was told by the police to keep track of things. And again, a few examples of the type of harassment that was happening. One of the things that Julie said is it always seemed like the person who was harassing them just was one step ahead. 12/19/95, photos left in truck at Ruther during David's Christmas program. That's quite a stalker there. Finding the truck at Ruther during a Christmas program. That's amazing. That stalker is one step ahead. And then if we just go further, we heard in the testimony too the nature of this harassment. It wasn't just the hang up phone calls. They would happen at home, but also, according to the defendant, they would happen at his work. The leaving of the pornographic images, they would happen around the home, but also, according to the defendant, they would be left at his work, mailed to him sometimes, but often left on his vehicle at work. These pornographic images, penises and photos of oral sex, or what looked like a woman in position close to a penis, those harassing photos. And we see more examples of that. Several hang-up calls at Mark's office, talking about David finding a tape, found videotape in front of brick ledge of garage, then hang-up calls asking how he liked the tape. Then various calls to Mark's office, soft, effeminate male voice referring to video, photo left on Mark's truck at office. And again, we're not going to go through all of this. It just keeps going. And we showed you this page repeatedly too, the new tactics, which led to the notation of these harassing emails. And we recovered these emails. These were from the zip disk. They were found in the defendant's home, saved on what we would use nowadays would be a USB drive, a thumb drive or a flash drive. But back in the day, it was these zip disks. And what was found on the zip disk is the email that we showed you with the attachments. And because it's the actual email and not a screenshot, that's how we can see. It was from Mark Jensen to Mark Jensen, and he saved it, and he saved the images attached to it, and it was on those disks. I also showed you too that he saved some screenshots from a computer. And in the screenshots, I showed you in the background, you could see Trading Expert Pro was up in the background. So you know it's from him. So we heard about Julie's hobbies, gardening and crafts and book club. This is the defendant's hobby. This is his hobby. This is what he did for years and years and years until, let's look when it stops. It trails off in June of 1998 and then ends entirely in August of 1998 when the defendant gets his girlfriend. Remember, Julie was alive for months afterwards, but there's no more notes in this harassment log because the defendant has a new hobby. The last thing I want to note about this, 6/19/98, definitely found Mark's new office phone number, ranted, raved, and swore at the receptionist, several hang-ups at the office after that. This was after Mark had moved to Stiefel Nicholas. We heard from the receptionist, Meredith Perez. She never got a call like this. Just more proof that this was fabrication. And think about the torment to Julie, because although Mark is reporting these things, who's at fault? It's her, because it's the man she had an affair with. And she has to tell the police about it. And when she tells the police about it, she has to repeat over and over and over again that she had an affair. And she even asked for one police officer, please, Pleasant Prairie, just send me one police officer so I don't have to tell the story again. We even have the defendant making Julie think the pictures were her. And if you saw this email, you saw how he would do it. In this email, the harasser is pretending that he's taking a picture without her knowing it of a married girl that he's currently doing. Just the kind of trickery that was used with Julie. The man she had an affair with must have taken secret pictures of her. And now these are pictures of her that he's leaving around. This is gaslighting. And Julie's a smart person, but she's just constantly being lied to and deceived by her husband. And she's told by the police and the private investigator, hey, we think it's your husband, but she doesn't want to believe it. Now, remember the defendant's interview. We showed you several clips from that recorded interview, not the greatest recording, 1998. But we showed you several clips from it, the defendant's own statements. And the defendant was confronted by Detective Ratzberg about this harassment. And what the defendant said, well, he said he'd find them around the house, these pictures, because he did. He'd find them around the house, but it was a question of showing them to her. He said he did end up showing a majority of them to her. And then here's what he said. How many times do you have to see pictures like that and get reminded of it before you kind of go, man, it's not worth it. It gets old and you put it away. And I'd put them away and then something would happen and I'd get pissed off and I'd pull some out and I'd say I found these in the shed. Then the question was, when in fact you had them? And Mark says, I had them. I mean, they'd accumulate for weeks. How many times do you have to see pictures like that? Who has an interest in exactly those kind of pictures? That's why this evidence matters, because Mark's obsession with these types of pictures, with these penis photos categorized on his computer, with photos of oral sex, this obsession was his, and those are exactly the harassing pictures that would be left around. And yet he acts to the detective like, oh, how many times you got to see it? He wants to see it. That's what he wants to look at. So we know it's him because of that too. And it's another lie to the detective. Remember how much Mark Jensen struggled when asked about Kelly Labonte? He just wouldn't say, even at the present moment, that she was his girlfriend. He, of course, wasn't going to admit to the affair before. But even in the present, he couldn't say she was his girlfriend. She had moved to Wisconsin at that time. She'd moved for him, but he wouldn't say it. So I said from the outset, the defendant was under no obligation to forgive Julie. If he had filed for divorce after the affair, you know what? Even if he did hate her forever after that, as long as he ended the relationship with divorce, then we wouldn't be here. But he never forgave her. That's what his friend from work, David Naring, said. That's what his friend noticed. Julie knew it too. It's one of the last things she said. She told Dr. Borman on December 1st about that affair and how she thought the defendant had never forgiven her. And that's not the only thing that Julie said on December 1st, because even though her marriage was falling apart and she was miserable, when she was asked about depression and whether she would ever kill herself, she said never. She would never leave her boys. And how many witnesses did we hear from in this case? It was a lot of witnesses. Not a single witness, not a single one testified that Julie Jensen ever made suicidal statements, that she ever had suicidal ideation, that she ever made a suicide attempt. Not a single one. Instead, what we can see in the evidence through the computer evidence is the timeline of the defendant's plot. That's why those emails with Kelly Labonte, the defendant and Julie's day planner, their respective interests matter, because we can see the defendant's life reflected in those internet searches, that internet activity, and we simply do not see anything similar for Julie. Remember how dismissive Dr. Thomas was of Julie's lack of computer knowledge? You are to decide this case based on the evidence, not on cognitive bias, not on some make-believe story that's unsupported by the evidence. In contrast with the defendant, we have evidence that Julie Jensen was very unfamiliar with computers. That's the evidence. The very beginning of September 1998, that's when she has that conversation with Therese DeFazio. Therese specifically asked her about helping in the computer lab, and Julie said no. She was there to be helpful, but she just couldn't. She just didn't know about computers. And they joked about how slow she typed, 35 words a minute. Then we have Julie applying for the job at Bradford High School. Joe Mangy told you about that. Well, back in 1998, that job she was applying for, even for a high school, even an office in a high school, it wasn't a computer job. The secretaries at that time didn't even have computers. So Julie was very well qualified for that job. And when Julie had that conversation with Therese DeFazio about her being afraid the defendant was going to poison her, how she had seen the defendant on the computer, but he would turn it off or cover up the screen. Ms. DeFazio suggested, well, maybe she could look at the computer cache and maybe she could see what the defendant was up to. And Ms. DeFazio was familiar with a Macintosh, and so that's what she was suggesting. But Julie said she didn't know how to do that. She wouldn't know what to do. Ms. DeFazio even remembered David doing what kids do, right? They blurt something out about their mom. Oh, my mom doesn't know anything about computers. And it's funny, I'm teaching her. And it started a whole class discussion where all the other little kids joined in. And Ms. DeFazio explained, well, that was normal back then. Computers were just getting in the home in 1998. I am going to emphasize once again, you are to decide this case based on the evidence. So I am going to show you the evidence and I'm going to go through that with you, because what I say or what they say, it doesn't matter if it's not supported by the evidence. So let's look at the timeline of the defendant's plan that we can see through the computer evidence. So we've seen this before, the dates and the times of this computer use. Now, the argument that you've heard from the defense is that, well, there's no computer use during normal work hours because Julie wouldn't have wanted to block the phone line. That argument is absurd and it's unsupported by the evidence, because not only is the internet on this home computer not used during normal work hours when the defendant wasn't home, but it also wasn't used at all when the defendant was out of town. So let's look at September. September 2nd, you zoom in. September 2nd, no internet activity. The defendant's in St. Louis. How do we know that? We have his day planner. We also have those emails. Here's the email from Kelly, September 3rd. Thanks again for yesterday. They were together in St. Louis on the 2nd. There's no internet activity on the 2nd. Let's go to later in September. We have another trip to St. Louis. We have computer activity, internet activity, the early morning hours of the 11th, but then the defendant goes to St. Louis that day, 11th and 12th. And again, how do we know it? It's right here in his day planner, and it's in the emails. Let's look at what Kelly had to say about that time frame. Her email, September 9th. She says on the bottom, a massage tomorrow and you the next day. How perfect can one life be? Tomorrow the 10th, the defendant the next day, the 11th. Let's go to October. The defendant and Kelly Labonte are in Appleton. No internet activity those days. This is the time period when the defendant and Kelly Labonte are going to Appleton. They're going to open up that office, the office where Ed Klug works. So this is where the defendant would have met Ed Klug in person, and where the other people opening that office noticed there was something going on between the defendant and Kelly Labonte. So now, what about Sunday, October 11th? We do have internet activity in the afternoon on that day. It's afternoon internet activity. Maybe this is Julie. Patagonia. It's the Patagonia website that's being looked at. And then what do we have the next day? Email from Mark to Kelly. This is where he's trying to buy some things for his girlfriend, right? A treat, spoiling his girlfriend. Now imagine we didn't have these Patagonia emails to Kelly. How much do you want to bet Julie would have been blamed for these searches for women's clothing? How much you want to bet? She would have been blamed for this computer evidence, but we know who was searching for Patagonia that day. Moving on in October, the trip to Chicago, the very suspicious trip to Chicago. Who needs to stay in a hotel in Chicago when you live in Pleasant Prairie? Well, that's what you do when you're planning a nice long getaway with your girlfriend. And we see it in the day planner, October 21st, 22nd, 23rd, 24th. That's the trip to Chicago. And we see it in the emails. Chicago is the subject. Oakbrook will move on 10/23 and open for business 10/26. Where is Oakbrook in relation to the airport? Any ideas? So this email, right, this planned get together between the defendant and his girlfriend, that happens on October 12th. The early morning hours of October 13th, we have the defendant on the computer planning the Chicago trip. The O'Hare Marriott, Morton's Steakhouse. Then on October 15th, I'm showing you this because it mirrors the defendant's life. On October 15th, we go from Bass Pro Shop to Big Cedar to Windstar Cruises, and we know these early morning searches are the defendant. He's the fisherman, so he's going to Bass Pro Shop. He talked to Kelly about Big Cedar, so he's going to this website. Then Windstar Cruises, early morning hours of October 15th. And what is the next email to Kelly Labonte? This string of emails from October 16th, 1998. Hey, want to run off somewhere? I do love you. Kelly responds, what sparked this bold attempt at messing with me? Sounds wonderful. Where should we go? The defendant says, really bold attempt. If it was really bold, you'd have tickets for the Windstar in your hand. Who was on the internet looking for Windstar? It's obvious, right? These emails are important on October 16th with Kelly Labonte because the defendant has decided he is planning his future with Kelly. He misses her, he wants her, he loves her. He's buying things for her, and he wants to sweep her off her feet with this cruise. Here's what Kelly says. Considering you have a milestone birthday next year, and we would both need some time to clean up our lives, so to speak, I was thinking what a lovely way to spend your birthday. You, me, sunsets, ocean, champagne, no outside issues. See, Kelly understands the practical implications of what the defendant is doing. You just don't go on an expensive, lengthy cruise with your lover on the side. That isn't realistic. So that transforms this conversation into what are you going to do with your spouse? And so Kelly wants time to decide. She wants until the end of the year to decide either way what to do with her issue. The defendant says, fair enough, no deadline on deciding, whatever time needs to be figured out. And then Kelly starts asking him, well, what are you going to do? Do you have it all figured out? The defendant says, I'm thinking so, but then is mostly talking about her, barring seeing a bunch of disgusting habits. Some details to be worked on, but then those are just details, not the big issue. But Kelly wants to know. She wants to know. It was the details I was wondering about. That's what she says. And the defendant just keeps on being vague. Murphy spins on details. Details are just noise in the bigger picture. Kelly, again. And you plan on dealing with the details how? One at a time. So at that point, that's when Kelly says, evasive little shit. Kelly wants to know, what is he going to do? She's asked for the end of the year to deal with her issues, but he's not telling her what he's going to do with his. The defendant isn't telling her what he's going to do with his wife. Kelly calls him out for it. But what we know from the computer is the defendant is forming a plan. He's planning for a future with Kelly by searching for Windstar Cruises. And he's planning for a future without his wife through the other searches on this computer. So it begins with this series of searches on October 16th, 1998, and it starts at 1:54 a.m. I'm not going to show you all of these again, but these are the searches that go from underground to drugs to botulism and ending with poisoning. Then we move to the evening of October 16th, 11:57 p.m., and disturbing searches continue. First, we start with the pipe bomb article. This was the one about the man who was attempting to kill his estranged ex-wife with a pipe bomb. And this browsing session, this one continues for over an hour until about 1 a.m. And I want to show you the various websites that are accessed in this browsing session so you know who is on that computer and doing these searches. We go to the mercury fulminate website. Now I want to zoom in a little bit here. So we go from the pipe bomb article to mercury fulminate is used as a primary explosive in the fabrication of detonators. Then we go to material required. We have here a list of things including glass containers, tape, syringe. Then we go to a warning. Caution. Acid will burn the skin and destroy clothing. Then we go to this. This is the list that Julie found in the defendant's day planner. It's what she took a picture of. We wouldn't have this if she didn't take a picture of it because it wasn't in there anymore when the defendant's day planner was recovered by the police. So what we see here on this list, and we'll come back to this, but we see bottles, booze. So those could be glass bottles. And then we see syringe on this list. Then we see bag hands, like maybe if acid will hurt your hands. Maybe if you've seen that warning on that website. And next we have a website accessed about pool fun. This pool fun article, it talks about reversing the polarity of a pool. And the article claims that that'll cause an explosion. And again, is this true? Is that how that works? I don't know. But that's what the user of this computer, the defendant, was seeing and what he was looking up. And what do we have next? Nicotine. That's the next search. Who's the smoker here? It's Mark. Julie doesn't smoke. So we go to this nicotine search, the nicotine searches. Let's go back to this list. Nicotrol. That is the stop smoking drug that Dr. Borman prescribed to the defendant. Librium. That's also the defendant's prescription. His own drug supply. Who do you think is on the internet doing these searches? And just in case you weren't sure, these are the searches that end the browsing session. They're for Stiefel Nicholas employees. We see the Appleton office here. Remember that address? 740 Ford Street? It was in the defendant's planner, and David Thompson knew it too. Then for some reason, we're going to Colorado Springs. The employee, the branch manager, John Jock Joseph. We heard from Kelly why the defendant was very interested in John Jock Joseph. Because as we learned, the defendant had exhaustive conversations with Kelly Labonte about every man she had had any sort of sexual encounter with, including detailed descriptions of that man's penis. And Kelly Labonte knows that in the beginning it wasn't so detailed, but she did tell the defendant about John Jock Joseph, including a description of his penis. And she remembers that it was the fall of 1998, and she remembers it was before the Blueprint conference, because she remembered seeing him with the defendant, seeing John Jock Joseph and kind of pointing him out to the defendant. They had talked about this man before. There is absolutely no reason why Julie Jensen would be so interested in John Jock Joseph, but we know the defendant was. Then finally, we have the search for Kelly. So why is the defendant searching for Kelly? He knows her name. He knows where she works. But it's a search for Kellys, right? They're all Kellys here. What he wants to know, what the defendant is very interested in, is her last name. Kelly's married by this point, but she hasn't changed her last name yet. The defendant's trying to gauge her relationship with her husband. Has she bothered to change her name yet? Is she really committed to this new marriage? He wants to know, and so he's checking. Oh, she's still Labonte K. And that's how this browsing session ended. October 19th, early morning hours, another search for pipe bomb. Maybe Julie Jensen wanted to build a pipe bomb. Then we have the infamous Blueprint conference. We see it reflected in the defendant's day planner. This is the conference in St. Louis, the early morning hours of November 7th. This is when the defendant was out drinking with a group at first, then the bar or club closes down, then they're in the lobby hanging out talking, and he ends up alone with Ed Klug. And they were wife bashing, and the defendant told Ed Klug about wanting to kill his wife, looking up ways on the computer to kill his wife, finding something that would crystallize you from the inside out. Now, we saw that video of Dawn Cooper, and I guess she was supposed to demonstrate that maybe that conversation didn't happen because she was also out in the lobby after bar close. But what happened in the end is she said that she left, and the only people there from her group were Mark Jensen and Ed Klug. And we know that it happened. We know that the defendant told these things to Ed Klug because of Joanne Klug. We know that Ed Klug talked to her multiple times the early morning hours and then again later in the day at the airport. She and Ed have been divorced for years now. I think they said it was finalized in 2013. She's never had a reason to lie about this. It's a very memorable conversation. They even have the phone records, right? Really, he was talking to his wife at those early morning hours? Well, yes, he was. Look at the phone records. And Joanne remembered something in particular. She remembered when Ed was at the airport, and she was thinking about, kind of ruminating on what Ed had told her, and she was confused because she was wondering, well, how does someone die from Benadryl? She remembers Ed telling her about the Benadryl. And so at the airport, she asked him that question about the Benadryl, and that's when Ed says to her, it's the antifreeze. Joanne Klug came in here and she had no reason to lie. She's long done with Ed Klug. But the truth is that conversation happened. And Ed told Stacy Bauer too. She remembers fewer details than Joanne. What she remembered is hearing that the defendant hated his wife and wanted her dead. But she does remember her immediate reaction when she heard less than a month later that Julie Jensen was dead. Oh my God, he killed her. And Stacy Bauer's opinion doesn't matter. It's not of significance, but what matters is she didn't know the Jensens. The only information she had was from Ed Klug. She knew what Ed Klug had told her when she made that statement. So we know that when Ed Klug got back from the Blueprint Conference, before Julie Jensen died, that he told Stacy Bauer about this deeply disturbing conversation that he had had with Mark Jensen. So that when Stacy hears Julie is dead, that is her first thought. Oh my God, he killed her. Finally, we know this conversation with Ed Klug is true. And we know how damning it is based on the defendant's reaction to it. And that's David Thompson. David Thompson is quite a character. He was in pretty big trouble in 2007. But whatever you want to say about him, when he came to court to tell you what had happened, what the defendant was up to, when he came to court to testify, he wasn't getting out of anything. He admitted he was a bank robber, but he's overcome that, and there's nothing to offer him today because he's not in trouble. Coming here for him was just an inconvenience. And with David Thompson, we have those recorded phone calls from the jail. We know that in the defendant's mind, this plot was real. This plot to sit on Ed Klug, so his testimony would never be heard. And we heard from the video of Nathaniel Clanton that this was the stupidest thing the defendant could have ever done. That's what he thought. But that's how desperately the defendant wanted to silence Ed Klug. There's absolutely no reason for David Thompson to get on the phone with the mother of his child, Kim, and give her Ed Klug's name and work address. The same thing that was in the defendant's day planner, the same thing that was on that internet search. There's absolutely no reason for David Thompson to tell Kim to say everything is as planned to the defendant when he gets on the phone. There's absolutely no reason for the defendant to be asking Kelly to give his parents $500 twice in the most evasive conversation possible. There's absolutely no reason for the defendant to be insistent that his mother get in touch with Kim in multiple calls, except that in the defendant's mind, this was a real plot. And think about that. Why didn't the defendant just leave it to the law and his lawyers? If Ed Klug's a liar, then that's what cross-examination is supposed to show. Cast doubt on him as a witness. And in fact, that's what Nathaniel Clanton said when the defendant discussed this plot with him. He's like, if you think you can beat your case, then why do you need someone to take a witness out? I want you to think about the defendant's thought process. There is a lawful, legal way to challenge Ed Klug's evidence in this case, just like there's a lawful, legal way to end your marriage with the wife you hate. But that's not what the defendant chose. And he's acting all cagey in these phone calls, thinking he's too clever to get caught. And even when talking to his mother, he references, gotta be careful on the phone. This weekend, when we know the defendant was in St. Louis, no internet activity. Once again, we see that pattern. But this weekend is significant in terms of what happened to Julie. She got sick that weekend, and kind of inexplicably so. She threw up on the carpet. And we know that this happened because that carpet cleaning bill, that's from that Monday, the 9th. She threw up on the carpet, and you can see it in the bill. It's also referenced in both of their day planners. Now, this is strange. For an adult to be so sick that they're throwing up in the carpet of their home, that's kind of how kids get sick. Very strange for an adult to be sick in that way. And we know Julie took care of the house, but she was so sick she apparently couldn't clean the carpets. She must have been really sick. Aaron Dillard knew about this. And this is how he explained the defendant cracking. Going from the defendant saying, this is all bullshit, and I didn't do it, to the confession. The defendant had been talking to Aaron Dillard about his case, getting advice from Aaron Dillard, like get those samples retested, which happened. He had been complaining a lot about Ed Klug. Then he told Aaron Dillard that he wished he hadn't made that mistake, had that drunken conversation with Ed Klug, said that's essentially what was screwing him in his case. And he said that it was on his mind because he tried to poison Julie before he left on that trip. He said he was lucky in a way that she didn't die because he really would have been screwed after saying what he said to Ed Klug. Aaron Dillard knew this, and Aaron Dillard said this, and Aaron Dillard described this admission from the defendant, opened the floodgates for the rest of the defendant's story. And this wasn't in Ed Klug's testimony. Ed Klug didn't know about Julie getting sick. Now, it was in Ted Voigt's testimony. That testimony, though, it didn't happen until January 2008. So that's half a year after Aaron Dillard came forward. And this is what you saw in that video the first week of trial. It seems like long ago now. But Ted Voigt talked about a time when Julie said she was throwing up. And he talked about how suspicious Julie became of the defendant trying to get her to drink something. And he described how Julie was telling him about the defendant trying to get her to drink some wine, and she didn't want to. And he was so insistent that it became a big argument. And I hope you can remember Ted Voigt's testimony, or at least look back on your notes. Because you see, that's the thing. This is such a massive case. There's so many facts and there's so much evidence, and it's hard to keep track of and wrap your mind around. And this incident with Julie getting sick that weekend, that's one of those hidden facts. What's the significance of it? Well, how would Aaron Dillard know? He was with the defendant for less than 4 days. How would he know? Why would he pull out that little fact? Unless the defendant told him and told him that it was significant. So let's go to our next group of searches. The next timeline the computer gives us, November 10th, 1998, once again, the early morning hours. Here's the search for suicide. So maybe this is Julie. Maybe she's on the computer searching for suicide, joining some kind of suicide group or whatever. Let's see what comes next in this browsing session. We go to physician-assisted suicide, leading to a website about an advocate for physician-assisted suicide. Is 40-year-old Julie Jensen a good candidate for physician-assisted suicide? She's healthy. She has 2 young children. She doesn't have a terminal illness. What do you think Dr. Borman would have said if Julie came and asked him about whether physician-assisted suicide was for her? This search makes no sense for Julie. It does make sense for the defendant who's looking for a way to kill. Next, we have a toxicology website. Toxic alcohols. Ethylene glycol. (2:57 a.m.). So right along this same browsing session, we're back to nicotine. Now, we can't actually see every website that was visited. As Jason Ruff from the Wisconsin Department of Justice explained, we have the internet history, that's the Excel file, but we don't have the HTML files for all the websites visited, which means we can see that there were websites visited, but we can't actually see them on the screen. But even though we can't see the websites themselves, let's look at some of the websites that were visited on November 22nd, 1998. So 11:22, 4:50 p.m. Oh, 4:50 p.m. This is a Sunday. We have Anatomy Atom, poison. Anatomy Atom, that website comes up a lot on December 2nd and December 3rd. Then we have a Yahoo search, 11:22, 5:01 p.m. for drug interactions. Remember David Naring? David Naring knew the defendant told him that all the time the defendant was looking on his computer at work for drug interactions. Before Julie's death, after Julie's death. Just like Dave Naring said the defendant was looking for drug interactions, so we see it on the home computer. Then we go to the top and we get what looks like prescription list, rxlist.com, drug. Could that be Benadryl? At the very top, could that be diphenhydramine? Generic for Benadryl? All of these searches within minutes of each other, 11:22:98, a Sunday. Now let's go to 11:26:98. Got some science units, measurements. This is all 11:26:98, 11:06 p.m. Potassium chloride, pool solutions. Then 11:29:98, Sierra antifreeze. That website was accessed. 11:29:98. We know the computer history was deleted that day. So December of 1998, these are very significant searches that we're going to look at. This activity. Now we see there's something at 1:18 a.m., but that's actually not a browsing session. That was just one HTML that was accessed. So really in December, when we're talking about the browsing sessions, this is what we're going to be talking about. So we know about December 1st. We know that's the day that Julie goes to Dr. Borman, and we know that that's the day the defendant gives her the first dose of ethylene glycol, because by the early morning hours of December 2nd, she is showing the symptoms of ethylene glycol intoxication. She's acting drunk. That's the first stage of ethylene glycol poisoning. And so what happens when Julie is acting drunk in those early morning hours? 4:35 a.m., we have the search for paroxetine. Paxil. That's the antidepressant. And so this time, this is when the defendant goes on the internet and he looks up this website for paroxetine Paxil, and he shows it to Julie, and he shows her all those side effects, a ton of side effects, as a way to soothe her worries, because she doesn't know why she's acting like this, why she's feeling like this, but she went to the doctor and she got that medicine, and so now there's an excuse. This doctor visit was very important to the defendant. Julie was scared. She wasn't just going to drink or eat what the defendant gave her, particularly when he was trying to force it on her, just like with the wine. But what if instead of force, he used deception? Something he's very well practiced in. What if he behaved how Julie wanted him to behave all along? What if he acted like he cared? What if he acted like he was concerned? What if he was good to her? He's making sure she's taking her new medication, something to drink along with it, and when she starts feeling these strange effects, he has something to blame it on, something he can show her on the internet, something to soothe her. Remember the morning of December 2nd? Julie Jensen talks to Margaret Voigt on the phone, her neighbor, and she sounded drunk. And that wasn't Julie, right? Every single witness who knew Julie told you she would not be drunk in the middle of the day. She sounded drunk because she was in the first stages of ethylene glycol poisoning, and Margaret Voigt was worried about her. But Julie said that Mark got the kids to school and he was being good to her. Right before that search for paroxetine or Paxil, we have a bunch of searches for Volvo cars. And this only matters because then we know it's not Julie. If she's sick, if she's feeling very strange, if she's looking for a reason, well, she's not looking at Volvo cars first. So that is the first internet activity, 4:31 to 4:35 on December 2nd. And I'm going to go through this internet activity in detail with you because this is an enormous case with so much material and so many witnesses and so much detail, but it's actually really simple. The person who was on this computer looking up ethylene glycol poisoning killed Julie Jensen. And I'm going to show you it was the defendant. So let's go. We're going to go to the second group of these searches, 8:14 to 8:49 a.m. And this is an unusual time to see internet activity on this computer, a unique time. And what we know about the morning of December 2nd is that the defendant didn't go to work. He got the kids off to school, David on the bus, Douglas to daycare, but he didn't go to work because he was going to Dr. Borman's that morning. So what happened in this next group of internet searches? We are going to see searches for ethylene glycol poisoning and specifically websites that include the symptoms of ethylene glycol poisoning. So I'm just going to page through these searches. Ethylene glycol poisoning, that's the first one. Oxalic acid, we learned that that's one of those breakdown products. Hard to say, I think it's fomepizole. That's the antidote. Toxic alcohols. How do patients with toxic alcohol ingestions typically present? We're getting to symptoms. Now for a moment, we're back to paroxetine, Paxil. What follows that? Ethylene glycol. We're seeing the symptoms: development of acidosis, tachycardia, hypertension, cardiogenic shock. And again, whether this is true or not, this is just on the internet, but this is what the person in front of the computer saw. So why is this research happening at about 8:15 a.m., starting at about 8:15 a.m.? The defendant has a problem. Julie has begun experiencing this first stage of ethylene glycol symptoms, and she's already worried about it. She's worried about it, and the defendant needs to know what's coming next, and he needs to know how to pacify her, or better yet, sedate her. So he decides to go to Dr. Borman. And this is what we saw from the defendant's book. Kelly told us about this book, how the defendant is planning to make some money off of this book. And he describes this trip to Dr. Borman, talking to the receptionist counter, explaining how yesterday Julie was here to see him. Let's look at his description of what he was doing. Wearing an expensive suit and a Rolex gives a presentation of authority and genuine legitimacy. And when accompanying a reasonable and polite request, frequently achieves the desired results. Really gives you a glimpse into the defendant's mind. He goes to Dr. Borman, he's got his suit, he's got his Rolex, he's giving a presentation of genuine legitimacy. Why does he have to give a presentation of genuine legitimacy? This trip to Dr. Borman isn't legitimate at all. And unfortunately for Dr. Borman thought it was. You heard in Dr. Borman's testimony, he had the best interests of Julie Jensen at heart, and he thought the defendant did too, and that's why he gave the defendant that prescription. But Dr. Borman told you that if he had known all the facts, what exactly was going on, he would never have given that prescription to the defendant. But the defendant had this air of genuine legitimacy, and he knew it. So this leads us to the third browsing session on December 2nd, 11:45 to 11:47 a.m. We know the defendant had that Ambien prescription in his hand by 11:13 a.m. That was the video of Mark Hunter. He was shown that picture of the Walgreens thing on the counter. 11:13 a.m., that's when he got that Ambien prescription. It's right on the Walgreens receipt. And he knows, we know that he wanted to give Julie the Ambien right away. That's what the defendant said in his interview, that recorded interview. Julie's first Ambien, he gave it to her Wednesday morning. So he goes home, he gives her the Ambien, and he gets on the internet. Anatomy Adam, that's what this website is. The one with the poisons, down there at the bottom. Go to E, ethylene glycol. Once again, we have poisoning caused by ethylene glycol. We have the symptoms. Symptoms listed: rapid breathing, skin, lips and fingernails blue, heart and blood vessels, rapid heartbeat, low blood pressure, headache, stupor, unconsciousness. Then we have a gap, 11:45 a.m. to 11:47 a.m., nothing until 9:31 p.m. So what happened after that? What is happening on December 2nd for the Jensens? The defendant, we have no reason to doubt this, he did go to work in the afternoon. David's at school, and we know that that's the day Julie was supposed to go to school. That's the Wednesday, but she didn't make it to Therese DeFazio's class that day. And David had the note, and David's note asked if he could go to Eric Shore's house. So David isn't coming home from school on the school bus. He's going to his friend Eric Shore's house. And Douglas is in daycare full-time now, starting that week, full-time daycare. And so the defendant and David and Douglas are not back at that house. In fact, they had karate that night. So they're not back at that house until like 6:30, 7 at night. During all this time that Julie is alone, no internet activity. This is the night where the defendant had to cook because Julie was in bed. He makes mac and cheese. And how was Julie doing during this time period? What was her condition in this time period? Well, the defendant told Paul Griffin in one of those recorded phone calls how Julie was doing. The defendant said, the night before, that's the night when I made the mac and cheese, botched that real good. She wasn't even awake much. I mean, she was in bed the whole time. I mean, she was sleeping most of the time. I think the kids were being quiet to not wake her. I mean, there was some conversation that night, but she was pretty much out of it. So while Julie's pretty much out of it, what's happening on the internet? 9:31 p.m. to 9:43 p.m. Antifreeze poison. Poisoning caused by ingestion of antifreeze with the symptoms. Breathing rapid. We know that was happening. David saw that. Hypoxia. Lips bluish. Fingernails bluish. Skin discoloration, bluish. We saw that as one of the symptoms. Blood pressure, low. Hypotension, low blood pressure. That's what was happening on the internet when Julie was pretty much out of it and didn't leave her bed. Now we're moving to 12:03. The early morning hours, this browsing session on 12:03. 12:44 a.m. to 1:23 a.m. Antifreeze poisoning. How do you think Julie's doing? 12:43 a.m. to 1:23 a.m. Well, we kind of know how Julie's doing. Unconsciousness. Consciousness decreased. Here's another search. Ethylene glycol poisoning. Hypertension. Pulse bounding. Here's another symptom we saw. tachycardia, fast heartbeat, pulse bounding. Here's another one we saw. Cardiogenic shock. Pulse, weak or absent. You know how sometimes you go on the computer because you got like a pain in your side or something's happening with your neck or whatever? You ever look up pulse, weak or absent for yourself? How about unconsciousness? You ever look that up when you're experiencing that as a symptom? We know how Julie Jensen was doing from 12:44 a.m. to 1:23 a.m., not because she's on the computer looking at these symptoms, because the defendant is. He's hoping she'll be dead by morning. So then we go to the last browsing session on this computer, 9:40 to 9:42 a.m. on the 3rd. But let's talk first about how Julie was doing the morning of December 3rd, the morning of her death. David said that his mother was breathing very heavily, raspy, labored breathing. He told his friends about it. He later told the detective about it. He asked his dad to take his mom to the hospital, and his dad said no. But his dad said, if she's worse later in the day, we'll take her. What does the defendant say about it? And we know the defendant said this. This is all from that recorded interview. Okay, that's not in dispute, what the defendant said about it. Various points within the interview. He's asked about this multiple times. She couldn't get out of bed that morning. The defendant says, you can ask David. She couldn't get out of bed. He wanted to stay home because mom was sick. She was asleep in bed. The defendant says, there was a question between myself and the kids that morning, whether or not to call an ambulance. Take her to the hospital. The kids wanted to stay home. Her breathing was funny. The defendant says from 6:30 in the morning, she was not able to get out of bed. I mean, she was groggy, almost incoherent, breathing very labored, raspy. The defendant said, I'm not even sure she was coherent. The defendant was asked if Julie sat up in bed. The defendant says, David tells me, we talked about it, David tells me that I was holding her up, supporting her. That's the part of the interview where the defendant talks about those 3 Ambien pills. One Wednesday morning, one Wednesday night, another one Thursday morning after the kids went to school. The defendant says he had to bring her water because she couldn't get out of bed. David told us the last memory he has of his mother is she said, I love you, and he said it too. What David said to the defendant, what the defendant said in his interview is that David told him mom couldn't talk that morning. I'm glad that David's last memory is I love you, but what he was saying to his dad was that his mom couldn't talk that morning. The defendant repeats again, she couldn't get out of bed. He talks about the sleeping pills and how the day before he couldn't rouse her at all. Then finally, we have that recording between the defendant and Paul Griffin, Julie's brother, talking about that morning, December 3rd. The defendant talks about he sat behind Julie on the bed, supporting her when the kids came in, getting ready for school. The defendant says she was weak enough by Thursday. If she could have gotten out of bed, it would have been crawling. Who's on the computer that morning at 9:40 a.m.? We know the defendant wasn't at work. We know he wasn't at work. 3 coworkers say that. We have Ruth Vorwald and her sister, and we have Ted Voigt. All of them, those witnesses, place the defendant either going to his house or at his house, arriving to his house between 9:15 and 9:30 a.m. that morning. He had to get Douglas to daycare. He went to pick up a check from someone down the road, but those witnesses say that he was at his house or going to his house between 9:15 and 9:30 a.m. And here's the defendant's dilemma. He was hoping when he left that morning that he would come back and Julie would be dead. But he comes back and she's still alive. So he goes on the internet one more time. That search, when Julie was incoherent, when she couldn't get out of bed, when David said she couldn't even talk, there's that search for ethylene glycol poisoning. Then we go to a website for diabetic ketoacidosis, because we learned in the medical evidence that you get acidotic from this ethylene glycol poisoning. And apparently something similar can happen to a diabetic person in crisis. The defendant's looking at that too. The last thing on the computer, ethylene glycol poisoning. This is why the defendant ultimately suffocates his wife. She would have died from ethylene glycol poisoning, untreated as she was. But the defendant can't take her to the hospital. And first, when he comes home and she's not dead, he hopes if maybe he just turns her. We know she's unconscious because of how her arm is under her body as he turns her. He's hoping if he just turns her, maybe has her face in the pillow, maybe she'll just die. And he leaves and he comes back. But she's still alive. She didn't die, and he promised, and he's running out of time. And Aaron Dillard was able to put into words what the defendant did. Aaron Dillard gained the defendant's trust, as Aaron Dillard does. But the evidence was all there to begin with. That promise to David, Julie's body, how it was positioned, the medical evidence of the hemorrhage, the suffocation. Dr. Chambliss suspected suffocation from the very beginning. So there's things we're never going to know in this case. We're not going to know what the defendant did when he didn't go to work on December 3rd, as he claimed. Dave Naring, Rosemary McGinnis, Meredith Perez, the receptionist at this small office, they all know he wasn't there that day. What exactly was he up to? What exactly was he doing? How exactly did he clean up? What did he do with the ethylene glycol he used? What about the juice that he put it in? Was that juice still in the fridge, or did he clean that up like the ethylene glycol? One thing we do know is the defendant did try to clean up. One of the reasons I spent all this time showing you the internet history is that the defendant never wanted you to see it. He deleted the internet history on this computer. We know he deleted it 11/29, 12/2, and 12/3. It's only because the police had the foresight to seize this computer in 1998, and only because the computer was analyzed by experts at the Wisconsin Department of Justice to see and get this deleted internet history, the defendant didn't want you to see it. Now, it seems that in this case, everything is blamed on Julie Jensen. But remember, this isn't a murder or just a sad suicide. It's a murder or a suicide and a frame up. If this was Julie Jensen on the computer, and I've already showed you that that's impossible, but if this was Julie Jensen on the computer, hypothetically, why would she delete that internet history? It's not what you do after planting with your friends and your neighbors that your husband's trying to kill you. If you want to frame your husband, you don't delete it. But it is what you do when you're trying to clean up and cover your tracks. So finally, at the close here, let's talk about Julie Jensen's two greatest fears. Dr. Borman said in his testimony she didn't want to be labeled as crazy and she didn't want to lose her kids. With her death, Julie Jensen lost David and Douglas. And in death now, nearly 25 years later, she's labeled as crazy. We're having a whole trial on the topic of whether Julie's crazy. The tragedy of Julie Jensen, and there are many, is she can't escape gaslighting even in death after all this time. Because we're told that Julie apparently has this family history of depression that makes her a high risk for suicide, even though the actual evidence is that that history is so minor that it makes her family indistinguishable from thousands or perhaps even millions of other families. And that family history pales in comparison to the history of other families, like where there have been actual suicides. We're told that Julie Jensen is at a high risk for suicide. And I can hardly even begin to comment on the absurdity of Dr. West's testimony. But Dr. West said Julie Jensen's view of reality was distorted. The only thing that I saw that was distorted is Dr. West's view of the evidence. But one preposterous thing Dr. West said was how Julie showed signs of suicidality. Even though she'd never made a suicidal statement, she'd never shown any signs of suicidal ideation or a plan. She certainly never attempted suicide, even though Julie Jensen specifically denied being suicidal on December 1st. There's literally nothing, apparently, that Julie could have said to evade Dr. West's diagnosis of major depressive disorder. Nothing she could have said. And what about all these statements she made of fear? To Ted Voigt, to Margaret Voigt, to Therese DeFazio, to the defendant's own sister. We're told she's just so crazy. Too crazy to be believed. I mean, is she actively framing the defendant, or is she just so delusional that she thinks the defendant's trying to kill her? We're told that Julie used the internet, that she would use the internet, even though there's absolutely no proof of that. We saw how that internet usage mirrors the defendant's life, and there's nothing like that for Julie. Not a single example. Dr. Hale and Dr. Thomas, they tell you, they act as though Julie could have been on that computer, even after she got so sick the night of 12/2 and into the early morning of 12/3, and then finally at 9:42 a.m. on 12/3. Even though that's contrary to the defendant's own words, the words of the defendant. And you know what? We're believing the defendant's words when he described Julie's condition, not just selectively because we want to believe those words because they're helpful to the state. We believe it and we know it's true because of David. The defendant knew David was talking about his mom and about her condition and about his last memories of his mother. The defendant knew the detective was talking to David. That's why there's all those weird statements in that interview. Well, David said, you can ask David. The defendant cannot lie about Julie's condition on the 2nd and the 3rd because David knows the truth. And then finally, these doctors, Dr. Thomas in particular, they blame Julie. Why didn't she call for help? My goodness, if she was so afraid of being poisoned, why didn't she call for help? Well, why didn't the defendant? Julie had in her system ethylene glycol and Ambien and Librium and Paxil and Benadryl. She, a 115-pound woman, had 3 Ambien, a brand new drug for her, in 24 hours, less than 24 hours. And the defendant was there. He saw her condition. He was there the morning of the 2nd, the night of the 2nd, the day of the 3rd. And he was there when Dr. Borman told him, if your wife's condition worsens, take her to the ER. And he was the one hearing David asking to take mom to the hospital when she couldn't speak. And somehow, according to the defense doctors, that's Julie's fault. That this woman on these 3 Ambien, sedated and drugged, it's her fault that she didn't call for help. It's like the more you get paid in this case, the less you can see the obvious. Julie's even blamed for Laura Koster leaving her job. Somehow that's Julie's fault. Julie's blamed for David's cough, David's tics, even though it was at her insistence that they scheduled that specialist appointment for David after those parent-teacher conferences. Dr. Borman testified they scheduled that specialist November 25th, but somehow that's still Julie's fault. Apparently everything, all ills can be blamed on Julie. Apparently she's crazy, and she's the one who was on that computer. But you know, it wasn't her whose hobby it was to create a stalker and invent years of terrorizing harassment using an array of pornographic photos. That wasn't Julie. And it wasn't her who took on the name of Warm Irish Eyes to catfish and torment a coworker. So let's go back to the evidence. At the time of her death, Julie Jensen was in a dilemma of the defendant's creation. And she described this to Therese DeFazio and to Ted Voigt. Either her husband was trying to kill her, to poison her, or he was trying to drive her crazy, make her look crazy, so in the divorce he could take the kids from her, as he said he would do. And Julie was a smart person, but she didn't know what to do in that dilemma. And she couldn't do anything rash, anything that looked reckless or irrational. She had to make a plan. She had to leave in an orderly and rational fashion with the kids, but the defendant had been planning longer, and he executed his plan first. Let's look at him executing his plan. This, we see here two things that are the same. This is the picture that Julie Jensen took of the defendant's day planner and made sure she got it to the police. It says, withdrawn, kids, locked chest, crying about miscarriage. Next to that, the defendant's actual day planner, seized by the police. Same thing. Another example. A picture Julie Jensen took and gave to the police. Locked chest. Locked in bedroom, morning. Jobs quit, crying about miscarriage. Suddenly detached. Julie Jensen took that picture and gave it to the police, and we see the same thing in the defendant's day planner. That day planner, by the way, found right here, right by the computer in that black bag, the defendant's day planner. This, what I've just showed you, this is gaslighting once again, and Julie saw it. Even if the police had made a mistake and not seized the defendant's day planner, even if that planner had not been seized, we would still have those photos. The police would have them because Julie gave it to them. And did Julie give those to the police to say, hey, police, look how crazy I am? Julie saw the defendant's plan. He wanted her to look crazy. She told this to Margaret Voigt, how the defendant was asking about this miscarriage, which was from years ago, and taking notes, and it made no sense to her. And she saw these notes and she knew they weren't true and wondered what the defendant was up to, and she made sure the police had it. Because Julie isn't crazy, it's just how the defendant wanted her to look. It's a continuation of the years of psychological warfare the defendant waged against his wife, but now the purpose was to make her look crazy so he can murder her, so he could give her a substance that would crystallize her from the inside out, a substance undetectable at autopsy, using a searches on the computer that he also thought would be undetectable once he deleted them. He thought he could trick Julie and the police, and honestly, if it ever came down to it, a jury. And if he hadn't made a few mistakes. Ed Klug, Aaron Dillard, David Thompson, the deleting of the internet history that wasn't deleted enough, maybe he would have been able to deceive and gaslight his way out of this too. Julie wasn't crazy. She was responding to the insane situation the defendant had orchestrated around her. If you look at the evidence in this case, if you look at the evidence, and if you aren't getting paid too much to see it, you'll believe Julie. You'll believe Julie when she said she was afraid, when she said she was afraid that the defendant was trying to kill her, when she said she saw the defendant looking things up on the computer, when she said he thought he was trying to poison her. You'll believe Julie when she said she wasn't suicidal, that she wouldn't do it. You'll believe Julie when she said her boys were everything to her, that she loved them, she didn't want to lose them, she would never leave them. You'll believe Julie, and you'll find the defendant guilty.
Folks, we'll take our break now. We'll talk about the case. We're getting real close, but go back and take your break, okay? For 10 minutes, thank you.
All right. What's up, everybody? Sorry, I had to go do something real quick. Maya says, I just don't see a person doing this to themselves. Angie, who says prosecution gave Julie justice. I don't think we're watching the same trial, but all right. All right, poll on YouTube on whether or not the prosecution's closing was convincing. 61% said no, 38% said yes. So, obviously, Facebook chat is still confused on everything. Angie, I'm curious what why you think there was justice given. You obviously think Mark's guilty. Curious as to why you think that. Maya, which part do you think? You don't think Julie was trying to frame Mark for attempted murder? I've been asking for days, chat, for days, to type in the comment section about why you think Mark is guilty. What has convinced you? Every time I ask, nobody talks. We like to communicate on this channel. This isn't fucking Law and Order and fucking Court TV. We like to communicate and debate. It's the purpose of what we do here. Learn the truth. Have discourse. Learn something. Try to change each other's minds. So quit being shy. Well, there's obviously some of you that think he's guilty. I'd like to know why. I mean, the state pretty much put Julie at every point of the crime. They've contradicted so much of their witnesses' testimony, plus their own testifying, because they don't shut up and they like to testify as well. And they've changed their story 14 times. Julie knew how to use a computer, didn't know how to use a computer. She's stupid. She's incredibly smart. They painted David Jensen as a liar because he can't get his fucking facts straight, but now we're supposed to believe him. They've said during testimony that Mark wasn't home at certain times, but now he's at the house. So Maya says, I don't know if she wanted to die. Why not just take a bunch of pills? So that's the thing, Maya. So none of us here believe that Julie intentionally unalived herself. Now, we all could be wrong on that, but none of us believe that. I think my personal thing is that I think the defense missed some stuff in 2008, and I think they're missing stuff now in 2023. There is a ton of evidence, and we have just exhausted my fucking breath on this, that she was trying to frame him for attempted murder. Attempted. So I think they're getting it wrong. They're trying to, look, Julie's got some serious problems. You know what I mean? And she very well could have unalived herself. But I think that's a wrong theory. I'm not buying it, not with where the evidence is. So there's a bunch of us that think that she planned everything to perfection. And then what she didn't account for was all of the damn pills and medications, the Z-Pak, the Duravent, the Librium, the Paxil. She was on some other drug I keep forgetting. She's all this stuff. And that's having massive side effects in her body. And that's where the plan starts falling apart. And now she's actually dying. I mean, we have literally walked through every piece of evidence throughout this entire trial. The entire trial. You guys get so hung up on Julie intentionally whacking herself. Let's just get that. Let's just erase that. Get that out of your heads. Get that part out of your heads. Go to the actual evidence. If she was so medicated, see, you guys aren't fucking paying attention. Nobody's watching this fucking trial, dude. Nobody. I'm gonna go ghost for fucking 6 months, and I'm gonna do an entire documentary. That's what I'm gonna do. She's been planning this for months, Maya. Months, and if not years. And there's evidence to support that she may have started planning this for years out. She didn't get so heavily medicated until the last couple of days. That's what I'm saying, is that she didn't account for that. You guys make me nervous if you're ever on juries. Seriously, I swear to God. When I'm done with my own docu-series, I'm telling you guys, I'm gonna go back and I'm gonna rewatch this trial. I'm gonna fucking do a documentary on this, the same as Bob Jamboy did his documentary. I'm gonna do one, and I'm gonna make it so dumbed down it's not even funny. For Facebook, put a 1 in the comment section if there's doubt. If you have any doubt, on anything, any point of this entire trial, any doubt whatsoever, the tiniest little bit of doubt, put a 1. If you're like, nope, there's no doubt he's guilty, put a 2. You guys are so hung up on her unaliving herself. How many? There's thousands of people that unalive themselves every fucking day, and they have people. So Lynn does have some doubt. So Lynn You're struggling on some certain aspects, but you have doubt. So can you actually convict this goofy guy? My opinion is to why those still think he's guilty of this. Religion goggles, good church mom syndrome, maybe. Yeah, her going around telling people she's not close to personal things. Plan is spot on. So Marilyn agrees. Again, guys, during lunch, if you guys want, we can. This is what I really want to do. Like, no bullshit, guys. Let's do this during lunch, because that's at least going to be an hour. Oh, Lynn didn't see the first 7 days. All right, so you're new. All right, so we got to take it easy on Lynn. We can't yell at Lynn. All right, so Lynn has not paid attention to the whole trial. All right, well, welcome. Welcome. I encourage you to go back in your free time and watch the entire trial. But during lunch, I want to bring people on. All right. If you want to come on, send me an email, Never.Stop.Voices@gmail.com. We'll send you a link. We'll bring you on the stream. You can keep your camera off. You don't have to turn it on. Whether you think he's innocent or guilty, I don't care which side. Let's just get some people on. Let's have like a cool little discussion between a bunch of us. Let's just chat. We did that on we had a mock jury. For those of you that are new, we did a mock jury on Friday, and we had some viewers come on and pretend they were the jury, and they all kind of deliberated. Would have been cool if we had a couple more people, but it's still a really awesome stream. But let's bring some people on the stream today during lunch, whether you think he's innocent or guilty, and let's all talk. Let's talk about some evidence and why it's believable, why it's not. Evidence that both parties, Julie and Mark, had access to. Right? Evidence that's in Mark's column, evidence that's in Julie's. Let's just talk about it. So if you want to come on, send me an email, Never.Stop.Voices@gmail.com. Again, you do not have to have your camera on. I know some people don't like that. You can if you want. It's up to you. I don't care. And let's try to get a handful of people. Try to get like 4 to 6 people in the stream, and we'll all kind of chat. But I definitely want people that think he's guilty. I definitely want it. And then people that think he's that are undecided too. You're hung up on certain pieces of evidence. There was a point of evidence that I pointed out on YouTube. So we think that Julie was trying to catch Mark cheating, so that's why she's on the computer looking up his emails, looking up the Kellys, looking up what branches. And I'm very convinced on that. I'm 100% convinced that she was a spouse that's trying to catch her bitch ass husband cheating. I think we could all kind of agree to that, right? I think we would all do that, right? We're trying to get the evidence. We're trying to get the proof that, our significant other is cheating, and we do some crazy irrational shit when that happens. But I hated the state's closing. It was stupid. I caught too many contradictions in what they said. But the one point, and it kind of put a little bit of doubt in my head for a second, right? But I went back to all the other evidence. But it put doubt in my mind for a minute. So they did kind of fuck me up for a sec. Is that Mark went on looking up the Kellys to see if she had changed her name from Labonte to, what was it, Greeman? I think it was the last name. And that's their theory. So that did kind of screw me up for a second. I was like, oh, shit, dude. Like, good. It was a great argument. That's a good way to cover that up. They got to clean that mess up, So I thought that was good. That was the best part for me. All right, make sure you guys like the stream, share it out, please. Facebook, spam the chat with hearts and likes. That helps us. YouTube, hit the thumbs up. 16 out of 22 have hit the thumbs up. If you guys want to support the platform, sharing out, communicating in chat, all that stuff helps. There's some pinned comments in Facebook and YouTube. All appreciated donations do help continue to provide content and investigative articles. We do have one open records request we have to pick up today, and then another one tomorrow. There's a couple investigative articles that ideally I'll get out by this weekend. So if you want to help us pay for some open records requests, you can hit that pinned comment. All of that helps us. And then the amount of hours that we spend streaming and editing video and writing and providing you guys the truth. So all donations are appreciated. You can become a member on YouTube and get member-only content for as little as 99 cents a month. That stuff helps too, guys. Tomorrow night, we are going to have a really cool group on Bikers Against Predators. They catch child predators and stream it live on Facebook. So we're going to have them on tomorrow night at 5:30 p.m. So that'll be streaming on YouTube and Facebook. We're going to multi-stream that because they're going to share the stream on their Facebook page. So make sure you guys are here for that. Might be a little disturbing for some viewers, but it's pretty awesome.
On the record.
Here we go.
On Mark D. Jensen, 2002, CF 314. The appearances are the same. The jury is back in the courtroom. Where are the phase of the defendant's closing argument? Mr. Perry, you can start whenever you're ready.
Thank you, Judge. I want to say how grateful I am that I'm able to stand here and speak to you all after these last few weeks. Things have not been presented exactly chronologically, or I think in the easiest to understand manner. We've had video testimony. Sometimes that's felt out of order, out of chronological order. Sometimes it's hard to hear. It'd be hard for anyone to catch everything that's been presented. Myself, Ms. Krause, Ms. Renner, and most of all, Mark Jensen, are so relieved to have such an obviously attentive and serious group of jurors. So thank you for that. Now, I'm not going to yell and shout about penis pictures. I don't yell and shout about really anything. During this trial, we've tried to be measured and analytical. And that's how I'm going to try to approach this as well. Because this man is charged with homicide. And emotional appeals that cloud the relevant evidence is not what's needed. In thinking about all the things that have been presented and trying to organize it, the photos, the harassment, the penis drawings, that was a lot of it. How much of it is actually relevant to the prosecution's allegation that Mark Jensen committed first-degree intentional homicide? I think a lot of it is meaningless. A lot of it serves no purpose other than an attempt to establish that Mark Jensen had pornography in 2002 on his computer that the prosecution has a problem with. Throughout this time that I have, I'm going to try to focus on what Mark Jensen is actually charged with and the relevant evidence regarding it. You heard the judge read the instructions, and I just want to touch on one of those instructions. Because in America, when you're charged with a crime, you have no burden of proving your innocence. It's the government that has to prove it before you can be found guilty. That's because you can guarantee you won't commit a crime, but you can never guarantee you won't be accused of one. And you've heard this jury instruction of the level of proof that's required when you're accused of a crime, beyond a reasonable doubt. The jury instruction does a couple of things. First, it tells you what a reasonable doubt is, and then in sort of a roundabout way, it tells you what beyond a reasonable doubt means. First, a reasonable doubt is, and you heard this, is a doubt based upon reason and common sense. The sort of doubt that would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. Pause or hesitate when called to act upon the most important affairs in life. What are the most important affairs of life? Is it buying a house? Is it choosing whether to trust somebody? Is it buying a car? If you're buying a house, at the home inspection, you see a hairline crack in the foundation. Do you pause or hesitate to have to need more information before you move forward? Because if you do, that's reasonable doubt. That's the standard in Wisconsin. And that instruction about the level of proof that the prosecution bears in this case before you can be convicted of a crime. What if you find out that your home inspector has a fraud conviction? Do you pause? So that's reasonable doubt. But what does beyond a reasonable doubt mean? First of all, it means nothing has given you any pause. But the instruction actually tells us what beyond a reasonable doubt means. It says you are not to search for doubt, you're to search for the truth. And that makes sense, because if you were to search for doubt, that would mean the defense carries some sort of burden. And we know that's not true. The entire burden is on the prosecution. It's the truth. Has the prosecution proven its case such that you're convinced its allegation is the actual truth? Because if there's something that gives you any pause or hesitation when considering the prosecution's allegation of what, when, where, why, how, that's reasonable doubt. And it's only when you can comfortably say there's no pause or hesitation that you can say that the prosecution has proven its allegation to be the truth. It's not guessing. It's not guessing at what you think may have happened. It's a careful analysis of whether the government has met its very high burden before a person in America can be convicted of a crime. Through the course of my time to talk with you, I want to talk about memory and how we all know how memories change. How they changed in this case. You saw that with witnesses testifying now, asked about their memories and what they testified to in 2008 and 2007, in 1998, maybe in 2002 when they were first interviewed by the investigators. How it was years before investigation even spoke to people in this case. How it was 9 years before some people even claimed they remembered anything. This trial has taken about 3 weeks. Wait and see when you go into deliberations if you all have the same memory of what each witness said. I want to talk about lies, because the centerpiece of the state's entire prosecution is a lie. And I want to talk about something called confirmation bias. Confirmation bias is when someone searches for and interprets information in a way that confirms or supports one's belief. It's not scientific. It's the opposite of scientific. It's not a process that results in a fair assessment of evidence. It's the opposite of fair. We see it in the states bending facts to science when it should be applying science to the facts. We see it in how Julie Jensen is described by the state. We see it in the systematic ignoring or pretending that certain facts just don't exist. We talked about things that cause you to pause or hesitate in the most important affairs of life. These are things that can cause more than just a pause. These are full stops. I want to mention a couple of things just out of the gate. There have been some, and this fits with what I've just talked about. There's this assertion that there's a high five when Mark came back to his house on December 4th. We talked with Detective Ratsburg at length about the handoff of that house on December 4th and the police that were there and all the observations of Mark Jensen. And you didn't hear anything about an observation of a high five and the timing of when this would have happened and it being late at night and how everything was being observed and recorded. This idea that Mark Jensen threw away her belongings. Now, I mean, I'm not going to be able to go through everything everyone said, and you're going to have to rely on your notes for some of these things. But the throwing away the belongings, when we dug into what does that mean, what was actually observed, very little. And very little knowledge or no knowledge at all about whether things were set out for a donation, what was in bags. Somebody recognized something that they thought may have belonged to Julie Jensen. And from that, this memory was created that, oh my God, Mark Jensen threw away all of Julie Jensen's things. Go back and look at what was actually said about that. He hated her. And that's what was going on. I mean, that's really, I'd say it's a lot more complicated. We heard just yesterday how Mark and his son were building a Christmas rod, a fishing rod for Christmas for Julie Jensen. Those day planner notes, and then combined with her later statements about how he's encouraging her to see a doctor. The investigation that was done in this case, you know, even the things found in that office, the box of zip drives, you know, nothing was fingerprinted. This theory, this idea that Julie Jensen never had anything to do with the computer. There's just very little investigation that was done in most of these things. They weren't looking for ethylene glycol. This idea that it was hidden, or what was Mark Jensen doing on December 3rd? They weren't looking for ethylene glycol when they searched the house. Detective Ratsburg acknowledged that. He said, when we looked back at the video, yeah, I could see things in the garage that looked like probably antifreeze. They took the Playboys. They didn't take the antifreeze. I need to spend some time talking about Aaron Dillard. Aaron Dillard, Aaron Galvin, Kyle Rezick. I don't know who this person is. He's an actual con man. He's someone who has conned educated people out of their life's savings. He's an international con man. And he's never stopped his lying, and he's never stopped his deceit. How does a con man convince people to buy his stories? He blends facts with fiction so that it sounds possible. He tells people what they want to hear. He presents himself as a reasonable, well-spoken individual. I think you saw that in here. You saw how he presents himself. In Lithuania, these families wanted visas to America, so Aaron Dillard took their life savings, and he did that 7 times over. Think of the things that Aaron Dillard was willing to do for a few $100s or a few $1,000s. He lied about who he was. He defrauded companies. He bought check stock, created false companies, false payroll checks. He researched how to be a medical and surgical equipment seller in order to defraud Wendy Reamer, who believed his name was Kyle Rezick, over and over again. You heard Lori Brown. She was a lawyer and then an administrator of a law firm, a smart, educated woman. She got defrauded by Dillard. She described him as personable, knowledgeable, and that he instilled a lot of confidence. Her opinion? He's not a truthful or honest person. How about Deborah Teagle Spears? She testified in this case. She met Kyle Rezick. She lent him money. Eventually, she went into his wallet to find out what his real name is and ran a check on him. Do you remember what Miss Spears said about Dillard when asked about his character for truthfulness? She said, "He has no character. He's a con man. He uses people for what he can get out of them." So on August 14th, 2007, when Aaron Dillard got to the Kenosha County Jail, what was he willing to do? He had been out on extended supervision and was coming back to court to determine how long he was going to go back to prison. He was AWOL from supervision. He got pulled over on May 31st, 2007. At that point, he hadn't reported to his agent since the previous October. When he got pulled over and he had a suspended registration, he lied to a police officer and said he was his brother, Mike Kaiser. And then while claiming to be Michael Kaiser, he blamed the suspended registration on his brother, Aaron Dillard. This is what he does. The police figured it out and he got charged with obstructing an officer. He had 17 violations while out on probation. He had cheated Dennis Ritt out of money. He told Dennis Ritt that he had a telecommunications company in Lithuania. He convinced him to lend him money, never paid him back. He wrote a check from a closed bank account to Dennis Ritt, knowing it's not good. He had defrauded Lori Brown. He had defrauded Cassandra Ivey. Cassandra Ivey had paid him $6,200 and had a construction contract with Dillard. For that, he got charged with theft by contractor and home improvement fraud. Dillard was facing 7 years on that case. For the reconfinement, he knew that his probation agent was recommending he get the maximum time available of 4.5 years. And it was an aggressive recommendation. I asked Aaron Dillard this when he was testifying, and he acknowledged, he said he was aware of the probation agent's justification for the maximum sentence. And I read it to him, and he remembered it. It is obvious that Mr. Dillard is in need of serious CGIP, but his criminal behavior is well beyond the need of cognitive thinking. His repetitive, deviant thinking is just in plain need of confinement. Even though prisons are normally used for rehabilitative purposes, Mr. Dillard is in desperate need of incarceration. It is the suggestion of this document that persons with criminal behavior of this caliber show no guilt or remorse. Their goal in life is to be a successful criminal. They are motivated by the power they feel to manipulate others, sometimes for material gain. So when he got to the Kenosha jail on August 14th, 2007, he was facing 9 months on that obstructing charge, 7 years on the theft by contractor home improvement fraud case, and a recommendation of 4.5 years from his probation agent. What was Aaron Dillard willing to do for a few $1,000s? Ruin people's lives. And you've seen what Aaron Dillard was willing to do to get out of years of prison. When Aaron Dillard got to the Kenosha jail on August 14th, 2007, he immediately recognized Mark Jensen. He knew about him from articles, he knew it was a high-profile case, and within 30 minutes he was talking with him. That's how quickly Aaron Dillard found his mark. And what did Dillard claim? He basically talked nonstop with Mark Jensen about his case. The evening of the 14th, all day on the 15th, all day on the 16th. He said that Mark Jensen shared the transcript of the Klug hearing and then talked all about his case. He said that Mark protested his innocence all evening of the 14th. He said that Mark protested his innocence all day on the 15th. And then on the 16th, Aaron Dillard said, you know, we all did something to get here. And Mark said, yeah, and then gave him a full confession. Do you remember the 7-hour interrogation by Detective Ratsberg? You were shown 45 minutes of it. Highly trained interrogator. I guess if only Detective Ratsberg had said, come on, right? Aside from just how unbelievable this story is, the prosecution bought it completely. Dr. Mainland bought it. Dr. Chambliss bought it. Mark Jensen was charged in 2002 with homicide in this case. Then in 2008, after hearing about Aaron Dillard's claim, they changed their opinions. Dr. Chambliss went from undetermined to asphyxia by smothering. Dr. Mainland went from ethylene glycol poisoning to ethylene glycol poisoning with probable terminal asphyxia. Why was everyone so willing to be victimized by Aaron Dillard? I think it's because the science and the evidence don't support the theory that Mark Jensen killed Julie Jensen with ethylene glycol. I think it's because it makes no sense that if Julie Jensen was paranoid and not eating or drinking anything from Mark, that then she'd suddenly eat and drink everything he gave her. And according to Doctors Chambliss, Mainland, and the prosecution, where could Aaron Dillard have learned these details? We're not wondering that anymore, are we? On August 11th, 2007, 3 days before Aaron Dillard showed up, Mark Jensen received 2 oversized envelopes from his attorney. In those envelopes were the transcripts of Ed Klug and the interrogation of Mark by Detective Ratsberg. Now, you heard from Nathaniel Clanton. Nathaniel Clanton's time in J Block actually overlapped a little with Aaron Dillard. I think he said he got there on August 16th. Nathaniel Clanton explained how Mark Jensen handled himself in the jail. He said Mark had 2 bins of paperwork. Mark would freely discuss details and share that paperwork with other inmates. He'd share his police reports. He'd freely share his case files. Nathaniel Clanton explained that Mark would even share this with the people that were only there for a few days. And Nathaniel Clanton did more than that. He explained what an awful idea it is to share your information in a jail. people will use it against you. They'll take the information, they'll twist it, they'll add some lies, and they'll make it look like you're confessing to something you didn't do. Mr. Clanton explained that happens quite a bit in jails. When Detective Ratsburg interrogated Mark Jensen, he told you that he was trying to come up with different scenarios to get Mark to confess. Detective Ratsburg had the autopsy, and he was trying to make his scenarios fit what he thought were the autopsy findings. He testified to that. You heard Detective Ratsburg's imagined scenarios that he proposed to Mark Jensen. Her arm was actually here. I'll show you how she was, okay? Her arm is actually across her body like that, okay? And it's an unnatural position. Do you sleep when you're on your side with your arm across like that? I know there was some type of contact there. There had to be in the chest, this chest area, Mark. There's no question about that. And the only person that could have done that was you. I'm thinking before you left, you pushed on her maybe. Now, she was frail at the time. She was frail. You said she was labored breathing. That makes sense, and I believe that. Okay, I know that probably happened, but she's frail. And you just innocently, I don't want to, pushed her like that. And could that have caused something? I mean, we have petechiae of the lungs. There's some type of contact here in the throat. There's also been an indication on the throat, as I showed you in Dr. Chambliss's report. It just did not appear there. Something and somebody had to touch her. That's the only way it could get there. There's no doubt about that. And did you push her, touch her on the throat maybe? Maybe like this? Maybe when you brought her over this way, you pushed her back on the chest and then went back and brought her up again. You know, you would have pushed her back. We still have to explain the nose part, the head pushed into the pillow. How are we going to explain that? I mean, that's there. Something had to push it down. There's three things that happened here. Head being pushed, the nose, some type of contact here at the throat, and some type of contact here in the chest. We know that happened, okay? You were the only one there. You had to do something, Mark. Dr. Mainland acknowledged, testifying this time, that Aaron Dillard could have gotten those details that made up his claim from this transcript. She agreed that Aaron Dillard's claim was not found in the Klug transcript, but was found in Detective Ratsburg's claims in the interrogation transcript, and that those claims lined up with the autopsy report. The prosecution has insisted, though. They keep insisting. Aaron Dillard denied reading anything except for the Klug transcript. Well, his claim would be a lot less convincing if he admitted to making it up. Can you trust what Aaron Dillard says when a decade of prison is on the line? Can you trust him when $50 is on the line? Dr. Mainland said she wouldn't buy a used car from Aaron Dillard. Does Aaron Dillard give you pause? To me, it warrants slamming on the brakes and never wanting to engage with the man in any way. We have to look further because his story has some reveals. Look closely at it. He said that Mark wishes he hadn't opened his stupid mouth around his coworker about him wanting to kill his wife. That's what's fucking him now. That's what Aaron Dillard wrote. So the person who allegedly regrets saying something to Ed Klug while maintaining his innocence, while denying that he ever said anything to Ed Klug, would then open his mouth and offer a full confession to the person that you're saying these things to? That doesn't make any sense. Aaron Dillard says, on a Tuesday, he took her to a doctor. That's a small detail buried in his statement. But we know from Dr. Borman that Julie came alone to that doctor appointment. He first describes Julie Jensen on December 2nd as just throwing up a little. He then changes it to really just vomiting. There's no vomit anywhere. And when she died, her stomach was full. He says that Mark came home and that Julie Jensen was breathing better. But we learned from Dr. Hale, the only one who testified in this courtroom that was qualified to discuss ethylene glycol poisoning, the only toxicologist you heard from. As long as a person is still processing ethylene glycol, they'd be in phase 2. Their breathing wouldn't get better. They'd be trying to get rid of that, to blow off that carbon dioxide. And because Detective Ratsberg isn't a forensic pathologist, he proposed an asphyxiation death, but didn't take into account that there were no marks or injuries to the inside of Julie Jensen's mouth when what's described as shoving her face into a pillow until she asphyxiated. He didn't take into account that nothing was aspirated, nothing was regurgitated. There were no injuries on her back. Would you buy a used car from Aaron Dillard? His story is a lie meant only to benefit himself. When he created his story, he had over a decade of prison that he used this to reduce to 0. Now, he's got even more at stake. He's facing decades in prison right now, and he's getting another letter from the prosecutor, which is the same thing he got in 2008, resulting in no time for lying to that officer. Would you rely on Aaron Dillard for anything except to lie? I want to talk about the autopsy. Dr. Michael Chambliss wasn't the medical examiner for Kenosha County. He came down on December 4th to do the autopsy. He did his autopsy report, and then he did nothing else with the case. He didn't review reports. He didn't send things out for studies. I think he said he didn't even review the toxicological results. He did an autopsy, and then he turned it all over to the medical examiner's office, and his role was done. That autopsy was in 1998. I think the faxed autopsy report was in February of 1999. The person he turned it all over to, Dr. Maureen Lavin, we never heard from her in this trial. A side note, even though Dr. Chambliss, even though the only report he ever did said that the cause of death was undetermined, he felt pretty comfortable in court giving an opinion to cause and manner of death without having done that investigation that a medical examiner does. Do you remember Dr. Lindsay Thomas testifying? The renowned and respected forensic pathologist? The prosecution attacked her because she didn't know the acronyms Mark Jensen and Kelly Labonte used in their emails. But Dr. Chambliss, he told you that his involvement in this case and his investigation was done at the time he issued that preliminary report. So what did he note and how did he explain it? He agreed that Julie Jensen had a substantial amount in her stomach. He agreed there was no way of knowing how long it was in there. It was very likely she had delayed gastric emptying. He identified petechiae in the cardio area. He found no injuries to the insides of Julie Jensen's lips and cheeks. He found no fluid in the nose. There was no aspirated food in the respiratory system. He found zero evidence of external forces to the chest. He found zero evidence of trauma to the abdomen. There were no rib fractures. And then he identified a small amount of hemorrhage involving the soft tissues and muscles attached to the left, second, third, and fourth ribs. Remember this theory that exists that from Aaron Dillard that this grown man climbed on top of Julie Jensen's back and forced her lungs to close. Set aside whether the evidence actually established that this hemorrhage was just post-mortem lividity or congestion since Julie Jensen was lying on her side. And set aside for a moment that the picture actually just shows darkness on all the ribs on that side of the body, demonstrating that this is just congestion. Dr. Chambliss even said this could be post-mortem artifact. He testified he doesn't know when this injury, if it even is an injury, even occurred. He said it could have been caused by bumping into something. And then he was asked whether Julie Jensen's death could have been positional asphyxia, whether she had gotten herself into a position and she couldn't breathe. And he said no. And the reason he said no is he said, because that wouldn't explain the hemorrhage on the ribs. This is the very thing he just had testified could have been caused by bumping into something, could have been post-mortem artifact. And if it was a hemorrhage, he was unable to say when it occurred. But then the reason he rejected the idea that Julie Jensen might have gotten herself into a tough breathing position is that it didn't explain the very thing he agreed had several completely innocent explanations for. I don't know what to do with that. That's confirmation bias. That's some sort of circular logic that does not belong in a courtroom. That's wholesale reliance on Aaron Dillard. Even with that, then Dr. Chambliss agreed that if Aaron Dillard's a liar, then Dr. Chambliss's cause and manner of death would be undetermined. Science didn't lead to Dr. Chambliss's opinions. He made the science fit the story told by Aaron Dillard. Dr. Mainland also, she says, that could be hemorrhage, it could be congestion, I don't know what it's from, when it's from, could be post-mortem artifact. After Aaron Dillard, it's hemorrhage, it's terminal asphyxia. She said she wouldn't buy a used car from Aaron Dillard. I'm sorry, but that says all you need to know about how Dr. Mainland's use of the phrase to a reasonable degree of medical certainty. In its opening statement, the state called Kelly Labonte the motive. Excuse me. Throughout this case, how many times did we hear about the cruise they were planning? At some point, she described to Mark Jensen all the men she had ever been with. And yesterday, when Mr. Jamboys was cross-examining Dr. Sarah West, he argued these four things. He said, Mark Jensen and Kelly Labonte had an affair and they had made a plan to go on a cruise in 1999. Kelly Labonte then divorced her husband. Then Julie Jensen died. Isn't that convenient? Do you remember those questions? Well, the problem is the chronology is completely off. They had an affair. No one's contesting that. Julie Jensen had an affair. Mark Jensen had an affair. I'm not saying that makes them even or something, but these affairs happened, and it's not being contested by us at one bit. Kelly Labonte talked about divorce. And then Kelly Labonte called off the affair with Mark Jensen. And buried in all the emails that were presented in this case, on October 27th, 1998, Kelly Labonte says, I did realize I need to give this a fair shot or get the hell out. I've decided to give it a fair shot first. A 6-year relationship that I fought tooth and nail for and a 1-month marriage deserves at least one bold effort. Anyway, I would very much like your support on this. I need to focus on the positives of this marriage and see what happens. Mark's response? You've always got my support. That was October 27th, 1998. Kelly Labonte called off the affair in October. She ultimately left her husband. That was in January of 1999. And then she got divorced in March or April of 1999. So this argument, how convenient for Mark Jensen that Julie Jensen died after this divorce from Kelly Labonte with her husband, it's changing the facts to fit the narrative. It's clear that this marriage was in trouble well before Mark Jensen had his affair. This marriage was in so much trouble that when Julie Jensen had her affair, she actually filed for divorce in 1991. I want to talk about Ed Klug. Think of how unbelievable Ed Klug's testimony is. How unbelievable he is as a person. The Blueprint Conference was in November of 1998. Julie Jensen died a month later. Over 3 years went by, and he reached out to the police department because he had something to say. And what did he have to say? That Mark might have used a computer in the Appleton office, but all the computers have since been changed out. That's it. That was his contribution. And nobody cared. 5 more years went by, and we're now 9 years from when Julie Jensen died, and Ed Klug gets contacted. And Ed Klug suddenly has a much more interesting story for the prosecutors. You know what? A month before Julie Jensen died, Mark Jensen told Ed Klug, someone he did not have a personal relationship with, that he was looking up ways to kill his wife. Now, in 2007, he had no notes of this. He testified he didn't have notes of this. He testified he didn't write anything down. He had no notes of any conversations or any details. In 2008, he found the notes. This is one of them. They don't say the words ethylene glycol or antifreeze, but that's what he remembers Mark told him. Why didn't Ed Klug come forward? He says it's because Mark was his boss. But Mark wasn't his boss in 2002 when he reached out to the police to tell them that Mark had used a computer. Ed Klug testified that when he called his wife at 2:34 a.m., he told her that Mark Jensen was talking about killing his wife. According to this note, and to his story, Dawn Cooper was present. Near the bottom, Mark unloaded on us. So what did Dawn Cooper say? She remembered sitting with Ed Klug and Mark Jensen in the hotel lobby after bar closing. She was going through a divorce and they were saying supportive things to her. She remembered Ed Klug leaving to call his wife. She said there was no conversation about harming wives. She said there was no conversation about anyone using a computer to look up ways to harm a wife. She was no longer working at Stifel in 2002 when Mark got charged in this case. She testified she got a call from Ed Klug, and he said nothing about any conversation in 1998. Dawn Cooper got contacted by the prosecutors in 2007, or by the investigation. And the way she was asked about it is consistent with what Ed Klug says, that she would have been present for that conversation. And she knows it never happened. She would have remembered that. Stacy Bauer, she worked in the Appleton office. She came here and made an assertion that she heard this from Ed Klug. She also acknowledged having read about Ed Klug's testimony. And remember this, what's on the screen? That's her written statement from August 10th of 2007, which says, quote, I have no knowledge of a conversation Mark had with Ed Klug in St. Louis regarding killing his wife, end quote. Ed Klug says that Mark was talking about a website called howtokillyourwife.com. In all the computer stuff that we've heard, have we heard anything about howtokillyourwife.com? Joan Wise was Ed Klug's longtime assistant. Do you remember that Ed Klug claimed he told all staff on the Monday after the conference about this conversation? Joan Wise says that never happened. She never heard anything about Mark Jensen from Ed Klug, except that Mark Jensen's wife had died and that she had committed suicide. That's what she heard from Ed Klug. Ed Klug never said that Mark Jensen talked about killing his wife. She gave us her opinion about Ed Klug's honesty. He's not a truthful person. Her knowledge about his reputation, you can't believe a word he says. He's an attention seeker. Ed Klug's testimony about his drunken night in 1998 is just not believable. Ed Klug is not believable. This issue of David Thompson, David Thompson acknowledged that prior to talking to Mark Jensen, he wrote a letter to his fiancée saying, it's time to help myself. And everything about David Thompson is consistent with this, that David Thompson came up with a proposal, a crazy proposal, that somebody would be held for 6 weeks for $1,000, that he communicated that proposal to Mark Jensen, and then it's also very clear that no money ever exchanged hands. Now, you heard some phone calls. You heard some recorded phone calls between Mark and his parents. And the one that I had played, the couple that I had played, predated the ones that he was calling where it was a three-way call with David Thompson. And you can hear the intimidation in Mark's voice. And he's talking about, I need you to do this or I'm going to have a fight on my hands. You heard that advice from Nathaniel Clanton. Nathaniel Clanton said, this would be the dumbest thing you've ever done or something like that. And he said, beat your case fair and square. It seems like Mark took that advice because no money ever changed hands. There's this sort of peripheral theory that's been floating around in this trial that in November of 1998, Mark Jensen had tried to kill Julie Jensen with ethylene glycol. And the only reason that this exists is because of Aaron Dillard. Now, we know that Julie Jensen threw up all over the carpet and didn't clean it up. And we've heard all about what ethylene glycol poisoning is. We didn't hear really about it from the state's witnesses. Like I mentioned earlier, no toxicologist. Their experts were Dr. Chambliss, who didn't review things, and then Dr. Mainland. But here's what's interesting about this claim, is Julie Jensen was at home with the kids. And with all the conversations and reports to the neighbors, the Voights, and with all the phone calls to Dr. Borman when there was the slightest sickness in that household, and with the statements about the paranoid statements about maybe being poisoned or being drugged or somebody's out to get me. There's nothing about this incident. There are no reports to Dr. Borman. There's no reports to the Voights. There's no report of breathing problems. There's no report of intoxication. There was no poisoning in November. I'd suggest that this vomit all over the carpet that wasn't cleaned up, that might be indicative of something else that was going on. Julie Jensen used the computer and she used the internet. We know this from Laura Koster. Laura Koster was an IT expert. She said that Julie Jensen used the computer and used the internet. We know this from her son, David Jensen. We know this from the Quicken software that she used when Mark was out of town. We know this from the resume she created on the computer. There's this statement from Therese DeFazio that Julie Jensen said she didn't know how to turn on a computer. And then there's a little bit more of an explanation. And Therese DeFazio talked about clearing out the cache or checking the cache. And the clarification is that Therese DeFazio, at school, they had Macs. Could that have been why Julie Jensen didn't know how to turn on the computer at school? Because at home, they weren't on just their first computer, and they had IBMs. Now, set aside the problems with the investigation. The computer wasn't write-blocked when Detective Ratsberg insisted it be turned on, and the corruption of the files that can be caused by that. Now, the state said, when they looked through these different websites, they said, we know it was Mark on some days because the website was for Bass Pro Shops and for a cruise. They looked to context to say who would have been on these sites, who would have been looking at these pages. Well, the interests of Julie's and the context of these websites tells us what was going on. This October 16th, the recipe link, a message board for cooking recipes, botulism. Who was the only one who did any cooking in the Jensen household? On October 16th, after 11 p.m., there's an access to the Stifel branch listings. And an email between Mark and Kelly Labonte from earlier that day. And then there's a search in Stifel for a Kelly, no last name. Mark Jensen knew who Kelly Labonte was, and he knew how to email her, and he knew where she worked. Julie Jensen knew who Kelly Labonte was. She knew of Kelly Labonte. This is the cover. This is the first page of Julie Jensen's day planner. And you see on the upper right corner, it says Kelly Labonte. And this lines up with what Ted Voigt said, that about 5-ish weeks before her death, that Julie Jensen knew that Mark was having an affair. The prosecution needs this to be Mark Jensen because there are searches for mercury fulminate in nicotine. The prosecution needs it to be Mark Jensen, or else it shows that Julie Jensen accessed the computer late at night. On November 10th, 1998, suicide message boards. A search for suicide, a search for physician-assisted suicide. I don't know why anyone clicks on different links after doing a search. I don't know how long Julie Jensen stayed on the page of physician-assisted suicide, but there's only one person in that house that would have been searching for suicide with what we know about the context of what was going on with Julie Jensen in those last couple of months. Look at the internet searches on December 2nd that Ms. McNeil showed you. 8:16 a.m. through 8:38 a.m. An article on ethylene glycol poisoning, oxalic acid, fomepizole, toxic alcohols, a page on how patients with toxic alcohols present, the dangers of ethanol substitutes, ethylene glycol, specific poisoning information. We heard about SSRIs from Dr. Hale, I think, and also Dr. West about the risk of certain medications and how they can ironically increase somebody's risk at suicide. The prosecution needs this to be Mark. But on December 2nd in the morning, Mark took Douglas to daycare. That was at 8 a.m. And then he went to Dr. Borman's. And after meeting with Dr. Borman, a prescription was written, and Mark Jensen took that prescription to Walgreens, where he waited for it to be filled. That was around 11:13 a.m. These searches at 8:16 a.m. to 8:38 a.m., all about ethylene glycol, it had to be Julie. On December 3rd, you have searches late at night, and then in the morning, 9:40 a.m., toxic alcohols, ethylene glycol poisoning, a page on diabetic ketoacidosis, 9:42 p.m., 2 minutes later, back to the Yahoo search results for ethylene glycol poisoning. I think it was the state's first two witnesses in this case, Ruth Vorwald and Shannon Krause. 9:30-ish, they saw Mark driving. He wasn't at home. These had to be Julie. Mark had gone to pick up a check from a client. Then later he said that he stopped in the office. Now, Detective Ratsburg waited over 3 years to interview anyone at the office. And 3 years later, after Mark had been charged, they said they didn't see him that day. Well, the police searched all of Mark's property. They searched his briefcase, they searched his office. The check that he went and picked up from the client, that wasn't found at the house. This is the problem with memory. It's the problem with waiting years to talk to people. Now, we know from Dr. Hale about the late stages of ethylene glycol poisoning. There is no scientific reason that she would have been unable to go to the office and do a basic internet search. We know her body was producing urine, and there was no urine or any fluid in the bed. Julie Jensen was able to get up and go to the bathroom. We know from David Jensen that his mom hugged him and spoke with him that morning. You know what's interesting is there are no searches on this computer for Ambien, Paxil, Librium, there's paroxetine, Librium, Benadryl. No searches for divorce, right? That point's been made. Even though we know Julie Jensen was planning on getting a divorce. We heard that yesterday, that after the holidays, she'd be getting a divorce. Nothing like ethylene glycol or poisons or drug interactions were ever found on Mark's work computer. And this claim that he fried that computer is nonsense. They recovered that computer and they analyzed it. So who was Julie Jensen? We heard from witnesses that Julie Jensen was a lovely human being. We heard from witnesses that she was a devoted mother. We have no reason to doubt either of those characteristics. But you can be lovely and you can be devoted to your kids and you can be mentally ill. And Julie Jensen was mentally ill. She had a major depressive disorder and was at high risk of suicide. Sometimes it's hard to put a finger on what we're supposed to believe about Julie Jensen. Was she meek and vulnerable? Did she need Mark's permission to discuss their kids' medical issues with a doctor? Was she constantly under the thumb of her husband, being controlled by whatever he wanted? Was she so naive that in 1998 on their second home computer that she didn't know how to turn one on? Did she need Mark to explain to her why she was feeling intoxicated on December 2nd? It sure doesn't seem that way. She was a straight A student. Chemistry, human physiology, death and dying, pharmacology, psych abnormal behavior, genetics. Those transcripts were admitted into evidence. She had her Series 7 brokerage license. She created a resume. After she had her own affair in the Jensen home with their 1-year-old in the house, she was the one who sent Perry Tarika packing and told him never to call or contact her anymore. That's not meek. We heard about her counseling in 1990 to 1991 with Paul DeFazio. She decided she wasn't happy with the progress. It wasn't going fast enough. And so she called and said she was going a different direction. That's not meek. When she fell in love with Perry Tarika, she got a lawyer and filed for divorce. She was in charge of the family finances. You've heard how she used Quicken on the computer. Her best friend, Laura Koster, the IT specialist. Laura Koster looked to her for how to use Quicken. Laura Koster confirmed that Julie Jensen used the computer and used the internet. When the private investigator, Dave Ellis, when he told her that the photos left at the house weren't her, she told him he was wrong. And she told him she didn't want his services anymore. When Perry Tarika sent her a letter with clipped out articles and cartoons, Julie Jensen called the police on him. Julie Jensen made decisions for herself. Now, the prosecution has advanced this theory that Julie Jensen was made to believe she'd lose the kids if they got divorced. I don't know where that claim comes from. She had a lawyer when she filed for divorce in 1991. She asked for full custody in that filing. According to Jill Polera, she was about to file for divorce again. Laura Koster said Julie didn't need Mark's permission and didn't need Mark to tell her what to do. Laura Koster would go to Julie Jensen with medical questions. But Julie Jensen did have some serious, long-standing mental health problems. And here is where I think the photos and the phone calls are actually relevant. We know that on June 29th, 1990, Mr. DeFazio, the psychotherapist, met with Julie Jensen. She had a new son. She'd been married for 6 years. He identified the possibility of limited postpartum depression. She described her mom's problem with alcoholism and said that there was a family history of depression. Mr. DeFazio testified that Julie Jensen was experiencing some obvious mental health issues. He diagnosed her as adult situational reactive with mixed features. He noted features of depression and anxiety. She told him she had a very unhappy childhood and was not happy whatsoever. Now, in July of 1990, she described getting little support from her spouse at home. In September of 1990, seasonal depression was noted. 2 weeks after that, they discussed an antidepressant and he referred her to a psychiatrist. She was prescribed Prozac. The psychiatrist, Dr. Newman, described her as crying all the time, having no appetite. She used to enjoy cooking, and now it's just a chore. Those are the notes. Chronically depressed, cries easily. Mr. DeFazio explained that with depression, things that used to give pleasure just don't anymore. Now, I mentioned in June of 1991, Julie Jensen canceled and said she wanted a different therapist, that progress wasn't going fast enough. She never told Mr. DeFazio about the affair. Mr. DeFazio made no referrals and did not know if she saw anyone else. Now, throughout this time are the hang-up calls and the issues with photos left at the house. I don't know what to make of the hang-up calls. Her log lists a lot of them. There's this narrative from the prosecution that it was Mark, and that when there'd be a trace, the calls would stop. We've heard that. It's false. We looked at the logs. We went through this. The vast majority of the hang-up calls were out of area. And in the 90s, I guess they couldn't trace those. The calls kept coming in while the traces were in effect. We've seen that in the logs. I went through those with Detective Ratsberg. Detective Ratsberg testified that out of area meant out of state. Mark's work phone was a 262 area code. The prosecution's argument that Mark was gaslighting Julie with hang-up calls, we know that because of the traces. is just simply false. The less than thorough investigation of Perry Tarika as being the source of the calls, they called and asked him and he said it wasn't him. Were these just normal hang-up calls? If they were, was this just more paranoia and perceived harassment? So what about these photos? Perhaps we can consider what evidence there actually is about these photos. What was actually described in all of those police reports to the House. The reported leaving of photos was sporadic. And Julie Jensen was convinced it was her in the photos. What Detective Ratsberg wrote, when I spoke with Julie last, she mentioned to me that she and Mark had sexual problems, and she stated that the photos, which normally showed her having contact with a man's penis, is something Mark wanted to do, but she refused. The photos were described as showing her. They were described by Julie Jensen as showing her. Now, Julie Jensen is a smart person and presumably would know if these pictures were of her. Now, despite testimony that there was a bag of evidence turned over and all the photos, all that was retained was a single photograph that by its description was unlike any of the others. This one was on actual photo paper. It had, I think, like a Kodak stamp on the back, and the picture looked nothing like Julie Jensen. Maybe the other ones didn't look anything like Julie Jensen, but the other ones were described as being on copy paper. These were never fingerprinted, although Detective Ratsberg acknowledged that they could have been. We heard from the secretaries that worked with Mark in 1998. They denied opening any mail that had pornographic pictures. But Detective Ratsberg confirmed that the only claims about getting photos in the mail at work were in the early 90s. Here's what else we know. They were all destroyed. So these pictures that Mark Jensen is accused of leaving around and sadistically torturing Julie Jensen with, there's no evidence for us to look at. Now, Mr. Jamboys asked Dr. West yesterday. He asked her this question. If Julie Jensen knew that she was being sadistically, psychologically tortured by Mark Jensen, would that suggest that her perceptions of reality in her stated fears were not distorted? First, Julie Jensen consistently denied everyone's suggestions that it might be Mark leaving the photos. She fired Dave Ellis, the investigator, when he made that suggestion. She insisted to Officer Kosman that they were her. So, if it was truly obvious that these pictures weren't of her, what does that say about her mental state that she just insisted that they were? Now, the next doctor reports that we have are Dr. Borman's. And he was her doctor from the mid-90s until Julie Jensen died. And she called about so many things. She called when Mark Jensen had washable marker on his face. She called if there was a cough in the family. You heard us go through these records. But in September of 1998, at that appointment, she brought up the family history of depression. She was concerned about her mom's history. She was tired. She had been prescribed Prozac before. Dr. Borman diagnosed her as having mild depression. At that visit, she weighed 123.5 pounds. In the fall, Laura Koster was talking with Julie Jensen outside while the kids played around them. And Julie showed Laura a photo of a list and a plastic syringe and asked her what she thought. And to Laura Koster, the person who knew her best and was her best friend, nothing seemed odd about what she was being shown. But what she noticed from this was the unsureness and the oddness of the question. And then Julie, while the kids were playing around them in the driveway, mentioned she thought Mark was going to kill her. And Laura Koster told her she didn't see it at all and was absolutely stunned by the suggestion. But she said, if you feel you're in danger, come with me and we'll make sure you're safe. Laura Koster knew Julie Jensen better than anyone, and she said that Julie Jensen wasn't scared. She said Julie Jensen, in that conversation, had extraordinarily flat emotion for the topic of that conversation. You heard about on November 29th, there's a search for antifreeze. And then on November 30th, Julie was at karate practice and talked with Laura Koster again. This is the week that Douglas was starting full-time daycare. And Julie said she'd be going to see a doctor and be treated for depression. That she was going to see a doctor that week and be treated for depression. And then she said she wasn't going to be at karate for the next few days or at the next time. She said Laura wouldn't be seeing her for a few days. Laura described her as unusually emotive, that Julie Jensen hugged her and it was like a goodbye. And then Dr. Borman saw her on December 1st, 1998. He fit her in. She was alone at that appointment. Dr. Borman explained that Julie really didn't want to be labeled as crazy. She was miserable. She was depressed. She had decreased appetite. She had lost nearly 7% of her body weight from the previous visit. She denied any issues of domestic violence. She was distraught and in tears. She declined counseling. She denied being suicidal. She denied being homicidal. Dr. Borman had never seen her like this. On December 2nd, Mark Jensen came and expressed his concern about Julie's sleep issues, and Dr. Borman gave him a prescription for some Ambien. Now, the prosecution seems incredulous that Dr. West thought that the prescription of Ambien was not based solely on the word of Mark Jensen. She opined it was necessarily filtered through the information from Julie Jensen the day before and previous visits which suggested major depression. I mean, we can look to the September visit where being tired, fatigue was noted. I want to talk about Julie Jensen's perceptions of reality. And I want to consider the wildly inconsistent statements of her. To Therese DeFazio, Mark wouldn't let her get a job. He was controlling. To the Voights, Mark is pushing her to get a job, and she doesn't want to. To Ann Lynch, she has to get a job because her marriage is in the toilet. To Laura Shore, she was actually offered a job and had a start date when she hadn't been offered a job and didn't have a start date. To Therese DeFazio, Mark always turned off the computer or covered it quickly. To the Voights, she'd walk past the computer screen and see poison on the screen. Mark would leave for work, and on the computer screen was a website for poison. I mean, I want to go through all of these, but on that one, right, like we heard about dial-up internet, and we heard about when these searches were. And so was the computer just logged on onto this website for 9-10 hours? To Ann Lynch, she said nothing about the computer. To Therese DeFazio, she wanted to put Douglas in all-day school, which is a special program for normal kids to mentor kids with special needs. To the Voights, Mark is making her put Douglas in daycare and she doesn't want to. To Ann Lynch, she was upset and crying about needing to put Douglas in daycare full time and wanted to know if they had space. All of these statements are basically contemporaneous with each other. That Post-it note that we keep hearing about, where did it go? Julie was the one that took a picture of it. In the moment, the people that she showed it to, the people that knew Julie Jensen, who knew the context, who knew what her complaints and concerns were, they looked at that Post-it note, and how did they react? They thought it meant nothing. Think about some of Ted Voight's testimony in this case. Evidently, he thought that Mark Jensen had killed Julie Jensen. And then when he was asked to describe that office, he didn't recognize it. I don't know if you remember this from the video. He didn't recognize it because when he had been in that office, later, things had been moved around. He was in that office after Julie Jensen had died, sitting there with Mark while Mark was helping him with stocks. So this neighbor who thinks that Mark Jensen was out to get Julie Jensen is then over there getting stock trading help from Mark Jensen in that office. You know, the thing about that, leaving the computer on so that when Julie would be vacuuming or walk by and she would see what was on and the door would be 3/4 closed. We saw a picture of that room, and we talked about this, I think it was when Detective Ratzberg was testifying about the scene photos. And we saw a picture of that room and the location of the computer and where the door was and how the door closed. And if that door was 3/4 closed, no one would be able to see the computer screen. That list, that Post-it note, that's such a big deal. It says DeFazio, Terry on it. Well, how does that play? How does Therese DeFazio play into this scheme of Mark Jensen's? It said Nicotrol. Didn't the state say that that was prescribed to Mark? Is this like all the other lists that got talked about, and what does this mean? What do these letters mean? And then we learned from Dave Naring that they were stock symbols. And here we are 25 years later trying to assign meaning to these little nuggets of information when we know the meaning of these nuggets of information because the people who lived in that moment and knew her the best looked at it and we know how they reacted to it. I want to talk about the offers of help that Julie Jensen received and declined. Ted Voigt offered to give Julie money and she could use his cabin, and Julie declined the offer. Therese DeFazio offered to set up Julie with a women's shelter. Julie declined and said her neighbor was working on getting her a place. But when that happened, she had already declined Ted Voigt's offer. Laura Koster offered to give Julie a place to stay with the boys and not allow Mark at the residence if Julie was actually concerned. She also said, your brother lives a couple of miles away. Take the checkbook and the boys and leave. Julie didn't call her brother. She didn't leave with the boys. She didn't take the money. She had her own car. Officer Kosman said, if this is real, go to the shelter if your life is in danger. She declined. You know, the state's wrong. We aren't suggesting that Julie Jensen was framing Mark Jensen with these statements about fear. These were paranoid misperceptions of reality. One of the things that Dr. West explained to us yesterday is she said that a person at high risk of suicide creates space for themselves to be able to follow through. She said she sees that in suicide cases. Julie Jensen created that space for herself. Her conversation with her best friend, Laura Koster, on November 30th. You're not going to see me for a few days. On December 2nd, she wrote the note to Therese DeFazio that she wouldn't be seeing her. Her conversation with Margaret Voigt on December 2nd. You won't be seeing me. Don't worry. I'm fine. I want to take a look at the last 2 weeks of her December calendar. Well, actually, if you go back, these are some calendar pages in November. And they're full of things. And then when we go to some pages in December, there's nothing. Julie Jensen was aware of what she was doing. She was creating space for herself, like Dr. West described. Now, the science, we didn't learn about the science and how ethylene glycol poisoning works from the prosecution. We learned that from Dr. Hale. And the blood levels tell us nothing about whether something is a homicide or a suicide. Dr. Mainland thought it's a homicide because it's hard to get someone to drink a fatal dose, and so it would have to be multiple lower doses. But then we learned that this little NyQuil shot was all that would be needed for it to be a fatal dose. And then there's nothing in Julie Jensen's toxicology that suggests this was anything more than a single fatal dose on the night of December 1st to the early morning of December 2nd. Now, the person educated in pharmacology who Laura Koster went to with questions about medicine, she didn't need Mark to explain side effects of Paxil or paroxetine. We learned about a person's mental faculties and their abilities while processing ethylene glycol. We learned about what Julie Jensen The person educated in pharmacology informed her neighbor on December 2nd that she was fine. It was her new meds. And Mark was going to the doctor for her. She knew that Mark Jensen was going to Dr. Borman's for her. Now, that doesn't really fit with this idea that he's got this scheme and he's involuntarily administering medications and she doesn't know what they're for, and he's forcing her to take these things and he's drugging her against her will. We learned about the high likelihood that the half a teaspoon remnant of ethylene glycol in her stomach was just that, a remnant of a prior dose. We also heard from Dr. Mainland's extraordinarily questionable study. But the blood levels tell you nothing. But you know what was interesting about her study? Is that almost every ethylene glycol case that she could find was a suicide. That's sad, and it's what happened here. Mark Jensen did not kill his wife. We know this from the science. We know this from what Julie Jensen told her physician. We know this from when Julie Jensen said goodbye to Laura Koster. We know this from the description of David Jensen and how distraught and grief-stricken his dad was. Now, the prosecution has one more chance to get up for an argument. They'll have their rebuttal argument. I'm not going to have a chance to answer that. So this will be the last you hear from me in this case. Please think about the questions we've asked of the witnesses in this case. Please think about what my answer would be to the state's argument. This case is tragic on so many levels. There's depression, there's suicide, and there's an innocent man on trial for homicide. Mark Jensen is innocent, and we ask you to return a verdict of not guilty.
All right, ladies and gentlemen, we still have the rebuttal, but take your lunch break. How about 1:45? Is that good? All right. Please don't talk about the case. We'll see you back at 1:45.
Well. What a closing argument. Long Crime fucking hates me right now. I'm getting attacked hard as fuck. I'm over on Long Crimes saying hashtag free Mark. Dude, they put a poll up, bro. Fucking 88%. There's 4,295 votes, 4,299, 4,300. 88% say guilty, 6% not guilty, 6% hung jury. The fuck? That's what I'm saying. Dude, people are so fucking dumb, dude. So we did a poll on ours. Did the state prove their case? 76% said no, 15% said yes, 7% said undecided. See, this is the thing, is that all of you yeses and undecideds are a bunch of chicken shits. And you don't chat, and you won't take me up on my offer to come talk to us. Chickens. So if anybody wants to come on, we can do it. We can do it, folks. We can do it. Oops, shut up. Anybody? Anybody? It'd be fun if you guys want to come on. I'll send you a link. We can all chat. If we can do that in the thing. Otherwise, you know, I'm just gonna play some videos. And I'm gonna bask in my glory of how braggadocious I'm being over here right now. I'm getting a little cocky over here. You guys wanna hear my email? Let me respond to this one. So I was typing in my on the YouTube chat. Bro, play the videos because nobody's going to debate you. I know they won't. I'm too good, bro. For real. They said everything I said. Get the fuck out of here. He copied me, bro. Copied me. What the fuck? So anyway, in YouTube, I told you guys I have to go pick up open records today. And we were trying to figure out like when I was coming and all that, whatever, and we got that figured out. So when we send the open records request, we put it all nice and formal, whatever, and then I sign it. Kevin Glowicki, Never Stop Media, investigative journalist, put the website. Generally I put my phone number. Sometimes, not always, but the email, the website, whatever. So I was trying to be able to go over the weekend, whatever. And so I tell them, I sent an email today and I said, hey, I'll be stopping by between this time and this time. This is what she says to me. So I was telling my YouTube chat, I said, I just shut down this fucking police department. She ain't got shit to say right now. And she's like Johnny on the fucking spot with the emails. She says, sounds good. Please bring your ID. I responded, is there a reason an ID is required when Wisconsin open records law expressly states that a requester is not required to ID? I've notated the media outlet I own/represent via the open records request. She says, we want to make sure we are providing the records to the person who requested. So this is a violation of Wisconsin open records law. And they do this because sometimes they'll try to make a copy of your ID. They want to know, this is why, like, most times there's no reasons why these things can't be emailed. You can't give a credit card over the phone. There's no reason for some of this shit. But when it comes to law enforcement, they want to fucking see who you are, especially when there's certain types of, cases and records and things that you're looking up. And God forbid you start investigating a police department. They really want to fucking know who you are. So when this shit happens, when I get these emails about, make sure you bring your ID, I go in with my body cam on and I make sure they see the camera. And then when they try to ID me at the counter, I state specifically what I'm about to read to you, and I have my camera on. And I let them know that the camera is on and that they're violating Wisconsin open records law. They can get fined for this. They can get in trouble for this. So I responded back and I said, respectfully, I'd prefer to reserve my right under Wisconsin open records law under statute 19.35 subsection 1I, except as authorized under this paragraph, no request under paragraph subsections A and B to F may be refused because the person making the request is unwilling to be identified or to state the purpose of the request. except as authorized under this paragraph. No request under paragraph subsections A to F may be refused because the request is received by mail, unless prepayment of a fee is required under subsection 3F. A requester may be required to show acceptable identification when the requested record, this is key, is kept at a private residence. It's not, because we're going to a police department, or whenever security reasons or federal law or regulations so require. No federal law for what I'm asking for. There's no security breaches and issues for what I'm asking for. So I don't have to ID. And the fucking law in Wisconsin says I don't. I also don't have to state the purpose of what the fuck I want the records for. So then I wrote, not trying to be difficult, but Never Stop Media focuses on constitutional rights, and we are very well versed in open records laws, not only in the state of Wisconsin, but other states throughout the country. Furthermore, I have identified myself and my media outlet in the open records request that was emailed. No other person or entity would have knowledge of this request other than myself or a representative of Never Stop Media. I have also made it clear via our email that myself, owner of Never Stop Media, would be arriving between a designated time to obtain the records requested. Lastly, failing to identify does not fall under any of the exceptions listed in 19.35. Thank you for your cooperation in this matter and following the guidelines specified under Wisconsin law. Kevin. She didn't respond to that one. That's why it's important, people. That's why it's important to know your fucking rights. So all of you, why don't you just comply? Fuck you. That's why. I don't have to. Just comply. Just comply. Follow what they say. Just comply. We ain't complying with shit unless it's fucking lawful. Get the fuck out of here. Dude, and I have been so well versed on open records laws, it's not even fucking funny. Just comply, Kevin. I want your ID, sweet baby boy. Get the fuck out of here, dude. All right, nobody wants to debate me. We're going to play boring videos that I like. I think there's some spots in here that I had to remove the music because we got whacked on some copyright shit. All right, good morning, beautiful people. We survived day one this morning. So we got to camp last night and had to set up kind of quickly. We were kind of moving a little slow, so I didn't film anything. Pretty sore, pretty beaten up. It's a little chilly last night. It's a little cold this morning. Making our morning coffee. So we are at just before Ramona Falls right now. So I played you guys day one. I never played day two because I had music back here that I wasn't supposed to. So I had to remove the music. Then we played day 3 and 4, but with no volume. At one of these campsites too. This is what I do when I'm not busting open trial cases. Cloud cap. Ripping apart government entities. This saddle campground there is 27.5, so 17.9 miles ahead. Otherwise, there is. I will fast forward a little bit because this part's boring. So there's some. We're just going over how fucking far we need to hike. that was super skeevy. But yeah, I went down a little ways and up, and I found this huge campsite, and it would have been perfect. So I'll show you guys the tents here, and then take a little walk.
With CarMax, you get pre-qualified in
Shut
no
up.
time at all.
Oh, I hate commercials. See, we can't even afford to pay for YouTube to get rid of my own goddamn commercials. So gross. All right, so there's my Lanshin 2. And I got like serious pack explosion going on in the middle of it. Left a couple of steaks at home, which was kind of a mistake. And then the ground is not very solid, so I had to use some rocks to block those steaks in a couple different spots. And then Justin has his stuff on the outside of the tent, and he's using a Mountain Hardware one-person tent. Yeah, so kind of came in over here, and it's cool because there's water right here. It's a little creek, so we got to fill up water right down there, which was super convenient, so easy. It was nice. And then there's another campground, little camp spot right there. There's somebody. Did you go up it?
Yeah, there's actually people
On the far side.
on the far.
Yeah, but it's kind of big.
Yeah.
So yeah, it's our little camp spot. So just gonna finish coffee. You eating breakfast today, or
I should, yeah. Didn't get much last night. I could not fucking stomach that
you
beef
couldn't eat
stroganoff. I don't know why.
Really?
It wasn't the beef stroganoff. I just wasn't hungry.
just
My
your stomach?
my stomach was fucking me.
How's your body feel? Are you
Tired.
sore?
Yeah, I just feel really tired though. Like, I feel like I fucking need to lay down.
Yeah, it was grueling. It was a grueling first day. My muscles are definitely sore. Shoulders are sore. It's gonna be fun putting that pack on this morning. We can do it. We can push on. All right, well, hopefully Mike is going. I don't know. Boss, you remember my gimbal that I had? I was always having problems with it. I brought it on this trip, and it was twacking out during this. I ended up fucking throwing that thing out during this. I got so pissed at it, bro, because like I had some good footage right before this, and the gimbal just was twacking. I fucking slammed it on the ground. I was so angry.
So it's 10 a.m. Hoping to get out by 9.
I was hoping to be out by 7.
That's not good. I don't know. There's no way we could get out by 7 because it's fucking pitch dark until 7. Unless we're like making breakfast and packing up. Man, my stomach is not right, dude.
All right, well, we had to pause. Gimbal twacked out on me already within the first 5 minutes. So, like I said, the thing got a lot of water damage. Filming a bunch of stuff over the last year and a half. And yeah, I was debating whether or not to bring it to begin with. And I shouldn't have. I brought it last minute because I wanted to set it up on like the monopod, kind of do some imitation drone style shots. I knew better than to bring it. So it's like an extra pound that I'm carrying on my back. But kind of a good thing that happened anyway, because it made us stop and then kind of realize we weren't following the trail the right way. So we kind of jumped off trail coming to this campsite, and we kind of forgot that this morning. So we got to backtrack, not far, a couple 100 feet, and then jump back on trail that way. So, you know, kind of a good thing that we had a tech issue. But anyway, onward bound. Super late start this morning. So that part sucks. But whatever. It is what it is. We're trying to push out 12.5 today. It's gonna be rough. So JK is kind of a beginner hiker. First time ever doing something like this. So he's not used to it. 9.6. Struggle for both of us. But he said he was definitely struggling. I thought he did fucking great though. But whatever. Anyway. All right, here we go.
Once you meet with a TurboTax expert who will do your taxes for you, you're free to do.
I would have played the actual video file, but again, I have music. There's actually music in this part, but I had to take it out. So I can't play the actual video file. Otherwise, I get whacked on my live stream right now. And all the editing was done on my old ass dinosaur computer. Now with the new laptop, I can finally again edit shit how I used to edit videos. I'm so excited. Anybody want to debate me yet? Anybody? Undecideds? Not guilties? Anybody want to come on the stream and chit chat? Chew the breeze? Chew the fat? Shoot the shit? Nobody? Okay. Hiking videos it is. Maya, you should come join us on YouTube. YouTube chat has been pretty rowdy. Boss says, I think everyone went to lunch. Yeah, everyone except me. A lot of shit.
Yeah, that's cool.
Yeah. So all right before this part, there's a whole bunch of shit that was happening in the background that I didn't film, and you'll find out in a little bit why. All right. Well, this might be a little shaky video, but had a little emergency on the trail. I'm running solo right now. JK had to bail. So, kind of last night, when we were getting probably, about 2 miles away from camp, he was kind of struggling. Kind of chalked it up to, just doing 9.6. This is his first big hike. So it was a long day, kind of grueling. We were just beat. The trail kind of kicked my ass yesterday too. And this morning, we woke up probably around 7, I want to say it was. And very, very slow moving. He wasn't doing good. Kind of coughing a lot, breathing weird. And we didn't leave camp until 10, so same kind of start time that we had yesterday. So I was kind of like, man, dude, I really kind of wanted to be out of camp by 7, 8 at the absolute latest, because we had to crush 12.5 today. So I was like, shit, this is a really long day. And, it gets dark, sunset at 7, super dark up here, by 8. So I'm like, all right, we're not going to be able to do 12.5. It's not going to happen. And finally left camp about 10, a couple minutes after. And I don't know, we got 100 feet down the trail. And right where I said, oh, the gimbal's freaking out. And we kind of veered off trail anyway, the wrong way. Which wasn't bad. I mean, it was, a couple 100 feet, no big deal. But, yeah. And then when we kind of bounced back on the right trail, he's like, dude, I got to stop. I'm sorry. And dropped the pack. It's just hacking. Just not doing good. Did not look good. And ended up throwing up. Kind of gave it a little bit. I was like, all right, just fucking struggling, dude, but I don't know if I can do this. So, I'm like, all right, well, don't think about it. Maybe you're just sore, beat up from yesterday. Don't focus on 12.5. If we got to stop early, we will. Don't worry, Put the backpack on, walked about 10 feet, literally dropped the pack. He's like, I can't. Fucking drop the pack. Threw up again. Really did not look good. And then, tried that one more time. Put the pack back on. 10 feet later, dropped it again. So we get to the falls. We seen a sign for the parking lot. He was trying to press on. We get to the falls, which is 0.3 from where we camped, and just immediate, drop the pack, puked a whole bunch. Shut up. It's so funny, dude. My hiking videos, there's regular commercials, and then my other types of videos that we put on the channel are all political ads. It's really fucked.
Protein.
And he was like, dude, that's it. I'm done. I gotta bail. I can't do this. So, we're kind of going through what are the symptoms? What's going on? And as soon as he said my equilibrium is off, I immediately knew it was elevation issues. So he was suffering from altitude sickness. And so So this part here, this is like video of us. I had to walk him back down this fucking mountain to the parking lot and begging fucking hikers to take him down the mountain so we could get to a phone because we had no cell service and neither one of us had a GPS system. So there's like, I'm playing a little bit of background of shit we had to walk through to get him down this mountain. And he's in like stage 2 of altitude sickness right now. So he's not fucking good. And this is not a very smart thing to be doing. And then I had to walk past all this shit by myself again. So just not good at all. So, you know, I mean, he felt bad, right? Like, he didn't want to let me down. He really wanted to do this trail with me. But, you know, at that point, it's about safety. Like, no trail is worth your health. And he, like, went from stage 1 to stage 2 of altitude sickness very, very quick. And going further in that, like, you start having some organ issues. And then after that, it's like death. So it was bad. It was not good at all. I keep looking behind me because there's mountain lions over here, and I'm by myself now. So it's I really wasn't worried about animals being with another person, but now I'm a little worried. But I don't know. I guess if they didn't get me in Cali, hopefully we'll be all right. But you know, they are around. So yeah, so we ended up going back to the sign that we saw for the parking lot at Ramona Falls. And I'm not sure the distance, but it's around 4 miles from where we were to the parking lot. So I hiked down with him down that. That was a little grueling because it was a lot of sun exposure. So that part sucked. We had to cross the river again. And then I dropped a lot of weight out of my bag. So I ended up giving him a bunch of stuff. Still heavy. I wish I could drop more. But yeah, and then just asking like everybody that was leaving if they would be cool enough to like give him a ride down to where he could get service. So he could text, you know, his family, and nobody wanted to help. So, you know, we found a couple people that were cool with like sending a text message for him. So we gave the number out to a couple people, and then finally we found somebody that was willing to take him down to where, you know, somewhere relatively safe where he would have cell service, be able to text his family and just kind of wait for them to pick him up. He was feeling better because like we kind of went down a little bit in elevation. So he was feeling a little bit better. Not as fucked up as he looked when we were by Ramona. So yeah, I ended up like shedding a bunch of weight, some shit that I just kind of only brought just because like it was going to be him and I, and we were supposed to be kind of spending like a decent amount of time at camp, which didn't happen, and I don't think it would have. It was taking us a long time to hike. So yeah, so then we kind of parted ways. Somebody gave him a ride down. I still have no cell service. And kind of hoping that changes. But then I had to hike back. So roughly 4-ish miles back, the same route that we took to get to the parking lot. So I don't know. I'm guessing between 6 and 8 miles I've already had to hike to this parking lot and then back to Ramona Falls. And it's already after 4 p.m. So the day is shot. We really needed to do 12.5 today. The nearest campground that's showing on the map is 8.3. So I am trying to crush 8.3 miles in the next 3 hours, which is going to be a little tough trying to film because I want to film because I haven't seen this part of the trail yet. And for those of you not familiar, you probably haven't either. So I want to film, which slows me down. But at the same time, we're kind of at a safety issue where because there are cats and potentially black bear, I really just want to get to camp. I do not want to night hike this trail at all because there's really steep cliffs. This is probably not the trail to be night hiking. I don't do well in night hikes anyway, but this is probably not the safest one to do that. So I'm not sure exactly how much I'm going to film just because I really got to hike. I got to go. So it's kind of, I don't know, probably see in the background the trees moving sort of fast. And the camera's not as steady, even though it's always shaky, but not as steady as normal because I'm trying to go. So, haven't eaten lunch. I just hit a couple of bars and some energy chews. Couple liters of water. I was sweating my ass off coming back from that parking lot. I lost a lot of water from that. That's the most that I was soaked. So I don't know. We'll see. But it's been good so far. It sucks that he had to bail. It's kind of our bro kind of hangout. So I got to try to stick to the schedule as much as possible. Tomorrow I'll have to crush more miles so I can kind of stay on schedule for the last day. And ideally, still kind of do our little celebratory brunch at the Timberline Lodge. So as long as I can get to camp tonight, which will be 4 miles short of where I want it to be, and then make up lost time leaving super early tomorrow morning and just hike all day, 12 hours, then I should be on par for what I wanted to do the last day. Because the last day is supposed to suck. So I'll have to make up more time tomorrow, but whatever. Anyway, you know me, crushing miles. Here we go. I'm beat. All right, well, let me fill you guys in. So, obviously, we had JK had to bail. I ended up coming back, kind of crushed some decent miles coming back from the parking lot. Made it back to Ramona Falls and started hiking, and the trail splits. Read the sign wrong, like a moron, because I'm in a hurry now, and I'm panicked because I have to crush 8.3 miles to get to the nearest campsite, and I'm not paying attention. I'm not looking at the Far Out app, so I just went. So then I recorded the part explaining to you guys about what happened with JK. And I ended up going 1.5 miles down the trail. After I was done recording, I looked at the Far Out app just to see, I felt like I was kind of crushing some miles. I was at a pretty good pace. And I'm 1.5 miles off trail on some other random trail. So I'm like, God damn it. I'm looking at the time. It's already 5 o'clock. So it's like I've just wasted all this time now. The whole day, it's fucked, obviously. And now I'm in a position where I'm like, shit, I need to think about my safety. There's no way I'm gonna crush that. Still carrying the weight with the camera gear and shit. Maybe if I dropped those 8 pounds, I might have been all right. Probably would have had a 25-pound bag, and I'm still heavy with the camera gear and stuff. So I'm like, all right, well, I guess I'll go back to where we camped last night. I don't know what else to do. The part of the trail that I was on, because it's not part of the Timberline Trail, and that's the trail I paid for, I can't see any waypoints that are on that trail. So I can't see if there's a campsite, 3 miles up ahead or any of that. I cannot get any of my other apps to work because there's no service. So, and even on the Far Out app, I'm using the offline version because I have no service. So I can't even purchase the trail that I'm currently on. So anyway, so I get back and I find out that there is, I figure out where I got to go. I'm like, okay, up this trail. And there's a yellow tag sign that it's temporarily closed because of downed trees and landslides. So I'm like, you got to be fucking kidding me right now. So I don't know. It said, there's a detour at a different trail. I don't know if that's on the trail that I was walking originally in the wrong direction. If there's signage further up that detours you back. I do know that from looking at that off trail that I was on, so it goes away from the mountain, looks like a lot of decline, which should be fine, should be able to crush some speed there. It almost looks like a loop, and it cuts back with the timberline. So that part I know. So I'm like, okay, I feel a little bit better about that. But I don't know when it cuts back, I don't know if that's closed, where I would end up catching the timberline again. And if that's the case, I don't know what the fuck to do. So, this is a grueling trail to begin with. You know what I mean? Like, it's not easy. And there are serious fucking dangers. That's why, JK was pretty gutted that he had to bail, and he kind of felt like he was letting me down. He really wanted to do the trail. And it was just safety first. You know what I mean? Over stupid miles. Yeah, this is cool, man. And it's the cool bucket list and, chalk it off the list. But when it comes to your safety, regardless of, whatever activity you're doing, safety is always the number one priority. And we had gone through, prior to leaving, we went through some safety things. I was, sketched about that Sandy River. And you guys saw, in the last video, I was super hesitant. You saw me kind of go, and then I stopped again. That river skeeved me out. That section of, the trail where we were on that cliff, and it was, 10 inches wide. Honestly, I braved that out for the camera. If I'm going to be completely honest, I braved that out for the camera so you guys could see that view. But I was super, super sketched out by that. I did not like that. I was very uncomfortable with that shit. And, and then seeing JK with what he was going through, I was like, man, and we talked about that. We talked about altitude sickness, if you're feeling some kind of way, either one of us, you got to tell the other person. You have to. Don't try to fucking gut through it and you end up falling out. So, we went through all these different areas that, of the trail that seemed a little sketchy, and some safety stuff, looking out for each other, taking breaks when somebody needs to take a break, So, and coming back from the parking lot with all that sun exposure, even going to the parking lot, I was soaked, and I didn't sweat like that yesterday. But coming back from the parking lot, you know, I was soaked again, and like wearing my hat, like there was dripping sweat from the bill, like the whole hat was just soaked. This thing, you know, I ended up having to put this on. This thing's soaked, but yeah, and I was like chugging water. So I was like, man, fuck. And my breathing, like yesterday, I was breathing fine. Coming back from the parking lot back to Ramona, I was like, I was breathing all fucking crazy. And like, I kind of got a little nervous that, like, shit, am I like getting altitude sickness now? Like, because I mean, like, we were going all downhill to the parking lot, and now I have to do this massive fucking incline coming back to where we started at. So I got a little nervous there. But yeah, I mean, you know, I took a decent break at Ramona because I'd already just hiked, you know, essentially 8 miles. So I'm like, okay, you know, and our goal was 12.5 today. So if we were actually hiking, we would have only had, you know, 4 or 5 miles to go. You know, the day would have been like, you know, half over. So, you know, and we probably could have pushed it. We could have made it. And by the time I did the extra 1.5 miles down the wrong trail, which I'm going to end up now having to go do again tomorrow, and then the 1.5 miles back, that was 3 miles. And I'm just like, you know, it was already nearing 6 o'clock. And I'm like, there's no way I'm going to be able to crush 8.3, 8.6 in, you know, an hour and a half. It's kind of a bum day yesterday, obviously. Had a hard time sleeping. I was just kind of bummed, kind of in my own head, a little defeated. And then woke up super early this morning, probably about 5:30, and my body was so sore, like I could barely even move. So I was kind of getting a little nervous about that. I really thought that, like, I was going to end up having to quit. So started getting up, started packing up things, making breakfast. Got out of camp at 8:25 and started off on the trail. Bag feels better. I don't know if I just packed it different or it's the loss of a couple meals makes it, I don't know, but it feels better right now. The goal today is 22. The short-term goal, like, if I just can't do the 22, I gotta at least do 16. So yeah, a little kind of anxiety coming up to that tree again where you know, the trail splits off, where there's the closure. And I found 3 hikers that were just literally right in front of me, stopped at the tree. I guess they had talked to a ranger, and the ranger said the landslide element is fine now, but there's still a lot of blowdowns. So like, if you're fine climbing up and over and under trees and whatever, like, you'll be all right. They were taking the detour, so it's kind of like, hey, do you mind if I just kind of hike with you? So they were like, yeah. So they're behind me a little bit. You know, my goal is to hit 22. They're stopping at 16. So I got you know, a few more miles than they do. But yeah, so apparently where this detour trail takes off and then re-meets with the timberline, it is open. So that's good. Same amount of mileage though. I was kind of hoping that it would have like cut a few miles out of the trip, but you know, just for time wise, it's because I got a flight back to Wisconsin in 2 days. So, but not that lucky. So whatever. But yeah, I got to crush 22, man. I'm feeling pretty good. Body feels good right now. I don't know why I was so sore this morning, but yeah. So we'll film a little bit. Probably not much because I got to crush so many miles. And I'm like really cruising today. But here we go. Let's crush it. Another part I had to drop the music out of. It's kind of irritating. I don't remember how long it is without sound. We'll do this. We'll play our own music since I had to delete the music out of here. Irritating.
Showing up on the first page of Google might not be the best for everyone. Showing up on the first page of Google?
Shut up.
Showing up.
At least I, got that kind of fear of the unknown kind of out of the way. Talking to those hikers. Just kind of reassuring that, this is the right path and stuff. So, all right, here we go. We're going to be coming up on a sign. I want to say we go off to the right looking at the map, but I get lost always. All right, yeah, so PCT, sweet. So we get to meet up with that again. I'm just going to pull out my phone and look at my direction, make sure I am actually going the right way. We'll see. Yeah, all right, well, they got serious jokes. So I got to cross this. It looks like crossing over at that bridge or the log. So some of you that are watching, you're like, why are you freaking out over these tiny little rivers? I'm deathly afraid of water. That's why. I'm terrified. I almost drowned as a kid, and then I did actually drown as a teenager. I had to be rescued and saved, kind of brought back. So, and I have no traction on my shoes on this trip. I thought there was enough tread that I could just kill the shoes and then buy a new pair when I got home. And walking over all these logs and things. So that's why you hear me in these videos, like freaking out about water and being real nervous. I won't even go in a pool. That's how terrified of water I am.
Because when I got across, I noticed it shut off. So it means I'm running low on my portable battery. So it means I'm going to be down 2 batteries just from all this filming. And the body cam doesn't stay charged, so it's got to constantly be plugged in. So it's a battery drainer. I'm still going up. This is so gnarly. I don't know if that really does justice. Sort of flattened out a little bit, and we're going right back up. It's not a good not a good way to start the day, especially like this. I gotta see on the map if I can figure out what exactly the elevation is, because I didn't technically purchase this trail, so I'm not sure if it shows. I think it shows a little bit, but not detailed like I could get on the actual Timberline map that I purchased. I don't know if you guys can really see how that's just a portion of what I've climbed. 22 is going to be hard today, but we got to do it. It's still going. It doesn't stop. JK, when you see this part, you're not gonna like it. This is a lot. Oh shit. Fuck. So I mean, it's just a lot of switchbacks. And it's just long section of switchbacks. And you're still climbing. It's a ridiculous amount of elevation.
We're about to revisit an uncomfortable conversation.
The only thing that's sort of nice is the fact that you're in so much tree cover and it's cool down here or up here. And I would assume higher in elevation. I don't want to stay by these rocks too long. That looks like that could be a nasty landslide.
Oh, shit. Not getting water out of that. That's for sure. My breathing here, just so you guys know, like background. So I have a respiratory issue, and then I smoke on top of it, which is not good. But I was actually getting a little bit of altitude sickness from this too. Never ending up. Oh, fuck. All right, here we go. We got to keep going. Oh, well, got a water source if I needed one. Oh. You know, one of the parts that sucks is the fact that there's no tread on my shoes. So some of these inclines get a little slippery. All right, so another switchback. It just never ends. And you kind of see the trail. So it's just like you keep going up. And it looks like it's about 1,200 feet of elevation. So that kind of sucks. I'm just sweating. Please do not shortcut the switchbacks. Yeah, don't worry. That looks harder anyway. Whew. All right, so it looks like on the map, if this is tracking right, because you know I'm not on the right trail, but it looks like 9.6 miles ahead to Cloud Cap. So if this is all sort of accurate, then it's 16 miles. So I'm halfway. It's 10:30, so hour and a half of doing that nonsense. When I get to Cloud Cap, I'll be at 5,880 feet. And we'll have ascended just over 2,800 feet. So if we can hit Cloud Cap in the next couple hours, then we should be able to pull the 22. So it should be all right. So we'll see. See what happens. Taking a break. All right. Well, back at the timberline. So officially on trail again. Oh shit. Do I have cell service? Ooh. Please, please, please. I have service. Perfect. Well, let's pause this. Okay, text went through. So first time I've been able to text JK to let him know I'm still alive. I got a text from him that popped up. That's what that was. So sounds like he's okay. So yeah. So all right. So we took the detour. So that's, you know, crushed about 5 miles pretty quick. So that's good. If I can keep this pace, I'm just around 9 miles to Cloud Cap now. I broke off with the group. There's another guy doing the timberline who was at this like kind of trailhead. I should have filmed all that, but I didn't. So they're taking this other kind of detour that goes through Bald Mountain. So you see the Timberline Trail from that. So it takes a little longer, but it's supposed to be like better scenic views. And unfortunately, as much as I would have loved to have done that and continued hiking on with them, I cannot afford to take extra mileage. So, you know, oh shit, I don't know if you guys can see all that. Hell yeah, dude. Oh my God. So, I mean, this is the cool thing. So like Jesus God almighty, look at they were hiking a really good pace. So that was kind of helping me kind of press on, which was good. And we just kind of kept passing each other back and forth, passing each other. So would have been nice to have stayed with them to kind of keep that pace going. But, you know, at the same time, running solo like this, I just kind of feel like I'm relying solely on me and not like somebody else. So it's all good. But we're going to get there. We got to get crushing. So I'm not filming as much today. I'm sorry, guys. I really got to hit this out. So I'll film, you know, sporadically as I can. I just want to make sure that I hit a certain amount of miles so that I'm on par with my last day here. So here we go. So this is what I've run into now. Incline with a root staircase. Every time you think you're making good time, the mountain says, nope, we're going to slow you down.
What do you want? You're going to be my eyes and ears. Annie. Say hi.
Oh, wow. Oh, unreal. All right, so I'm only like 0.2 on the McNeil Point shelter. So I'm at McNeil Point right now. So the shelter is first stop for a break. I wish you guys were here. I mean, I can't really see on the phone right now because of the sun's in my eyeballs, but I'm really praying to God that this comes through on the camera. This is amazing. So I'm over 5,000 feet of elevation right now. Still have another 880 to go from here to Cloud Cap. Oh, man. Dude, if I could have just like hung a hammock here. Jesus. Heaven right there. That's majestic. All right. Well, just got done with a little break. So I'm up by McNeil Point. So finished off my 1 liter of water, and I've been doing pretty good not tapping into the 2nd liter. It's been some pretty decent water sources. So I've always had like that 2nd liter for food, but water sources in this area are a little bit more scarce. So I had to tap into the 2nd liter. So I put like an energy multiplier, liquid IV, in this one. And then had a little honey stinger waffle with some peanut butter. Just a little snack. I was going to tap into the granola, but I didn't want to take too long of a break. I have this damn uphill again. So, I don't know, we're like halfway. So I got some honey stinger energy chews. I'll probably start chewing on those soon. But yeah, got the mountain just to my right. It's gorgeous. So if I make it to exactly where I really, really, really want to make it, which is 25 miles, fuck, I'll be at 7,200 feet of elevation. And I think it's like I've ascended 3,900 feet. So this is the wrong day to be trying to pull out 25 miles. That's for damn sure. It's not the day for that. I really needed to do some miles yesterday because this is, I'm just going to be dead by the time I get to camp. That's all. But whatever, man. Oh, this is not fun right here. Anyway, I'm going to stop filming. I got to focus on this. This is pretty steep. So here we go. Crushing miles. Crushing miles.
Some families you're born into, some find each other in.
That butterfly that I filmed, I took a half-hour lunch break, and he sat on my bag for half an hour. At one point, he flew on my hand, but I couldn't get a shot of him. It's kind of cool. Court is still on lunch break, guys. Still on lunch break. I am paying attention. As much as I'd rather be on a trail right now, I am paying attention. So once I start seeing heads bobbing around, I'll switch back over. It'll be coming up shortly. Oh, shit. I don't like that. Mud and no traction on the old shoesies. Horrible. More incline. Come on, you're killing me. Oh, here we go. Well, maybe some wet feet on this one. Maybe. Oosh. And now I gotta climb up this. Okay. Sure, sounds good. Sounds good, Kevin. Brilliant idea. Okay. Yeah, all right. Well, we accomplished that. Minimal water on the old shoesies. Now we press on. I think I lost my green towel. I think it fell out of my pocket back there. Oh, shit! Oh, dude, I laugh every time. Every time I see this puppy. Shit, and 1 is 3. I'll tell you that. I just didn't see this at all and totally ate shit. You gotta be kidding me. It's like a little step up. I didn't see it because I'm filming like an idiot. I literally fell right on my face. I literally just completely ate shit. Fell right on my face. I'm covered in mud now. I'm filming and not paying attention. I didn't even see that there was, like, the trail just stopped because there was a little step up and I went right into it. And it's like knee level. All right, hang on. I'm coming back. I saw Grouchy McGroucheson's fucking head. Dude, that part makes me laugh hysterically every time I see it. I mean, it's the funniest shit ever. Dude, a lot of people that watch my videos, they're like, I'm so surprised you didn't edit that out. I'm like, nope, we're leaving that in 100%. We played, I did a blooper reel from this trip. We played the bloopers. That was funny. It was all my trips and falls, and that wasn't the first time I wiped out like that. All right, we are coming back. Last day before the jury gets this case. We're going to be coming up on the state's rebuttal. We do have a poll up on YouTube. If you'd like to participate in those types of things, you can come to our YouTube channel, which is Never.Stop.Voices on YouTube. Make sure you guys share the stream out, like the stream, follow all the platforms. If you like what we do here, there are some pinned links. Any and all appreciated donations are welcomed, and we love you for it.
Please rise for the jury.
I don't know. Defense looks pretty happy. Look pretty confident. If you're on YouTube, you may see some new links that are popping up. So one of my hiking sponsors is up there. And then we have the Never Stop Media sponsor, which is an apparel company where we make some t-shirts and hoodies with some outdoor style graphics on there. So by law, I have to tell you that is my company. Full disclosure. Another great way to support the platform and get something out of it for yourself besides the truth that we provide here. Some pretty cool things. So there are some links. On Facebook, you can find that on our page. It's in the pinned comments as well. Same as one of my hiking sponsors. We have a link to their gear, backpacks, all that fun jazz, tents.
All right, we're back on the record on Mark D. Jensen, 2002 CF 314. The appearances are the same. It is January 31st, 2023 in the afternoon. The jury has numbers and are seated different, and I will tell you why we're doing that later, but there is a reason for that. So with that, the state has to do their rebuttal. Anytime you're ready, Ms. McNeil. Oh, I'm sorry. Anytime you're ready, Mr. Jamboys. Thank you, Robert.
And thank you, ladies and gentlemen of the jury, for paying such careful attention to this trial. And here we are today, 24 years, 1 month, 28 days after Detective Paul Ratzberg was called to the scene of what the evidence shows was the homicide of Julie Jensen. Now, you know, last night in preparation for what I knew was going to be my rebuttal, I watched the opening statements. I watched them on YouTube of the opening statement by Carly McNeil and the opening statement by Mackenzie Renner. And then I just watched the closing argument by Mackenzie Renner and the closing argument by Jeremy Perry. And I was struck by this point in Mr. Perry's closing argument where he said, he didn't want you to be responding to emotional appeals that cloud the evidence. I wrote it down, just to make sure I got it right. And I'm wondering, what could he be talking about? I mean, I watched Mackenzie Renner's opening statement, and I just watched her closing argument, and it was not an emotional appeal to cloud the evidence. If anything, it was a very clear-cut, detailed, and I'd say somewhat dispassionate recitation of what the evidence was going to show in her opening statement and what it did show in her closing argument. And I was struck by the extraordinary similarity between her opening statement and her closing argument. In fact, I would say they were identical. And there's a reason for that. It's because in between the two was the evidence that was presented to all of you, and it was presented to you in exactly the way that Carly McNeil told you it would be presented to you, and it was presented to you in exactly the way she said it was presented to you in her closing argument. So if we're talking about emotional appeals, let's see, emotional appeals that cloud the evidence, the first thing that came to my mind was the defense opening statement. In fact, the opening lines by Mackenzie Renner, where she spoke of, and I can't quite emulate the tone of voice that she used, but it was like a broken tone of voice, like a distraught mess of a man, eyes red from crying, snot bubbling up from his grief, had trouble standing up. Well, I guess that was an emotional appeal, but it didn't cloud the evidence. It was just pure fiction, because you never heard any evidence like that, did you? I know you didn't. I was sitting here in the courtroom with you. There was no evidence of anything like that. In fact, they asked Dave, I forgot Dave's last name, but the paramedic who responded, who's now an assistant chief, and they asked him, well, did you know anything about defendant Mark Jensen? No, I just was going there to take care of the victim. And so he described to you the scene, the victim, her condition. There was no evidence at all of this, the opening couple of paragraphs in the defense opening statement. And there were other things in the defense opening statement that simply were never, there was no evidence presented to you. When they had the opportunity to present their evidence to you, they didn't present any evidence of any other person besides Mark Jensen and at one point, Laura Koster, speaking of Julie being suicidal. DeFazio said she was not suicidal. Dr. Borman said she was did not appear suicidal. She was distraught. She was upset. There was no testimony from any witness here that Julie Jensen, that if any other third-party lay witness had ever heard Julie Jensen talking about suicide. That was mentioned in their opening statement, but when they had the opportunity to prove that to you, to present evidence of that, they didn't, did they? And then they also, during the course of their part of the case, if there's something important that they want you to know, that's when they're supposed to bring it out. Now, in his closing argument, Mr. Renner referred to this as being, I'm sorry, Mr. Perry, not Mr. Renner. Mr. Perry referred to this home computer as the second home computer. Where did that come from? Another thing that was just made up out of whole cloth. They asked David Jensen, wasn't this the second home computer? He said, no, not that he remembered. There was simply no evidence of this being the second home computer. And remember, there was testimony about how common it was to have a home computer in a residence in 1998. It was very, very, very unusual. In fact, Detective Ratsberg said this is the first time they'd ever seized a computer from a residence in the course of an investigation. So the emotional appeal, I don't know, maybe he was thinking I was going to do it. Maybe he was talking about my cross-examination of these hired guns that the defense brought in. The $23,815 testimony from Dr. Lindsay Thomas. The $10,000 to $15,000 testimony from Dr. Stacy Hale. And I don't know, the $10,000 plus testimony from Dr. West. Because I did cross-examine those witnesses, and perhaps that's when he's talking about emotional. But you know, that was very directly connected to the evidence. Now, defense counsel also, in his closing argument, told you some things that the evidence just didn't support that proposition. Remember when he was talking to you about how the evidence showed that Mark Jensen could not possibly have been on the computer on December 2nd at 11:45 or 11:43 a.m. And I'll ask Ms. McNeil if she could pull that up. Not his argument. We're not pulling up Mr. Perry's argument. We're pulling up the evidence about the use of the computer on December 2nd. And that evidence, when you see it come up, is going to show that the internet was used on the Jensen home computer at something in the neighborhood of 11:45 a.m. on November 2nd. He said, well, that's not possible. It's not possible that he could have been using the computer 11:45 a.m. or at whatever time it was because, he was picking up the prescription. Well, the evidence also showed when he picked up the prescription, and it was at 11:13 a.m. So first of all, here's the internet usage, and you can see 8:14 a.m. to 8:49 a.m. Well, he was saying, at 8:14 a.m. to 8:49 a.m., he was taking Douglas to preschool. Well, that's not true. There's no evidence that he was taking Douglas to preschool at 8:14 to 8:49 a.m. And in fact, we know for a fact that he wasn't. You want to know how? We know that he was not taking Douglas to preschool at 8:14 to 8:49 a.m. because there he is on the computer at 8:14 to 8:49 a.m. And there's no evidence that Douglas was being transported to daycare at 8:14 to 8:49 a.m. other than what Mr. Perry said to you in his closing argument, and that's not evidence. Opening statements and closing arguments are not evidence, and I guess there's a good reason for that when you consider the opening statement by Mackenzie Renner when she's talking about the defendant's distraught condition on the morning or in the afternoon when law enforcement responded to the scene of Julie Jensen's murder. And then we can bring up, do you have the receipt or the record of the pickup of Ambien? It was 11:13 to 11:14 a.m. While she's looking for it, I can just tell you that's what it was, 11:13 to 11:14 a.m. Because I know the evidence in this case. Because it wasn't just Detective Ratsberg that responded on December 3rd, 1998. 24 years, 1 month, and 28 days ago. I was there too. You know, in his closing argument, Mr. Perry spent a good 40 to 50 minutes talking about Aaron Dillard and Ed Klug and talking about their credibility or his perception of their lack of credibility. But remember, when did they come into this case? In 2007. In 2007 is when Ed Klug and Aaron Dillard first came into this case. There's no indication the state had ever heard of either one of them before 2007. Yet when was this case issued? In March of 2002. So do you actually think the entire state's case hinges upon the testimony of two people we've never heard of, never seen? Obviously not. What do you suppose the evidence in this case actually does hinge upon? It hinges upon all this evidence that the defense counsel wants you to ignore. Now, there's been an unusual amount of discussion about penises, considering this is a homicide case. But you honestly think that we were talking about penises as a means by which to misdirect your attention away from the evil, unspeakably awful things that this man did to Julie Jensen? Do you really think that's the thing we wanted you to focus on? No. The reason that we talked about these penis photos and the astonishing collection and array of penis pictures on Mark Jensen's work computer that was recovered in 2002, it's not because we want to show you that he's got a strange and sick obsession with penises. It's because we wanted to show you that his strange and sick obsession with penises drove his behavior in the years of harassment of Julie Jensen. Now, think about what the defense theory of the case is here. That Perry Tarica, a man who you saw testify in this case, and a man who clearly loved Julie Jensen and described her to you as the finest, kindest woman he'd ever met. Now, did you get the impression that Perry Tarica's testimony was contrived? Or did you get the impression that Perry Tarica was telling you the God's honest truth about this woman that he loved? Do you honestly think, as you're sitting here right now, that any normally constituted human being, any normally constituted man, for 7 years after his girlfriend breaks up with him, for 7 years, he does hang-up call after hang-up call after hang-up call after hang-up call. For 7 years, he drops explicit pornographic photos off at the residence of Julie Jensen and at the office of Mark Jensen. Do you honestly believe that? That doesn't make any sense, does it? On the other hand, if you're dealing with a sadistic, narcissistic sociopath, which the evidence shows Mark Jensen is, then it makes perfect sense. Because you see, doing all these hang-up calls, the person who's doing it doesn't see the result. Dropping off these photos, the person that's receiving that, the person that's, Perry Tariq would not have seen the effect that it's having on Julie Jensen. The police saw it. The police saw how distraught and humiliated and embarrassed Julie Jensen was by this. And Mark Jensen saw it too. And Mark Jensen, when he'd get, as he put it, one of his few truthful statements to Detective Ratzberg, I mean, he told the truth in some instances to Detective Ratzberg. It was, as defense counsel referred to it, Mr. Perry referred to it in his closing argument. I wrote it down so I get it right. Blends facts with fiction. So who is blending facts with fiction? You know, part of this case, when you're looking at the way people were speaking about the case, and the way Mark Jensen was speaking about the case, you've got to look at the process in which this case unfolded. So when Mark Jensen was talking to Paul Ratzberg on April 21st, 1999, he'd never heard of Ed Klug. I mean, well, he'd heard of Ed Klug. He didn't know that we knew what Ed Klug was going to tell us. He didn't know that Ed Klug was going to come forward and tell the truth about that conversation on November 7th, 1998. So on April 21st, 1999, what Paul Ratzberg knew was pretty much only what Paul Ratzberg told him. Of course, in addition to what he did. So on April 21st, 1999, Mark Jensen knew how he killed Julie Jensen. And then he found out from Paul Ratzberg what we knew about how Julie Jensen died. So he was blending fact with fiction. He had to disclose what he knew that we were going to find out. David was there with him. So he had to disclose that David said, well, yeah, she couldn't get out of bed, or David said she couldn't talk. She could not talk that on the morning of December 3rd. So Mark Jensen was telling the truth about Julie Jensen's condition on the morning of December 3rd because he had to. He had to, because David was there with him. So he had to tell that much of the truth. And he did not know that we were going to later prove that at 9:42 a.m., somebody was on the computer looking up looking up antifreeze, ethylene glycol, and why isn't she dead yet? You know, what are the stages of ethylene glycol poisoning? He didn't know when he was talking to Paul Ratzberg on April 21st, 1999, that was information that Paul Ratzberg had already. And Paul Ratzberg didn't tell him that. So he told the truth. That on April 3rd, 1999, on December 3rd, 1998, on that morning, Julie couldn't get out of bed. He said it multiple times. Could you pull that up, Ms. McNeil? Answer, she couldn't get out of bed that morning. Answer, I mean, I'd hate to have it come to that, but you can ask David about Mom's condition that morning. She couldn't get out of bed. He wanted to stay home because Mom was sick. We did nothing, you know. There was no sexual thing going on that morning. And then later, well, she had to get up, get water. Answer, I brought it to her. Question, oh,
Answer, she did not get out of bed. Question, so you did have some conversation. She asked you to get a glass of water. Answer, no, I got it for her. She had nothing to say. David, after that fact, I think she was giving me indications like nodding her head or something like that. But David said that she couldn't talk that morning. So you see, on April 21st, 1999, he was blending fact with fiction. So when he was confronted about Kelly Labonte, no, oh yeah, well, she's just, she's the secretary for Scott McQuay. Girlfriend, no, she's not my girlfriend. And then when he starts showing the emails, you mean that, Kelly? Oh yes, well then yes, okay, now yes, now on April 21st, now yes, you could say that, but even it was very difficult to get a straight answer out of this guy who was blending fact with fiction. And do you think it's because he was too stupid to understand the question, or do you think he was smart enough not to answer it? Blending fact with fiction is Mark Jensen's pièce de résistance. It's his calling in life, to mix fact with fiction. So take the fact of Julie Jensen's one weekend affair with Perry Tarica in 1991, and then build the fiction around it, that Perry Tarica is doing all these hang-up phone calls, but that's not enough. Eventually, he's got to make it better. He's got to make it more humiliating, because he's a sadist. He's sadistic. The evidence shows that he's sadistic. And what means did he have by which to perpetuate the sadistic plan that he had? Well, he had a seemingly endless array of penis photos on his computer, and a seemingly endless array of fellatio pictures on his computer. He had an endless stock of pornography that he could use to humiliate and demean Julie Jensen with for years and years and years. And that's the mark of a sadist, a controlling, manipulative sadist. And then you have Turtle. It looked like an email from Turtle to Julie Jensen. That's the email that he showed her with these disgusting, revolting photos. And by the way, talk about somebody being bought and paid for. Consider the testimony of Dr. West. She wouldn't even acknowledge that, this 36-page record of harassment that was maintained by Julie Jensen at the request of a law enforcement officer. Dr. West could not even bring herself to acknowledge that that's a form of harassment, or that's evidence of harassment. Couldn't even bring herself to acknowledge that Turtle to Julie email with those disgusting, revolting photos on it. She couldn't even bring herself then to agree that was harassment. So maybe I got a little bit upset with Dr. West, because I think when people get on the witness stand, they're supposed to tell the truth, no matter how much they're paid to disguise it. So Dr. West, with her lofty degrees and her forensic psychiatry specialization, and Siggy caps, and you remember Dr. Hale laughed at me when I said side caps. Well, I apologize to you, ladies and gentlemen. I mispronounced Siggy caps, but I knew what the first letter of Siggy caps was. It's an S, and what does it stand for? It stands for sleep. The very first thing, the Siggy caps, the very first thing for analyzing depression with a patient is to talk about sleep disorders. And don't you think that Dr. Borman, a board-certified family practitioner with years and years of experience, and he said,
many patients who came to him with depression. Don't you, in fact, he talked about Siggy caps. So don't you think he talked about sleep? He did. He said he did. And he said he made no notes of any kind of sleep abnormality or sleep problems with Julie on either September 21st or on December 1st. And you don't have to take my word for it. You can look at his notes. Of course, good luck reading them, but you can consider his testimony. He never said anything about any sleep disorder. And yet, what did Dr. West say about Siggy caps? Oh, yes, Julie Jensen had a sleep problem. Well, where did that come from? Well, Dr. Borman's notes. Well, that was Dr. Borman's notes from December 2nd when he was talking to Mark Jensen. So it was Mark Jensen was the origin of her sleep disorder, not Julie Jensen, not Dr. Borman. It all came from Mark Jensen. But she just could not acknowledge, well, no, that came from Mark Jensen. No, she just couldn't say that. No, it's in Dr. Borman's notes, therefore it came from Dr. Borman, even though the evidence is absolutely, positively, unequivocally clear that all of that information about sleep problems came from Mark Jensen. And when did it come from Mark Jensen? Years and years and years after he'd been charged with this offense, because she interviewed Mark Jensen for 5 hours. And the other guy, Dr. Herzl Spiro, whom you didn't hear for, but she read his report, he'd interviewed him for 14 hours. Now, what do they teach in these psychiatry courses where you can become, where you get board certified as a forensic psychiatrist when you completely ignore the evidence? When you consider the prime suspect in a first-degree murder, that's the best source of information, most reliable source of information you're going to get about the condition of the victim in the months preceding her death? It's Mark Jensen and Laura Koster. And you saw Laura Koster. You heard Laura Koster testify. And you heard the testimony about what Laura Koster had truly actually said to Julie Jensen about a week and a half before she died. Because you heard Ted Voigt testify about it, and you heard Teresa Fazio testify about it. And what did Ted Voigt say? Ted Voigt indicated that Julie told him that Laura had told Julie, I lived with him after Julie had shown him this Post-it note, Laura Koster told Julie, I lived with him for 18 years. You have no idea what he's capable of. Now, Laura Koster denies making that statement, but she didn't deny living with him for 18 years. So what had the ring of truth to it? And then Laura Koster denies calling Paul Ratzberg crying and upset sometime around December 4th or December 5th saying, I think my brother killed my best friend. Well, how many brothers did Laura Koster have? And how many best friends did she have? So didn't Detective Ratzberg's testimony have the ring of truth? You know, there's so many little things about this case. There are so many little things. Take Dave Nearing. Dave Nearing testified that Mark was complaining to him about how he wanted his computer back, his home computer back. This is on a Friday afternoon. And Dave Nearing said, well, you know, you should be happy they didn't take your work computer. And what happened the following Monday? Do you remember what happened the following Monday? Dave Nearing comes to work and Mark Jensen approaches him and says, oh, my computer's fried. I have to get a new computer. Now, at some years earlier, Dave Nearing also recounted a conversation when Mark Jensen indicated that you could fry a hard drive on a computer by putting a magnet over it. Now, defense counsel made much of that. You know, they were cross-examining Jason Ruffle. You can't destroy a computer that way, can you? You know, take a 4,500-pound computer or something. Well, it's not like we said that you can destroy a hard drive that way. Mark Jensen said it, so he was wrong. That's what he said. Because Dave Nearing has no motive to lie to you. Dave Nearing had no motive to lie to you about the time on December 3rd, 1998, when Mark Jensen said he was at work, and Dave Nearing said he wasn't, and Meredith Perez said he wasn't. The people that were at work who testified in this case on December 3rd said Mark Jensen was not there. I think Rose McGinnis said that too. Everybody that testified who was at work on December 3rd, 1998, in the Racine office of Stifel Nicholas said Mark Jensen was not there, which is a rather inconvenient fact since that's Mark Jensen's alibi for about the time that Julie Jensen was murdered on December 3rd, 1998. In the closing argument, defense counsel made much of saying Julie used the internet. Well, of course, here's the problem with that assertion. There is not one whit of evidence in this case that Julie ever used the internet, not one whit. In their opening statement, they said, well, there was internet usage on this date when Mark was at work and Julie was at home. Well, remember Jason Ruff testified about that. No, that actually wasn't internet usage. That was the computer updating itself. There's certain things that update themselves. He said it was something that would take 1 to 2 seconds, and the computer would do that itself. There was simply no evidence that this computer was used when Julie Jensen was home alone. When Mark Jensen was off to his blueprint on November 5th, 6th, and 7th, the computer was not used at all. Now, defense counsel said Julie never told anybody about being sick the weekend that Mark was away at the Blueprint conference. Well, again, sometimes you hear these closing arguments from defense counsel, you wonder if they've been sitting in the same courtroom. Now, acknowledge it's a long trial, but you all saw and heard Ted Voigt's videotape testimony, where Ted Voigt specifically, unequivocally indicated that 2 to 3 weeks before Julie died, she told him that she'd gotten sick. And so she was afraid that Mark was trying to poison her. So she was afraid to eat or drink anything around the house. I'm not making that up. You saw it yourself. You saw it on the screen. Some of you looked at that screen, some of you looked at that screen, but you all saw and heard Ted Voigt testify about Julie being sick 2 or 3 weeks before she died, and how she was afraid to eat or drink anything because she was afraid that Mark was trying to poison her. And by the way, might that explain some weight loss? If you're afraid to eat or drink anything around the house because you're afraid your husband's trying to poison you? There were no searches on the internet for divorce. Well, there are a couple of reasons for that. Number one, Julie didn't use the internet. Number two, she already had a divorce attorney. Remember, she filed for divorce in 1990 or 91. I think it was 91. So she already knew who her divorce attorney was going to be. She didn't need to look it up, even if she could, and there's no evidence that she could. But the guy who wanted to run off with his girlfriend on the Windstar cruise, the guy who was having sexual relations with Kelly Labonte or Kelly Greenman, and then I think during most of this relationship, when it started in September, she was Kelly Labonte. When it continued by October 1st, she'd just gotten back from her honeymoon, and it started up again. By that time, she was Kelly Greenman. He was having sex with her again, going off again in the end of October to meet her in Chicago for 4 days. Then she was Kelly Greenman. There was no evidence that Julie Jensen used the internet. And here's the other thing about Julie using the internet. If Julie used the internet, don't you think he'd know about it? If Julie used the computer, don't you think he'd know about it? And if Julie used the computer and he knew about it, do you honestly think he'd have internet exchanges between him and his girlfriend Let's run off somewhere. Let's do a Windstar cruise. I do love you. I miss you. I want you. Do you think that would be on his home computer if Julie used the computer? Now, defense counsel also said in his closing argument, well, no, we're not saying that Julie was framing Mark for murder while committing suicide. We're just saying she committed suicide. Well, the problem with her just committing suicide is that the evidence is plainly and unequivocally contrary to that. Let's start with what Julie said. Julie was telling her next-door neighbor, her confidant, Ted Voigt. She was telling her third grade teacher, and she was telling her best friend, Laura Koster, that she was concerned that Mark was trying to kill her, or was trying to poison her, or he was trying to make it look like he was doing that so she'd do something that would make her look crazy. That's what she confided to Ted Voigt. That's what she confided to Laura Koster. That's what she confided to Teresa Fazio. Isn't that kind of inconsistent with a suicide? And of course, Dr. West explains everything away because, she had a distorted perception of reality. Well, Dr. West, how do you know she had a distorted perception of reality? Well, because she thought her husband was trying to kill her. Well, doctor, what if he was trying to kill her? Or what if she had reason to believe he was trying to kill her? Well, that was because of her distorted perception of reality. You see the circular reasoning there? Maybe you could see how I was starting to get upset with Dr. West and the nonsense and the BS that she was trying to feed you. So she was looking at the Siggy Caps thing, and there was this major depressive disorder, and the first S in Siggy Caps is for sleep, and the only evidence of sleep disorder comes from Mark Jensen years after Julie's been murdered. Oh, and then what about I? What was the I in Siggy Caps? Anybody remember? It was interest. Julie had lost interest. According to Dr. West, who was paid to review this case. Remember, she was paid to do this. She was paid a lot of money to do this. A lot of money. And what did she see about interest? Yeah, well, there was no evidence one way or the other about that. Well, except, of course, you know that's not true. Because you heard testimony from Marion Passetti. You saw her on the television screen. She testified at the last hearing. Remember, she said that Julie called her on November 30th. Julie called Marion Passetti. And what did she call her about? Something about which Julie had a profound level of interest. Gardening. Julie wanted to know what Marion Passetti's information, what Marion Passetti could tell her about how Marion Passetti had such a beautiful garden early in the spring. And so Marion Passetti was telling her all about how you get these seeds in the early winter, and then you get potting soil, and you set it up in your basement, and you get sun lamps, or these black lamps that provide sunlight, and you start your garden in the basement. So Julie was asking Marion Passetti very detailed questions about this. Marion Passetti said that conversation lasted 20 minutes to a half hour on November 30th, 1998, the day before Julie went to see Dr. Borman. So the day before Julie went to see Dr. Mormon, and 4 days before she was dead, Julie Jensen was talking with her friend, her neighbor, about having a detailed conversation about setting up her winter garden so that she could have early spring garden. But Dr. West didn't see anything significant. She didn't know about that, apparently. And if she had, well, of course, Dr. West could explain away anything that was inconsistent with suicidal intent, because under suicidality, she had admitted there was no evidence of suicidality. She admitted that. Julie never told anybody she was going to commit suicide. Julie had never attempted suicide. Julie had never made any plan for suicide. Any plan for her two boys that were everything to her. Her plan, apparently the defense theory is that Julie's plan was she'd leave the children in the care of the man who she believed was trying to kill her or make her look crazy? Julie had no suicide plan. She had never attempted suicide. She never talked about suicide to anybody at all. Mark Jensen also talked to Paul Griffin. And again, remember, we're talking about blending fact with fiction. Well, I shouldn't say that. We're talking Mr. Perry talked about blending fact with fiction. And if you look at the lead up to the point where Mark Jensen was charged with first-degree murder, that's what he was doing with everybody he talked to outside the family. When he was talking with Paul Griffin on February 24, 2000, this is Mark said about December 2nd. Right. The night before, the night before was when I think, if I remember it, it was the night we had macaroni and cheese, and we made that, and I botched that real good, and she wasn't even awake much. I mean, she was in bed the whole time. She was sleeping most of the time. I think the kids were being quiet not to wake her. I mean, there was some conversation that night, but she was pretty much out of it. That was Mark Jensen's description to Paul Griffin of Julie Jensen on about her condition on December 2nd. And he said that on February 24th, 2000. And then what did Mark Jensen say in his blending fact with fiction about December 3rd? He told Ratsburg, David stated he observed his mother breathing very heavily and had labored breathing the morning before her death. David stated he told several friends about this as well. David asked his dad the morning of December 3rd if his mother needed to go to the hospital. His dad said no. However, if she was worse later in the day, they would take her to the hospital. David said it was too late as they returned home and they found her dead. David said his mother was not eating. However, she was drinking a lot of water. And then the defendant's interview, page 71. She couldn't get out of bed that morning. You can ask David. She couldn't get out of bed. He wanted to stay home because mom was sick. She was in bed asleep. And then page 82. There was a question between myself and the kids that morning whether or not to call an ambulance, take her to the hospital, and the kids wanted to stay home. Her breathing was funny. She could hardly get out of bed. I mean, it was a god-awful situation. The bruising probably came from her getting up. I didn't hit her. She got up and she fell. She hit her head. I remember her telling me that. She got up to go to the John. And then at page 89, from 6:30 in the morning, she was not able to get out of bed. I mean, she was groggy, almost incoherent. Breathing was very labored, raspy. David tells me we talked about it. David tells me that I was holding her up, supporting her. Page 119. He had to bring her water. She couldn't even go to the John. David said she couldn't talk that morning. Page 138. She didn't get out of bed. She had a hard time breathing and could barely move on her own from 6:30 on. Blending fact with fiction. The fact that Mark Jensen knew he had to disclose because David was right there with him for this April 29th interview. And then the phone call that Mark Jensen had with Paul Griffin on January 9th, 2000. Mark, I didn't even hear her talk Thursday. How to describe it, to have it make sense to you. Her breathing was labored, kind of wheezy. She was cognizant of what you were telling her. She was weak by Thursday. I doubt she could have, if she could have got out of bed, it would have been crawling. Blending fact with fiction on April 21st, 1999, before Mark Jensen knew that we had computer evidence that we recovered from his computer, establishing that at 9:42 a.m. on December 3rd, 1998, somebody was looking up the late stages of ethylene glycol poisoning, unconsciousness, loss of consciousness, so forth. How to explain that? How to explain that when she couldn't get out of bed? Well, there is no explanation for it. That's consistent with the defendant's innocence. The only explanation for that is Mark Jensen was continually upset that Julie wasn't dying quickly enough. Here he gave her this antifreeze on the evening of December 1st. He was hoping she'd be dead by the morning of December 2nd, and there she was still alive. And he woke her up, and he was saying, or she she woke him up and she was dizzy and drunk. She said feeling drunk, and she needed an explanation for that. So he needed something to cause her to sleep through the poisoning. And so he went to see the doctor on December 2nd. And Julie thought, we know this because Julie talked to Margaret Voigt. Julie called her friend Margaret Voigt on the morning of December 2nd. And Julie was happier than she'd been in weeks or months. Here she was desperately sick, desperately ill, very uncomfortable, very, very uncomfortable. But she was happy because Mark was taking care of her. Mark was being good to her. Mark got the boys off to school. Julie was finally getting what she'd been looking for. She was getting a supportive spouse instead of the sadistic, narcissistic thug that she was actually married to. She thought Mark loved her. And when Mark got back from the doctor, he showed again how much he loved her by giving her the Ambien pill that the doctor had prescribed for her, and giving her another half a dose of paroxetine, and, helping her wash it down with orange juice and antifreeze. What a loving husband. Didn't she have reason to be happy on December 2nd, 1998 at 10 a.m.? She'd been lulled into believing that this monster that she was married to was finally showing her a little bit of love. That's what the evidence showed in this case, ladies and gentlemen. And you know he's guilty. Thank you.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You'll be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind as upright citizens to render a just and true verdict. The verdict submitted. The following two forms of verdict will be submitted to you for your consideration concerning the charges against the defendant, Mark D. Jensen. One reading. We, the jury, find the defendant, Mark D. Jensen, guilty of intentional homicide of the first degree as charged in the information. The other reading, the jury, find the defendant, Mark D. Jensen, not guilty. It is for you to determine which one of the forms of verdict submitted you will bring in as your verdict. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff, signed by the presiding juror. To have a complete record of this trial, it's important you communicate with the court only by a written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court. The court may ask each of you if you agree with the verdict. At this time, we'll swear in the bailiffs if they all could come in front of the clerk.
Do you swear that you will, to your utmost of your ability, keep all the jurors sworn on this trial together in some private and convenient place, subject to the direction of the clerk, having agreed on the verdict or discharged by the court, and that you will not, before they render their verdict, communicate to any person the statement of deliberations or the verdict they have agreed upon, so help you God?
I do. All right, the record to reflect the bailiffs were sworn in. All right, I have one more duty before we can start the deliberations, and it's a difficult one because all 16 of you have shown up on time. We're in the 4th week. It's not been easy. Sometimes the weather wasn't pleasant. I gave you short lunches. We had a lot of videos to watch. So it's difficult for me to say this. 4 of you cannot deliberate. And it's all random. You all have your numbers. We're just going to use the numbers. The other thing I have to tell you, the 4 that cannot deliberate, you are not excused yet. Because there could be an issue in the future, and it's a legal issue. I don't want to get into it now. We might have to consider you for something. So the 12 that are picked will deliberate in the back. The other 4 will be in another room, and we will tell you where you have to go. So let's do the random picking by numbers. What number? 3. You don't have to stand up, but you know number 3. Number 4. 6. 6. One more.
Number 5.
Number 5. Okay, have all 16 walk out in the back all together, please. Joe. Of the courtroom. If we have questions, my policy is to bring all the lawyers back and the defendant. So you cannot be far from the courthouse, but you have to leave a number with the clerk so we can call you. And I usually make a copy of the question for both lawyers and they can review it before we decide what to do.
Your Honor, I have one question, and that is with respect to the 4 alternates who are they weren't given any instructions as to what they could do aside from staying in that one room.
They're not going to do anything.
Well, but did you tell them they're not going to deliberate among the 4 of them?
We're going to have a bailiff with them in that room.
Oh, I just want to.
We're not going to have 2 verdicts.
I understand that, Your Honor. What I wanted to make sure of is this. I mean, I don't know what the defense is going to do in this unlikely event that we're going to need to get one of those jurors. And so I want the record to be clear that the 4 alternates are going to be instructed to stay in a room and they can talk about anything they want, except they can't talk about the case.
We will tell them that.
Thank you. Is that
my word on that?
Agree with that?
Any objection? Yeah. And I'm not going to give them their phones either, so they're not going to be able to surf anything.
Okay. Cruel and unusual punishment.
I will do it. Yeah. Okay, but make sure you give the phone number to the clerk. Okay?
Okay.
Thank you.
All right. Jury is now in deliberation, chat. They're now in deliberation. Odds are they are not going to have a verdict today. I would highly doubt that unless they've made up their mind. I mean, if they fucking come back in, before 5, that's not a good sign. If they come back tomorrow morning, that's probably not a good sign either. All right, let's see. Oh, here's let me hold it up to the camera. I got to make sure you guys can see. There's a lot of sun in here, and the lighting's kind of fucking weird. It looks yellow. I know it looks yellow, but it's actually green. I wish we were in my kitchen because the lighting is better in there. It's actually green. So here's to... It really is green, I promise you. I swear to God. Ruben's like, are you drinking piss? I promise it's fucking green. I swear to God. It's so good. Promise it's green. Looks like a cup of pee. It's Julie's missing urine. It really is fucking green. I promise you. I swear to God. All right. Antifreeze is down. Oof. Oof. I need it. Hang on. I got to mix that the right way. Jesus shit. Jesus shit. We're going to stay live for a little bit, so I'm not leaving for a little while longer. So we're just going to stay live. We're going to hang out. We're going to chat. I'm going to fuck around. I'm going to play some random ass videos. If you guys want to, if a bunch of you want to come on to the platform and you guys can all chat about what's going on, you can all talk about the case. That'd be cool. So we put a poll up on YouTube. Did the defense create doubt? 73% said yes. 26% said no. That's probably Bob and Bev. They were watching my stream, apparently. Apparently, everybody was watching my fucking stream. They copied word for word exactly what I said. Those of you on Facebook, if you like polls, come on over to YouTube. I'm going to put another poll up for the chat. Up on YouTube. I got to go mix this with ice cold water. It's the proper way to drink my antifreeze. That just fucked up my allergies too. Fuck. Oof, this is why we don't drink, guys. Gross. All right. Bev looks like if the Gerber baby and the Grim Reaper had a baby. She looks like the bride of fucking Chucky. That's the fuck she looks like. Bride of Chucky looking ass. We're definitely, guys, we are definitely doing we are definitely doing a fucking live reaction to Bob Jamboy. We're gonna do we'll do that another night because I got his fucking I got his whole dialect down perfectly. I got the whole dialect. Charlie started drinking a strawberry margarita yesterday and finishing it today. It sounds like how I am. All right, so we do have a friend in the courthouse, but we still don't have a working phone. So, fuck. I don't know how we're going to... Fuck, dude, that's really fucked my allergies up. All right. Let's see. I'm just going to play some random stuff. We'll chat in the background. Did you hear how? Listen, I want to say this, but I'm gonna do another live stream in one of the evenings, maybe over the weekend. I don't know. I gotta figure it out. But I want to replay Bob's closing, and I want to fucking do like a live reaction to it, and I want to talk like him while I'm reacting to his fucking. Everyone's got fucking sniffles today, dude. Jeremy Perry obviously was fucking partying with Bob. I don't know what the fuck happened. I just went in the kitchen and fucking feel like I'm gonna die right now. It's the fucking antifreeze. I'm in stage 2 already. Fuck. The fucking enzymes are breaking down, guys. I'm the only one in the house, so it must have been the neighbor. Jesus fuck. But yeah, so I want to do Bob's closing again. I want to play it, and I want to do like a live reaction because you guys missed. I was typing a bunch of stuff, but like I'm obviously talking back here to myself. I didn't want to I really wanted to talk to you guys during that, but I didn't want to fuck up for the video editing. But dude, I was sitting here and I was just like, I just kept talking. Did you guys hear that? This is my phone sex voice. We heard on the stand. We heard from this witness. I was like, Bob, shut the fuck up, Bob. Bob was making me fucking crazy. So I wrote this down. I wrote it down while we were on the break. And did we hear Attorney McNeil in her opening statements? And then just a little while ago, when Attorney McNeil gave her closing argument. I'm like, what the fuck did he just say? Attorney McNeil gave a closing argument? And he's like, and then she said this during her closing. Didn't it sound exact, people? Exact. I was like, no. No. I didn't see her up there. I don't think she gave a closing. I think Jeremy Perry for president gave a closing. And Jeremy Perry was like, I'm not going to yell at you like you've been yelled at before in this trial. I'm just going to talk to you calmly and respectfully like an adult. And the jury was like, thank God. Did you hear him shout out? Thank God. They really didn't, but they should have. And then within 6 minutes, Bob was yelling at the fucking jury. What was Trump's nickname for Hillary? Besides that woman. What did Trump call Hillary? That's how I literally was trying to think of that during the fucking thing. Because when he was up there, let me talk to you about Dr. Wells. That woman. I'm like, Bob, shut the fuck up, dude. Was it Nasty Woman? I was like, bro. He went like cool, bro. Like, talk shit about Dr. West. Like, she's a fucking, fortune teller. But I don't like those type of doctors, dude. They're fucking like I think the only thing I agree with Bob on. Hey everybody, welcome to the Never Stop Media phone sex line. Today you'll hear from my wife, Beverly, while she sticks a ribeye in a pan and pours me 2 glasses of Chianti. And I'm going to talk to you about that woman. Fucking Bob, dude. Get the fuck out of here, Bob. For real. I can't do a Trump imitation, but that's what I saw. The pursed fucking lips. Fucking robot arms. Fucking glue sticks. Bro, and like no bullshit. Like I know we joke around and we fucking make fun of Bob on this channel a lot because Bob's easy to make fun of. But like for real, dude. He looked high as fuck. Like really, he looked high as fuck. And I mean that with like the sincerest part of my being. I was concerned for Bob in that moment. I was looking at him and I'm like, oh shit. Like Bob's really high. Like for real. Bob's high. What kind of fucking edible did he fucking eat during the break? That wasn't a ski patrol fucking high at all. Bob's the kind of, I'm telling you right now, Bob's the kind of ski patrol party buddy that's fucking twacked out of his gourd looking out the fucking window at every fucking sound that's coming. That's Bob. He was on something else. Beb slipped him a fucking Ambien or something. Goddamn fucking Xanax. Motherfucker was on methadone. I thought he was going to nod the fuck out for a minute. He was fucked. He was fucked up. It's no good, Bob. Adderall? Nah, not Adderall. I don't know. He was fucked up, dude. He was fucking tweaking. Fucking Bob. Stupid fucking Bob. All right, I gotta go mix this antifreeze with water. That's really the right way to drink it. So give me a minute. I really needed to do some miles yesterday because this is, I'm just gonna be dead by the time I get to camp. That's all. But whatever, man. Oh, this is not fun right here. Anyway, I'm going to stop filming. I got to focus on this. This is pretty steep. So here we go. Crushing miles.
It's unbelievable that Aldi grocery prices are so low. Aloha savings.
It's not a sale, it's an Aldi thing. Find your purpose at Grand Canyon University. Visit gcu.edu.
Oh, shit. I don't like that. Mud and no traction on the old shoesies. Horrible. More incline. Come on, you're killing me. Oh, here we go. Well, maybe some wet feet on this one. Maybe. Oosh. I know. I gotta climb up this. Okay. Sure. Sounds good. Sounds good, Kevin. Brilliant idea. Okay. Yeah. All right. Well, we accomplished that. Minimal water on the old shoesies. Now we press on. I think I lost my green towel. I think it fell out of my pocket back there. The old shoesies. Here's to the Never Stop legal team. I'm gonna get mad at me for drinking antifreeze live on my stream. They don't like when I drink cups of flavored things. Oh, shit. Oh, there's the fall again. I don't remember backing it up, but that's funny as fuck that we got to see that again. See, I give you guys things to laugh at. This is your chance to laugh at Kevin. Shit, and 1 is 3. Tell you that. I just didn't see this at all and totally ate shit. You gotta be kidding me. It's like a little step up. I didn't see it because I'm filming like an idiot. I literally fell right on my face. I did too. I fell hard as fuck on my face. I literally just completely ate shit. Fell right on my face. I'm covered in mud now. I'm filming and not paying attention. I didn't even see that there was, like, the trail just stopped because there was a little step up. And I went right into it. And it's like knee level. What the? This day just seems to end already. It's a grueling day. We'll leave that in the video for you guys. You have to chuckle with me. Holy Christ. Oh my God, here we go. I did too. I totally ate shit. That step up was fucking knee level. I walked right into it. And I got a fucking 35-pound bag on my back. I just toppled over. Toppled over. Fucked up. Well, what do you guys want to do? What do you want to do while we hang out? We got like 2 hours. We'll hang out. I got nothing else going on. I'm not leaving for another couple hours, so. Who's drinking antifreeze with me? Those of you that are on Facebook, you should come join us on YouTube. This way you're all not alone over there. Christine and Charlie, come join us over here. So I've actually got.
All right, so we're gonna stop right up here, grab some water, because just past this is a spot that I'm gonna stop for lunch. Yeah, this is gonna be perfect. I may just stop right here for lunch. Why not? That's right. Right on the other side, maybe? Let's see, we gotta find the best way to cross. Yeah, that looks good. Juicy right there.
Yeah, I was honestly surprised that they didn't ask for a mistrial today, because they put the objection on the record. That worries me that they're all aware of what happened, and I really don't understand why that wasn't like an immediate mistrial. That should have been an immediate mistrial. At least asked for it. You know what I mean? I'm sure fuckface would have denied it, but I think even if he denied it, he would have been in the wrong. And that's why I made that video, because like people need to understand. They could refer, because you heard the cop. He said, Julie left me 2 voicemails. That's in the testimony. That's allowed. They could say Julie gave Ted Voigt a letter. That's allowed. But they cannot reveal the contents of what the voicemail said or what the fucking letter said. So they can't have a testimony of, yeah, I gave a voicemail. Well, Mr. Voigt, what did the voicemail say? You know, or the letter, I'm sorry, gave him. See, this is why we don't drink fucking absinthe while we're trying to stream live fucking court trials. Don't drink absinthe on the fucking, when you're doing important shit. But they couldn't say, oh, she gave you a letter? What did the letter say? And then he says what the letter says. That's why Ted Voigt's fucking thing was edited. And then same thing with Ron Kossman. When they said, they showed it in the testimony, the video testimony, Julie left me 2 voicemails. And then it just kind of stops talking about that, and you see it go on to some other topic. It's because he can't fucking say what's on the 2 voicemails. That's what the Wisconsin Supreme Court fucking said. The contents of the voicemails and the fucking letter are testimonial. That's it. So I even went back, I watched both the fucking motion hearings specifically about that. I clipped in part of it. It was a much longer fucking thing that I could have edited in there, but I was like, oh, people are going to get real fucking confused. But that's the thing too, is like people aren't paying attention to that. That was a major thing. So I'm surprised they didn't at least file for the mistrial this morning. But yeah, no lessers. So both sides are real confident. And this is a brand new trial, so they could have done lessers. They absolutely could have. I'm wondering if they could have charged him with the kidnapping conspiracy because it's a new trial. You know what I mean? Now they have evidence. I don't know. Maybe they didn't because fucking Klug is not around. I don't know. I don't know what the fuck happened with that. Any guesses? So I'm saying I'm saying fucking Friday morning. So I was planning on maybe doing a poll tomorrow, but I don't know if I'm gonna go live tomorrow.
Yeah, I think we're gonna cross right
I don't
here.
know. What do you guys think? Type in the chat. How long? How many hours? What day? They may have it wrapped up tomorrow. They fucking better not. I mean, it took them 4 days last time. Yeah.
It's either gonna be that spot or right down there. Yeah, this might be the spot. Then I can use water to make lunch and then fill back up right away.
Look, right now we got 36% that say guilty. Who the fuck is voting
right off
guilty
here.
on the fucking stream?
Not where I was gonna stop, but I don't know, man.
Why
This is
are
too-
you all a bunch of fucking
it's too
cowards?
perfect.
And you don't type that. Just type that shit. And then 27 hung?
I just came from up there.
Oh my god, bro. What a bunch of
Perfect.
fucking keyboard
Let's do it.
warriors.
Take water, just make lunch, take a break.
Those scary ass motherfuckers in the background. Come type or some shit and convince us why he's guilty. This is the most fucked up poll that we've had. Well, we did have the 30-30-30, but that was a while ago.
Of course, as soon as I turn the camera on, I trip. All right, this part of the video might be a little shaky. I'm trying to seriously crush some miles. I'm kind of running down this decline. Look at, holy Christ. We got the mountain right there.
Anybody want to come on and chat?
Look at her.
Come on to the stream. Talk Jensen.
It is a long way down, people. There's like a lot of rocks, so like I feel like I'm in cat heaven right now. Another reason I'm trying to like run through this. I feel like, you know, you got one up there somewhere just staring at me. The problem with the cats is they come up behind you, so
Poll is
by the
now
time you realize
even.
you're there, it's already too late.
33,
Look at this. Oh, look at
33,
this.
33.
Well, maybe I'm not running down this.
Poll is even. I really want to talk to the people that think guilty or hung.
I'm trying to like make up a little bit of time. One, it's like 3:45. So I still have 3 hours. I'd like to stop by 7 because it gets dark by 8. So I'm really trying to push out as many miles as possible and not. Oh, Chippy, don't do that, dude. You scare the bejesus out of me. Trying to kind of catch up with the 3 hikers that I was hiking with.
Are you guys
They're a
getting
little
the
ways
idea
up
that I'm
ahead of
crazy
me.
yet? You hear me talking to
They
myself in the
passed
fucking
me while I
hiking
was eating
video?
lunch.
I'm like talking to the phone like I'm talking to you. Boss thinks it'll be Wednesday. So that's
Your
tomorrow.
new home needs more than just paint. It needs the power of CertaPro Painter.
No, my home doesn't need
customized.
Shut up. So, I mean, I don't know. I think if I literally stopped filming, I sort of have this idea it might be just tomorrow, but ran this. I really kind of think Friday. Several miles. Juries are always really hard. I could probably make my goal. I don't know. It's going to be real tight regardless. I wonder if he'll cut them at 5 or if he'll cut them at 8, but, you know, 7? At the speed I was going this morning. I think I could crush out 10 or 11. I'll keep streaming until I like noonish. Tomorrow and still make my deadline. Yeah, this just seems like cat heaven. So make sure you guys like the stream, follow all the platforms. Come join us on YouTube for those that are on Facebook. If you guys want to help support the platform, there's some links. Check out our apparel website. That's fun. So I think if I got up early, the hiking YouTube channel up there, you can go subscribe to that. Still hit my goal. Like the hiking stuff that I do. Even if I finish a little, we need 1,000 subscribers and 4,000 watch time hours. But whatever, we'll see. Or I can even monetize that channel. That channel's not even monetized. She's like right there. It's crazy. Make sure you guys like the NSM trial coverage. All right, I'm gonna shut it off. Here we go. Crushing miles. Here we go. Stream, trials only on that channel. Yeah. We're just crossing river after river after river. Just getting our shoes soaked. I'm trying to get some of this mud off of them. Well, yeah, that's yeah, about ankle high. Well, they're blue and about to be brown again. Well, what other days do you guys think? When do you think the jury will come back with a verdict? It's called Cottywomple Wayfarer. I'll put the link in the thing for you. Hang on. It's on the Facebook page. If you back out of the stream and you go to the page, I posted it today. I don't know if you'll be able to click on this link. And apparently somebody fucking named their channel the same as mine, which really kind of pisses me off right now. I don't know how the fuck they did that. Fuckers. We checked before we named the fucking channel. Yeah, I almost bailed out at that point. I literally almost called fucking search and rescue. There's no way to trust that. I'm just super nervy about the water because of the no traction on my shoes. So watch them come back, dude. As soon as I leave the house, watch them come back. Just nervous about slipping.
Get stuck with a big, giant, heavy backpack, slip face down, be stuck in the water because the weight of the pack is holding you down. You should join us on YouTube, Lynn, on the YouTube that we're on right now. Never.Stop.Voices on YouTube. You join us over there. Charlie, Christine, you guys should come over. It's all a bunch of ladies except me and Boss. All right, here we go. We're the only two dudes on here. Wasted too much time on lunch. How much does my pack weigh? Rinsing off in that river. We really gotta hurry. Before food, water, and my camera gear, I have a 21-pound backpack. Camera gear, depending on the hike, is between 6 to 8 pounds. And it's more like these bigger hikes, it's between 8 and 10 pounds of camera gear. Food, picture 2 pounds of food per day. So depending on how many day trip I'm on. Water, I usually carry 2 liters. So a liter of water is a pound. So I'm generally between 35 and 40 pounds on my back. And it's because of, in big parts because of the camera gear. And the food. Just pure white. But when you're counting base weight, like you don't count your food and water. I separate the camera gear too because it fluctuates. And I don't necessarily kind of include that in a base weight, even though it sort of is. Every trip is different though. I brought extra stuff on this trip, but I dropped, when JK left, I dropped like 7 pounds out of my bag. I needed to run through the rest of this trail. But I've carried California. I carried 6 liters of water on the trails I did out there, and that was just a day hike. That was a day hike, and I'm glad I did because the water sources were all dried up. I've never seen anything like this. Sun exposure really just loses that mountain up there. The sky is just so like blue. All right, looks like some easy stuff, so I'm gonna crush. Here we go. All right, Iceland, we'll see you.
Ever heard of scent-flavored hydration? Well, let us fill you in. It's Air Up's way of sipping water, but tasting flavor.
Native! Clean?
Stupid commercials. All right, it looks like we got another river to cross. So, trail's up there. We're gonna find a good spot. I'll be right there.
Still got a live feed in the courtroom. We're getting wet on this for sure. All right, well, that went just to my knee on the one side. Shit. I gotta climb this. Give me a minute, guys. All right, well, that sucked. I'm soaked. Well, we knew that was going to happen eventually on this trip, right? Yeah, that went to just below my knee. Seemed all right, like it was kind of shin level. And then the next step, right to the knee. So now my shoes are soaked. Socks are soaked. It feels good, though. I mean, I'm not going to lie, but I was trying to avoid having wet feet, especially with the amount of miles I got to hit. So, I don't know. Whatever. We made it safely across. That's what matters. But we're going up again, so here we go. A lot more miles to crush. Give you guys an idea how high up we are. We'll see if we can get my buddy to message me if the jury has questions or they want to see exhibits and stuff. We'll see if I just messaged him to let me know if he has time. So we'll see if he does that. I could have him fucking email me though instead of texting me, which is gonna be a fucking nightmare. I don't know what kind of trees these are. We're getting closer and closer to this mountain. This whole area, I mean, like every time it peekaboos out, it looks so far away in the video, I'm sure, but at least from my screen, but I mean, it feels like it's a couple 100 feet away. This whole side of the mountain ended up catching fire several years ago. So this whole side is like scorched. But I don't really know
So much
like
exposure.
my trees.
All right, I got to crush. Here we go.
I know more about like plants and berries and shit that are out there. I don't really know trees. There's a whole section of this side that I didn't film because it was super sketchy, and then I ended up meeting up with another hiker, and we were trying to hurry because it was getting ready to get dark. Oof. So there's another video that I'm gonna work on where other people filmed the sections that I hiked. So I'm gonna like rip some of their video and kind of do like a talk over, because there's some pretty sketchy parts that I had to walk through. And then the cliff,
Wherever today takes you.
the 100-foot
Whatever
cliff that I had to fucking Alex Honnold down, and then the river I had to cross, I didn't film any of that. So I did that all in the dark, which was super sketchy. Oh man, look how clear this water is. It's so clear. All right, let's go through the mud field. This mountain's throwing everything at me today. Everything. Oh, we're soaking wet again. Yeah. Oh yeah, soaked. You know, my feet were just starting to dry out. Mud everywhere. Hey Mom, I'm muddy. Yeah, the day I gotta crush Miles, it's like it wants to throw everything at me. All right, so that noise, that's my phone going off, obviously. So I'm able to get some self-service, so I've been chatting it up with JK. He's like super making sure I'm all right. I think he's nervous about me being out here by myself. I'm kind of past the nerves part. I'm just trying to go. You know, I keep running into little groups of people that I've been hiking on and off with, so again, we just keep kind of passing each other, and so these photos are horrible, and my arm is sore. Yeah, I had to stop. I had to readjust my pack. Something about like after lunch, I always like pack the bag weird, and I feel it pulling on me. So I had to stop, readjust a couple of things. It feels better. Oh, I'm kind of trucking. Still got several miles to go, but if you don't run into any crazy, then I might be on par with definitely hitting my target goal. So we'll see. It sucked too, man, because if I didn't run into that cliff and that river, I totally would have been able to crush out these 22. I should have ditched a couple more pounds. I probably could have just done with the monopod. I got rid of the rest of the parts of the tripod. Oops. And probably a windbreaker I could have ditched. A few other small things. Probably could have dropped another maybe 3 pounds out of the bag, which would have been nice. Whatever. Oof. This looks like bear scat for sure. I don't know. I'm going to show you guys. You guys tell me in the comment section. Okay.
Can we see? It looks like a bunch of berries and shit. It definitely looks like bear scat. I'm a smaller bear though. So whatever, we'll just be mindful. The group I was hiking with is just ahead of me, so not too super worried. The views here are just absolutely insane. And the trail just such a tiny single track. Filming and walking, people, is not easy. I'm trying to like look through the camera so I can see what I'm filming, and that just keeps proving to not be a good idea. I keep falling, tripping on stuff. So now I'm just kind of holding the camera chest level so I can see out in front of me. So I don't know what I'm filming now. Oh, Christ. More ups. It's like you come down a little bit and then you're going right back up. Right back up. So more sun exposure on this side, which, you know, is kind of nice because it'll dry my trail runners off, but at the same time, you kind of start sweating more. So, I don't know. I think we're around 5,400 now, 5,400 feet, somewhere around there. And the campsite I'm going to be at literally looks like it's on the side of the mountain. So I don't know how I feel about that. We're gonna have to see. But anyway, onward bound.
But like where that snowy patch is?
Yeah.
Slightly above that, and then curl left and then round the ridge. Then so we're going not quite to the top of the square there, but like where that snowy patch is.
Yeah.
Slightly above that, and then curl left and then round the ridge. And then tug that elevation for a while, and then back down.
All right, what's up, everybody? So day 4 for me, day 3 of actually hiking. And I am at Cloud Cap. Got here last night. I had to do multiple dangerous river crossings. And I did one in the dark last night, along with climbing down the side of a cliff in the dark. But we'll get more into that later. So yeah, right now it's just after 7. Got about 14 more miles to go until I reach the Timberline Lodge again. And some of the hikers, you know, that I was talking about in the previous episode, that we were kind of hiking on and off together. So they're here, and we're going to hike the rest of the trail down to Timberline. So it's a long day. Got to get down by Timberline by like 1. Supposed to be some rain. It's going to be cold. The mountain is behind me, and we are going up to 7,200 feet, and we are literally going to be on a ridge of this mountain. So it's going to be interesting. By far the grueliest hiking day yesterday, and one of the most dangerous hiking days I've ever had. So hopefully today's a little bit easier. We do have a little bit of a sense to get up, so probably another 1,500-ish, maybe 2,000 feet, and then down. So I'm exhausted. My body's sore. I'm beat up. I didn't sleep well last night, so just got to push on. Just got to crush.
I don't even know what funeral you're talking about.
This mountain.
For generations, Bridgestone has made tires.
You guys always
Today,
like
we're still tirelessly
speak in
at
half
work.
sentences. Like I know everything. I have no idea what funeral you're talking about. You guys could tell me there's a nuclear strike happening outside, and I'd have no idea because I'm spending 20 hours a day on this trial. See, like the whole rest of this part I didn't film because it started raining. I filmed some of it, but the video was shit. And then it was a hailstorm, and then we went up on the ridge, and it was like 70-mile-an-hour winds. I was more worried about not getting blown off the mountain. Tyree Nichols' funeral? All right, no. Still didn't even hear that. I've not like, I mean, if you watch the Facebook page, I haven't even posted like newsy stuff on there since doing this trial. A couple of posts here and there, but that's it. I just don't have time. That's the problem with doing these trials and trying to edit video clips out. There's no time. I was still uploading videos during the trial stuff today, uploading them onto the YouTube channel. Some for members, some that are public. There's some that are unlisted right now. That's why I wasn't like super chatty, because I was trying to be back here working on video stuff. That's why I sound exhausted right now too, like I'm ready for bed. Staring at the goddamn computer.
We would use it in laser than a lens, and it would be somewhere around the building.
Yeah.
And we know about it on this.
I mean, those people just go to the funeral just for show. You know what I mean? That shit's not real.
You know, why isn't the president there? You know what I mean? Send the vice president. I don't know.
Yeah. Right where it's.
Well, right. That was my point. Yeah, right. That's what I'm saying. Like, why isn't he there too? You know, he should be there. It's not gonna let us off too easy, huh? I mean, they have like the whole presidential, you know, line of succession that's at the inauguration. It's like playing Jenga.
Wisconsin Dells. Go to Wisconsin.
Shit. Holy God. I think I'm a little bit more nervous doing it just because like I ate up the traction on the shoe, so like everything slips. So it's like I lose that little bit of confidence that I need.
It's like I'm not gonna drown. I don't think. So. Yeah. Right. Exactly.
Grew up in a place where they told you what to chase, told you how to run the race. Every move was on the page, but I didn't like their way. Had to fight and misbehave, had to find a way to change, had to leave to find my way. Caught up in a daydream, I beat my mind up there almost daily. It's how I pass time, no opinions safely. It's how I understand what I want in this place. See, cause everybody wanna tell you bad things. What could go wrong, what fame brings, but success is a finicky thing. And if you ain't sure, no, it'll never be. I don't wanna let myself down. I don't wanna let myself down. I will run away, I don't have to plan it. I can go, change my fate, you won't understand it. All alone, that's okay, people I can't stand them. They don't want me to change, keep me where I'm standing. And I don't wanna be where I am. I want something more, take a chance. It could be possibly my last dance.
Yeah. So like all this, how steep this is, loose rock. There's some random boulders. That's what I climbed in the dark, but way worse. And then catastrophically one false move and you're falling straight into the river. I'm trying to like give you guys a visual because I couldn't film that. It was way too dangerous. And I should not have done that in the dark at all. There's no way. That was super sketch. But I didn't have a choice. I needed to get to a campground. This camp spot behind me was full. Oh, yeah. So like, I mean that, dude, that's like what I had to climb down. It's insane. I'll take it. I said I'll take it.
think there's been a murder. I'm trying to figure out what happened.
At Right Brand, the
All right, guys, what's up? All right, so it's been pretty crazy weather today. Passing that mountain, it was hailing, crazy wind up there. That was super sketch. I think sketchier than my in the middle of the night river crossing. As you see, I got like my rain jacket on. It's been on and off raining. So this is definitely the coldest day and rain here and there. So I kind of put all the electronics away and taking more pictures than video. So I'll try to shoot a video as I can. But just trying to get out of here. Estimated 3 hours left. And we're good. Finally get off the mountain. So here we go. Crushing miles. All right. So probably going to be super shaky. So the sun is out. So it is supposed to rain again. But it's, I don't know, it's weird because who knows what side of the mountain it's going to rain on. But we got just under 4 miles to go. Then we're done. It's not going to make brunch, which is all right. Gonna be a couple hours late for that. But, whatever. We get, it's just unreal out here. It's so nice, but you're paying for the views for sure. This mountain will challenge you 100%. This has been some of the most dangerous stuff I've ever done in my life. And you're basically walking on one of the peaks of Mount Hood for several miles. You got a good 3-hour hike on the peak. And it's just, you're 7,200 feet in elevation. It's so windy up there. And there's giant gusts of wind, and it's coming so fast. It's just blowing you all over that peak. But I've crossed some of the sketchiest rivers. The Sandy River and the Elliott River are pretty dangerous out here. The Elliott is the one that I did in the dark. Doing the peak that we hiked this morning. That was super sketchy, super dangerous. A lot of it's just taxing on your body. Even though it's 41.5 miles, there's still so much of this trail that's just taxing. And some of those water crossings, you're climbing boulders. It's not just step on this rock, step on that rock, or cross this log. You're climbing boulders to get across. And the one river I crossed, I was, literally laying on the boulder, hugging it and sliding down it just to place my foot. And I'm kind of Supermaning my foot over to reach another foothold. And there's a big gap between boulders. And then you're stretching your arm out. So now you're Spider-Maning this thing. And it's super sketchy, and you're supposed to be doing these water crossings early in the day, because as the sun comes up, it heats, that mountain up. So that snow that's up there, you're just having this glacier runoff. That's why you see some of these rivers are roaring. So the later in the day that you do it, the more dangerous it gets. And, we're kind of have some doing it at this time of the year in the fall. Those rivers aren't as high, so they're not as psychotic. But still dangerous enough. There's a couple of them where, you're crossing and, 10 feet to your left, it's a giant drop waterfall. So, I mean, one slip and it's over. So, but yeah, like I said, I mean, this mountain is not letting you get the views without paying for it. This is going to test your body. It's going to test your mental strength is a big thing. There were a couple of times I really wanted to tap out, especially at two of those rivers. Last night, crossing the Elliott, having to climb down that cliff and then cross that river in the dark, just using a headlamp and just trying to trust your handholds on the cliff and your feet, mostly your hands, and then, trying to trust your holds crossing the river with just a headlamp and then trying to figure out where the hell the trail is on the other side. So, your body's going to take so much and your mind is going to quit before your body does. And it's like when I crossed the Elliott last night, I knew in the moment this is one of the most dangerous things I've ever done and probably one of the stupidest decisions I've ever made. But I just kept viewing it where it was like, I have to get across this because I need to get to this camp spot. I have to. I don't have a choice. And, looking back on it, the guy that I ended up hiking with, he stopped right before the crossing, but the camp spot was so small, it was only big enough for like a one-person tent. But looking back on that, I probably could have just cowboy camped. I have the little foam mat, the pad, and 0-degree sleeping bag. Like I probably could have just cowboy camped that, and that would have been the safest bet, and then crossed it early this morning. So in the moment, looking back on it, definitely one of the dumbest things that I've ever done. Even though it was successful, it was still stupid and very, very risky. But a few more miles, man. It's one of the hardest trails I've ever done. One of the hardest. So anyway, a few more. Here we go.
Why are these so bad?
All right, one more river crossing, then about 1,000 foot of elevation, and we're almost there, 2 miles away.
everyone's lurking in the background, April.
We're getting there. It's almost done. So when this water level is higher, this is supposed to be a super dangerous river. We'll see how it is here. Yeah, here we go. All right, so there's this part we got to cross, and then there's one more on the other side of that little berm there we got to cross. So kind of two rivers in one. All right, so I don't think I'm gonna film this because we just gotta go. So here we go. It is what it is. All right, look at that. Just up ahead, JK came and met me for the last little 0.5. We're almost there. I'm struggling. I'm walking real slow. It's been like 1,000 foot of incline, with just like thick sand. We finally kind of leveled off a little bit with some gravel, but it's brutal. It's windy. It's freezing up here.
I don't really know what comes next. I'm just doing my best, even though I'm so stressed out. Everything just feels like a test that I fail, so depressed when I can't seem to get out. But something deep inside won't let me quit. I swear that I'm inspired by all this shit. Tell me that I can and I won't. That's what guides me the most. Kill lies, I'll do what I want. I'm inspired by thirst. I'm inspired by worth. I desire your worst, so you can just hide while I work.
I like it.
I ain't tired, you first. I'll write a second, third verse about the lies you go disperse. You never did shit, I know it hurts. But something deep inside won't let me quit. I swear that I'm inspired by all this shit. Tell me that I can and I won't. That's what guides me the most. Kill lies, I'll do what I want.
Everybody, this is just it. The stage closing I thought sucked. Jeremy Perry's closing was really good, and then Bobby Boy's, I don't know what the fuck came out of his mouth. He did not look good. He looked high. He was, I don't know what he did. That was the worst thing I've ever seen in my life. But as soon as this little hiking video is done, I'm gonna jump off. I'm gonna try to edit at least one video real quick, and then I gotta get going. I'm gonna try to get the closings up first. All right. So probably be a few hours before I get it clipped out and uploaded to the YouTube channel. But I'll have it like editing and rendering, and then I gotta leave, and sometime after I come back, hopefully it'll be done. All right, sorry about the shaky camera. I'm just holding the phone at this point. Whatever reason, if the jury ends up coming back tonight, which I don't think they will, but if they do. So JK came to meet me. hiking friends that I met up here stopped to wait for me so we could all hike down together.
Send me a message ASAP. I'm hoping my buddy
This
will
has
message
been
me. The phone's still
amazing.
off, so I'm hoping he gets my email. I don't know.
Now we're here. It's one of the hardest hikes I've ever done. I had 4 days to do 41.5. Ended up doing it in 3. Not by choice. And yeah. So we're gonna celebrate down here. It's a victory for sure.
Yeah, the phone's still off, man.
Talk to you guys soon. Trail feet.
Yep. Is this fucking live? What the fuck is this? All right, guys, hang on. They just came back into the courtroom. Nobody go anywhere. They're all in there. Maybe they asked, yeah, did they ask for an exhibit? See, this is why I need my phone, because I'm not sure if my buddy's getting my text messages or my emails. Because he's there like doing his newsy shit. Whereas if I could fucking text him, because he doesn't respond to emails fast enough. Fuck. I don't know, Denise. They may just be back because they're, the jury's allowed to ask questions and ask for exhibits and whatever. So they might be doing that. I don't know why you're getting worried he'll walk. I mean, all the evidence points towards Julie, not towards him.
Gun here, I'm thinking about the thumb drive, if we're going to let him. All right, we're going to go on a record. Mark Jensen, 2002 CF 314. At 4 o'clock, the foreperson informed the bailiff that the jury had a question. For the record, all the attorneys are present for the state and the defense, and Mr. Jensen is also present. It says question number 1. The first column, it looks like they're asking for certain items. One is a flip chart. Underneath it says marker and tapes. I'm going to give those items to the jury. There shouldn't be any objection to that. So we'll give them a flip chart, markers, and Scotch tape. On the other side, to the right of the note, it says exhibits, and I would take it that they're asking for those exhibits. Exhibit number 10, which for the record is the thumb drive of Dr. Chambliss. It says photos 1 through 7. Exhibit 24, which is the EMS statement for Julie J. It happened on December 3rd, 1998. And then Exhibit 99. It is the handwritten notes of Dr. Borman regarding Julie's physical, September 19th, 1997. So if we're going to give them these exhibits, as to the thumb drive, I would have the jury come out. They can watch the photos and have the physical exhibits of 24 and 99. So,
Your Honor, so if the state could be heard on that, first of all,
I'm just saying if we do it, that's how we would do it.
Okay.
So now you state your position.
With respect to Exhibit 10, the thumb drive, the
only parts that were admitted into evidence were photos 1 through 7, according to the exhibit list. So I don't know if the rest of it was admitted in evidence. I know the autopsy report was. No photos 1 through 7 to the jury out here. Then with respect to, and we agree with that. Then with respect to Exhibit 24, Your Honor, the last page of the EMS statement was read to the jury. It was so they know about the last page. And the Dave Wilkinson was asked about responding, but the first 2 pages, maybe the first 2 or 3 pages, were not admitted into evidence. There was no testimony about them. So I don't think the first 3 pages can come in. I do believe the last page can come in because it was read in its entirety to the jury.
Well, the exhibit was received.
Correct, Judge.
I can't make a determination what parts of exhibits now that are received are not part of the record. There's no way I can do that.
Well, Your Honor, there were.
I mean, if they asked for the manuscript of 300 pages, I would say no. But this is a 4-page exhibit that was received.
Well, Your Honor, there was also, as you said, there was the paginated manuscript that the defendant wrote, S45. That was received into evidence.
I know, but I'm not going to, if they ask for it, they're not going to get the manuscript.
Yes. And why? Because
it's 300 pages.
Well, not only that, because hardly any of it was testified to. In fact, only 1/2 of 1 page was testified to. So in terms of the fact that something was received into evidence doesn't mean the jury gets it. What the portion that they get is the part that there was testimony about. So with respect to Exhibit 24, I mean, I'm not saying that it's particularly prejudicial necessarily to the state, but pages 1 and 2, there wasn't any testimony about that. The part that was testified to was the last page. So
What's
that's
your
the part
position as to Exhibit 99?
Exhibit 99, let's see. That was the handwritten notes of Dr. Borman. Well, Dr. Borman testified about his notes. However, the notes themselves are not readable, and it would call for speculation for the jury to try to interpret those notes. Dr. Borman testified about the notes, but everybody conceded that nobody could read Dr. Borman's notes except for Dr. Borman. So I'd say sending the notes back, first of all, those notes are hearsay, and secondly, it would call for speculation on the part of the jury to try to read those notes.
What's the defense position?
I think they should all go back. They were all admitted without limitation. Mr. Jamboys actually in his rebuttal actually said regarding Dr. Borman's notes, you can look at these. I don't know if you can read them, but so if they can't read them, that's fine, but they want to see them, and it was admitted without limitation, as were the other exhibits. Now, the one difference with that manuscript that's been brought up that they haven't asked for, at the time that it was submitted into evidence, we addressed the fact that it's only that half a page that like this whole thing wouldn't be admitted for that purpose. But that didn't happen with, I don't think, any other exhibits.
Well, the only other exhibits I can think of, and they might not ask for them, is some of the experts' reports that talked about the letter.
Right.
I mean, we would have to take that out.
That'd have to be redacted. That's right.
Well, but all the other parts have to be redacted as well, because, for example, in Dr. Ward, the defense psychiatrist, she makes reference to all kinds of hearsay evidence that's not admissible. The jury can't hear it. She relied upon that in coming to her conclusion, but the jury cannot see or hear the hearsay that defense experts relied upon in coming to their conclusions. And that's, if you remember, Judge, we had a great deal of discussion about this in advance of trial, that the proponent of an expert's testimony cannot obtain, cannot present to the jury the hearsay that the expert relied upon. And you took that one step further with respect to the letter. You indicated that I couldn't even cross-examine the defense experts about the letter. So the experts' reports are not admissible. The fact they're received into evidence doesn't make them admissible. It doesn't mean they go back to the jury, because the jury can't see hearsay. And all I'm saying is you can send back the portions of the report of the exhibits that are not hearsay, but the portions of the exhibits that are hearsay cannot go back. So with respect to Exhibit 99,
there was significant portions of Exhibit 99 that Dr. Borman testified to, and there are other portions of it that he did not testify to.
They're his notes.
We went through all of it, and he was questioned about all of it. And the EMT's response was questioned about the times.
I was
And
just
that
going to
report-
say that. I'm looking at the report. It talks about the time. It talks about the ECG monitoring that they put on her. It talks about what they did when they got there, and all that was testified to. So I'm not going to go through each one of these exhibits now that are in evidence. They're not experts' reports. It's not the manuscript. And I'm going to let the jury look at 24 and 99. I think
I would just cite to the court State versus Hines, 173 West 2nd, 850, 496 Northwest 2nd, 720, where they found 496 Northwest 2nd, 720, where at paragraph 6, the court concluded that it was reversible error for the exhibit, which could have assisted the jury in this credibility determination. The statements were hearsay. It is not proper for a jury to be allowed to use objected to hearsay that does not fall within any exception to the hearsay rule. So there was, that's what we're trying to avoid here. We simply don't want the jury to see or hear hearsay. And so the fact that a document was received into evidence doesn't mean it's not hearsay, Your Honor. And there were vast numbers of documents that were received into evidence that are hearsay, such as all of the expert witness reports and such as the portion of Exhibit 24 that was not testified to. I'm not objecting to the jury receiving the last page of Exhibit 24 because it was read to the jury verbatim. So I don't have a problem with that. But the rest of it was not attested to. So it's hearsay.
that's incorrect. Page 2 talks about the time they got there and when they left. So don't tell me the other pages don't have any evidence that was testified to.
But Your Honor, look at page 1. Look at page 1. Page 1 has all kinds of information in there that was not attested to.
It says at location what the scene was.
And then it also...
And they took her to the hospital. And it's got her address. It's got her age. The location call. Unresponsive. He talks about a cardiac monitor use. Talks about vital signs. So all that was testified to. And Dr. Borman, he was on the stand for a long time.
He was.
And he had his notes, and he went through his notes. And I know one of the issues was you couldn't read them.
That is true.
So I don't want to sound like somebody who's predicting the future, but if we couldn't read them, I don't think the jury can read them.
So, Your Honor, then the court's ruling is that with respect to Exhibit 10, you're going to bring the jury in and show exhibits, show photographs 1 through 7.
And that's it.
Okay, and then
That's the only way we could do that exhibit.
and then exhibits 24 and 29 and 99 will be sent back to the jury.
And I don't want to send a precedent on further exhibits, but if we get into experts' reports and manuscripts, we're going to look at it totally different. That already. Okay, so tell the jury we're going to show them, bring them in, and we'll.
Who's going to set that? Who's going to? Did you want us to show it, Judge, or who's going to show it to the jury?
I think is there a way the court can show it to the jury? This
Sure.
should not be.
We're going to have to put it on the screen.
Yes, and so I'm wondering what mechanism you're going to use to do that.
I'm just asking if the clerk can do it as opposed to one of the parties, because this is no longer presenting a case.
You'd have to ask them clerk nicely for that.
I'm wondering if the clerk could please do it.
Okay.
I don't have a laptop.
It's got to be through a laptop.
Do you want my laptop?
Well, it has to be hooked up to
It has to be hooked up.
another desk.
I mean, do you want to use my computer?
Or I can use this desk.
Do you want to borrow the computer?
Any laptop will do.
It's fine.
Bring the jury in to make sure we got the right things. Okay.
The exhibit list.
See, if I was in Kenosha instead of Milwaukee, I could be down in that media room and have the laptop hooked up to Court TV's feed like everybody else.
That's your copy.
And then I could be like running
Copy that it's okay for the
back and
flip
forth
chart
from the
markers
courtroom
and
to the
tape.
war room.
We're going to show them the thumb drive, and they'll receive the other 2 exhibits, and I signed it.
The only bad thing about doing that is that, you know, I can't be talking to you guys like I do during the thing. The Wi-Fi in there sucks ass, so trying to show you guys videos. So I'd have to be like running from the courtroom all the way downstairs and then getting back on the laptop and like typing what's going on. So not as fun. They were asking for Dr. Borman's notes, so that I think might be a good thing in Mark's favor. And then they were asking for a thumb drive. I'm not quite sure what's on that. And then they were asking for the paramedics report. I don't know what's on the thumb drive, but we're gonna see that ideally because they're bringing them out to play it. So I don't know. What do you guys think? What do you think of Dr. Borman's notes? So he was Julie's doctor. He's the one that talked about how depressed she was and prescribing the Paxil and her condition when she came in, acting crazy. He's never seen her like that. And then the paramedics, you know, that came in, the way they found her, putting the things on her chest, and then whatever's on this video. I saw a tiny glimpse of that TV, but I couldn't tell what was on it.
They wanted to deliberate later tonight, or
Yeah, I think the indication that they gave to the bailiffs is that they want to go home after 5.
Oh, okay.
Okay, so this sounds like 5 o'clock they're going to be done.
So this flash drive has like his CV, his report. Then there's also just a number of photos contained.
We just want photos 1 through 7.
Photos 1 through 7.
That's it.
Well, there's 2 other photos on here that were shown.
If they're just asking for 1 through 7.
Well, they asked for exhibits.
Yes, it's in, yeah.
I mean, they're notes.
Dude, the state is arguing hard about like not letting this jury see stuff. The lady DA's over there in the corner
Well, the thing
arguing
is, Your
with
Honor,
Jeremy.
they're
Yeah, this
asking for
fucking
exhibit
idiot
10,
goes
and
again.
The exhibit list says photos 1 through 7, but the photos that were actually shown to the jury were the photos that were just depicted up there, but also the juxtaposed photo. This photo right here was shown to them. That's not 1 through 7, but that is a photo that was shown to them. And
We're going to show what was shown to them.
okay.
That's what the exhibit should be.
Oof, guys, I don't know, man. We may have to go live again at 8:30 tomorrow morning and just sit and do a jury watch. What's up, dog mama?
Right, we're going to show them the exhibits that they saw, so there might be one extra one, is what Mr. Jamboy said. There's whatever photos they saw. Okay? All right. Let's bring the jury out.
Mark looks nervous too, though. Jamboy's sweating, but Mark, this is the first time during this trial I feel like he's nervous. Look at his face. He looks definitely nervous to me. And plus, guys, he's been here before. You know what I mean? So he's been through the jury stuff. So that might be an indication why he looks that way.
Please be seated. All right, the record should reflect we're back on the record on Mark D. Jensen, 2002 CF 314. The appearances are the same. The jury is in the courtroom. I did get your question or note, ladies and gentlemen. First of all, we will give you the flip chart, the markers, and the tape. We'll also give you the 3 exhibits that you asked for. The only problem, one of the exhibits has to be shown to you. It's on a thumb drive, and that is exhibit number 10 that you asked for, and that is Dr. Chambliss photos 1 through 7. So we will show you those photos. The other 2 exhibits are what I consider physical exhibits. We'll give you those in the back, okay? All right, so let's look at the first exhibit 10 so you can look at it, the photos. To reflect the jury then have a chance, they did have a chance to look at the photos of Dr. Chambliss, photos 1 through 7. We're giving them the flip chart, the markers, and the tape. Also exhibits 24 and 99 for the record. The other thing, I'm looking at my computer and it says, you know, it gets dark at 5:03 today. Isn't that terrible? So I'm going to let you go at 5, okay? I don't want you here after it gets dark. But you have to come back 8:30. Don't talk about the case when you get home. You can come back and then you can start your deliberations, okay? So here's the exhibits, and then for the record, they're going to be released at 5. Anything else we need to address from the state?
Nothing from the state.
Anything else from the defense? Okay, thank you. Thank you, folks.
Okay, so I guess we'll wait till 5. I'll end the stream. At 5. So, asked for Dr. Michael Chambliss's autopsy photos. Dr. Borman.
Everybody come back at 8:30, and I'll bring the jury in, and so we're on the record, and we'll send them back. Yeah, be here.
Dr. Borman's notes. What else did I say they asked for? So they're definitely looking at those bruises on her body, because there was a lot of back and forth testimony about the bruising on her body. Everybody's answer was different. Nobody could tell what the fuck anything was. Every doctor's answer was different. Oh yeah, the paramedic statement. That one kind of worries me. That one makes me nervous. There's somebody in there definitely saying he's guilty. I think why that one is being asked for. For all you randoms that are back there lurking, if you've been watching this trial on a different stream, you have no idea what we're talking about, and you guys are lost. Can you imagine if they come back with a verdict in the next 20? Fuck, bro. That'd be so quick. Although, you know, realistically, though, they would have done that with Brooks if they didn't have all that goddamn paperwork that they had to do. They would have had Brooks wrapped up that night. But they had so many papers to go through. 68 charges, and then 2 different sets of the documents had to be done. Fuck. I guess we're going to have to be back here 8:30 tomorrow. So we'll go live again at 8:15 like usual. I'll try to get some of this video edited and up. We might have a little hope for justice. I don't know. We just know too much on this channel, though. You know, we've been breaking the case down. We've been examining the evidence. We've been clipping out the testimonies so you guys can watch them again, clipping out certain parts. We've been seeing the lawyer arguments, the scandals, playing a lot of 2008 testimony. I mean, we probably have almost 40 hours of testimony from 2008 that we've played on this channel. The story of my life. I always know too much. Yeah. Yep. If you've not hit the thumbs up yet on YouTube, make sure you guys do that. Facebook chat lost their stream 27 minutes ago. If you haven't been on our platform, please don't vote in the poll because you have no idea what the fuck you're talking about. We'll be back 8:15 tomorrow morning. What's up? It's been forever. I don't know who you are. DizBiz49. I don't know who you are. Are you going to tell me who you are, or? Makes it sound creepy. I know you. You don't know me. You going to tell me who you are? How we know each other? Just randomly come in here. If you obviously you think you know me, so you know we don't play little kid games here. So maybe say, yeah, this is how we know each other. I came into one of your lives. I didn't mean to be suspicious. I mean, did you talk during a previous live? We just get a lot of goofy stuff on here, with people, and that it was a pretty kind of suspicious comment. Kind of puts all of us on, red alert. Okay. I don't remember your name ever, but welcome. You remember what live you came in on? What we were talking about? What the subject matter was? JD, the jury asked for some exhibits, and Bobby Boy and his loser cohort were trying to block the judge from showing the exhibits to the jury. And Jeremy for president argued a pretty good argument, and the judge kind of got a little snippy with Bobby. And then they brought the jury to come back and watch some photos up on the screen. So they're releasing the jury at 5. So I'm going to dip out at 5 then. I was going to dip out literally right when they were coming back, and I heard voices. I sat in one of your lives and chatted with you once because I found you through Snack Squad. Okay. Cool. If you know that name, you're fine. You're good people. Okay. Cool. Yeah, it was just kind of the way you came in. We get a lot of bullshit on the channel with chat sometimes, so it was kind of weird how you said that. It sounded a little stalkery. But if you know that name, then we're good. Don't worry about the chat, Dizbiz. Like I said, you put everybody on like high alert, so the chat's gonna pounce a little bit, but you're good. You're good. You dropped a name that I recognize, so we're good. They're good, chat. They're good. That's an old time name too. That's some OG shit right there. Is it a Daryl Brooks reference? No, it's a Mercado Media reference. It's Merck's gaming channel. Most people wouldn't know that unless they follow Merck on his gaming channel. So that's some OG shit. Oh, it's a Daryl Brooks. I'm fucking tired, dude. I'm reading your comment wrong. Yeah, well, you always make Brooks references. Bro, could you imagine Brooks and Bob? That would have been epic. Bobby would have lost his mind. He would have lost his mind. And the way he snaps at the other side attorneys, he would have snapped on Brooksy boy. Oof, that would have been funny. Actually, I haven't watched any of his lives in a long time. I hope he's doing well. Yeah, Merck's good. He's been covering all the Ukraine stuff. He goes live every night at 7. He's been covering the Ukraine stuff since it started. He's like 1 out of 3 social media platforms that have like the best content. There's him here in the States, and then I want to say there's 2 other people, but they're from like foreign countries. I think one is from like the UK, and he's supposed to have a really good channel too. I don't remember his name. Merck just did he just did a live stream like interview with the guy. I don't remember that platform name though. I haven't watched that guy myself, but Merck said he was pretty good. They know each other, I guess, from doing the Ukraine stuff. And then there's somebody else they were talking about. But yeah, Merck's been doing that. Yeah, if you go on Merck's platform, he I don't remember. I want to say it was like a month ago he did the interview with the UK guy. Because that guy's been covering the war from out there. But there's only like 3 platforms that are covering that situation that basically have been verified, like the most accurate and the most truthful and showing actual coverage. Merck's got people like in the shit that are like going live with him and like sending him footage and shit from out there, and he's been like able to verify it all. And then, like I said, he's got people that are, I guess, going live with him from like fucking bullets whizzing past their heads. So he's been playing their shit and like doing like interviews with them on the ground. He's been covering the shit out of it. But every night he goes 7 o'clock. He goes live on the Mercado Media platform. I've popped in a few times to watch a little bit, but I can't. It's not really my jam. I just spent fucking 2 years fighting Nazis. I don't really feel like watching more of them. So. Look at all the randoms just popping in the fucking stream. All these people voting that Mark's guilty. They haven't even fucking been here. If you guys are like just randomly looking for a stream and you've not been on my platform, stay off my fucking poll. You guys have no idea what you're fucking voting for. Look at the numbers going up though. That's funny. That's funny and convenient at the same time. Just fucking end it because a bunch of fucking idiots. Yeah, we've been live with this whole trial since it started. So they just the jury just got the case today. Be on for another 5 minutes and then I'm going to end the stream. We'll go live again tomorrow at 8:15. And yeah, I mean, we can do whatever. We can play videos again. You know, you guys can come on and we'll talk about Jensen and whatever. There's we got tons and tons of videos that we can play. Just some of them, like the California hiking trips. I can't play any of that with sound because it's got music. My Ice Age Trail hiking trip, I can't play with sound because it's got music. So there's a lot of like, I don't really want to sit and like play Kenosha shit all day. I mean, there's hundreds of videos. We could literally take up an entire live stream playing Kenosha riot shit, but I don't really want to watch all that. And we can, if you guys want to. We can do whatever you guys want. Because it's literally just going to be sitting here staring at each other, basically, tomorrow. So we may see some action first thing in the morning. Hello, everybody. Welcome, jury. Okay, go back in the room. And then it's just going to be sitting here staring at each other. So I'll try to think of some stuff tonight, that maybe we can do when I get off here. I'm going to edit some of this video from this stream. I'm going to start with clipping out the closing arguments. We'll start getting those up first, and then whatever the fuck else happened today. I don't even remember at this point. And then depending on what I pick up for this open records request, We may have some videos for that to play for you guys. I don't know. With any luck, maybe I can get the article written. Question: if you play royalty-free music while playing the videos, would it pick up the copyright? No, like I have. So when I edited like my hiking videos, like when I was in California, right? So I was on Ocean Avenue. So I played Yellow Card Ocean Avenue. I put that in the background. When I went to Santa Monica, I played Savage Garden, the Santa Monica song. So I already knew I was going to get like, it's not like a copyright strike, but it's copyrighted so that I can't make money off of it, right? And then stuff goes to the, and I didn't really give a shit, you know, but during like these times when there's like all this downtime in the trial, we've been playing like a bunch of recap trial stuff, but then that kind of gets old and boring. So I've been trying to show some other stuff. So some of it I can, on the back end of my channel, I can mute the songs, and then it's like a whole editing process. Is a long story, but it's a nightmare, but I can't do it with every song. So and I did it in one of my Portland videos. I put a song in there and it fucked it all up. So what, like one of my videos I couldn't monetize. So I went in the back end and dropped the songs out of that. But it just sucks because there's parts of those videos now that don't have fucking sound. But in a bunch of other videos I've done, I'm using music that I'm allowed to use. So there's websites that you can go and you can actually buy songs, and then you basically split the monetization of the video between you and the artist when you use the song. But now you bought a license to use the song basically, and it's like forever. But I can't afford to be buying no fucking songs. Stupid ass shit. So we use a lot of songs that YouTube allows us to use for free. I just don't always put royalty free shit in some of my hiking videos because sometimes a real song fits the mood of the video. So a bunch of videos that we don't have monetized. Not that we fucking make real money off that anyway, but we're going to do a stream on that for those that are watching. So I was watching a bunch of hiking videos yesterday while I was trying to edit. And apparently that's like the go-to thing right now is everybody talking about how much fucking YouTube money they make. That's like the trend with content creators right now. So we'll probably do one because everybody asks, and fucking, I'm going to show you a guy that I watch that makes fucking over like $100,000 a year. We'll break down like what the back end means and, you know, how much money you make per 1,000 views on a video. And then basically how you make money and then the limitations of the money. Because if your videos are controversial like mine, sometimes they're fucking just automatically demonetized. Sometimes you don't get shit. You know, basically it's like, you know, 1,000 views, you get 50 cents. That's pretty much what it is. You get 50 cents off 1,000 views. And then that depends on the content. So if your content is not what, you know, family friendly, then that starts dropping and you may make a penny off 1,000 views. So a lot of you guys think that YouTubers just fucking crush, and they don't. And the amount of work that goes into it, like, you know, like for me, I watch a bunch of hiking channels, right? Because I'm into hiking. That's why I go hike and I film and I whatever. But those people, when they're out hiking, they're not enjoying their fucking hike because they're out there fucking filming, and then they have dozens and dozens of hours of editing to put out videos. And it's just, it's a fucking, it becomes a job, and it's fucking horrible. You have no life. There's no going out. You have to do content constantly and upload and edit, and it's fucked. And then if you miss, say you want to take a trip and you miss 2 weeks of uploading, you just fuck the whole algorithm up. And then you got to catch back up to that. How much did you get in the TPR candy? Nothing, Ruben. Not a fucking thing. That video, we have 103,000 views. I didn't get a fucking thing. You know why? Because the channel wasn't fucking monetized back then. 103,000 views. So like, I'll show you, basically, I'll show you several YouTubers that basically on 100,000 views, depending on the video. So again, it depends on the video, right? Maybe I'm doing a makeup tutorial, right? How to put fucking eyeliner on. If I got 103,000 views, I may have gotten $5,000 or $7,500 off that, right? Generally, it's like $2,000. But because of what that video was, I may have only made 700. But that's the thing too, is it fucking varies. You could have a video that you made $7,500 on, and then you do another video that's similar content but different, and then you made $562 on it. So it's fucking weird. Or, you know, wait till you see my channel. My channel's fucked. my channel's fucked. I've been looking at it for the last 2 weeks because you guys have been coming on talking about this shit and asking questions. So I've been digging all into, and that's stuff I look at anyway, but I've been like really diving in because I've been trying to take notes so I can kind of talk to you guys, know like what pages I'm going to click on to show you the different things. And I'm going to play some other videos, like clips of other videos, because we can't play the full fucking clips or we're going to get whacked on copyright. And then even, you know, what I'm trying to show you, I'm not going to fucking make any money on. But I'm going to show you some other stuff. We'll make it kind of interesting, so it's not a fucking accounting fucking stream, because that'll be boring as fuck. So, but I'm also trying to figure out, do I want to make it a live stream? Do I want to just make like a 15-minute little video? Hey, blah, blah, blah. Here's the shit. And then put the video out. I don't know. I'm trying to figure out that too. That's a lot. And if I did that, that's a lot of fucking editing in the background to make it a fun, informative fucking 15-minute video. So I got to figure out what I'm doing, but I need this fucking trial to end. Plus I have my own docu-series that I'm working on, and I have 6 more fucking videos of that need to get edited and up. And I got a documentary on Minnesota protest that I need to work on. That's actually going to be fun and interesting, but everything kind of went on hold. So the Minnesota thing, I got to go and do interviews and all the fucking hundreds of hours of footage I have from Minnesota. So we're basically interviewing another independent, and they're allowing us to have all of their footage, and we're going to do an interview. It's basically a documentary about what we have to go through as independents. So we're going to film them, you know, we're going to do an interview. We're going to cut to some Minnesota stuff, some interview stuff, but you're going to see me though in the documentary too, where it's like me editing and kind of talking to the camera about, you know, because I'm an independent too. So it's like me as the independent doing a documentary on another independent. So you kind of get some behind the scenes about what the fuck I have to do to be able to put this thing together. So it's kind of interesting. My whole little concept of how we have it worked out. It's just going to take a while because it's a lot of video editing. I got hundreds of hours of fucking video to go through. And then there's going to be dozens of hours of interview shit that we have to do and then edit that. And it's just going to be a fucking nightmare. So because I'm trying to get into more documentary style stuff instead of live streaming. So, but yeah, I made dick ass nothing. I made nothing. The channel wasn't monetized when the Candy Cane Lane thing happened. So that may have solved a lot of fucking problems at that time if the channel was monetized. So, but anyway, all right. It's 5:07. Can you pronounce independent like the defendant? Independent. The defendant. Defendant. All right, I'm out. I got to go somewhere. We'll see you guys first thing tomorrow morning.